mentioning on the 10th, Your Lordship, and directed the matter to appear on 19th, which is today, Your Lordship, as under the heading urgent motion, Your Lordship. However, the matter is not appearing today, Your Lordship. There's some urgency if the matter can be kept tomorrow, Your Lordship, under the heading urgent motion.
May I permit to mention for extension for interim order, my lord. That is extension for interim order, my lord. That
When
is
interim order going to expire? When?
28th of November, my lord.
Huh?
28th November.
28 November. Yes.
Yes, my lord.
Today we are on 8 days is there. Come on 25, 26. Mention on 26. 28, na?
28, my lord.
Mention on 26 or 27 if the matter is not listed. Correct. Yes, call the list. किसमें आ गया? किसमें आया? किसमें आया? तो तपन दास है। वो तो पोर्ट ब्लेयर वाले मनोज पाल है। दिस इज तपन दास। दिस इज अनदर मैटर। वेयर इज दिस फाइल? Okay. It will go to renumbered and it will be listed in the circuit bench. Yes, call.
My lord, I beg to the petitioner, my lord. There is two applications, my lord. One for modification of the order dated 4th March 2021 and another for recalling the order dated 20.
Who has
Same order.
both filed by the petitioner?
One filed by myself, my lord, respondent number, can number 1, and private respondent filed by the recalling order. What happened, my lord?
Recalling of J can 3.
Can 3, my lord, and 2 is disposed of, my lord.
Which is the, where is the order?
Second, my 4th March, my lord, the order in my can 1, my lord.
What is your can 1?
Can 1 for modification of the order, my lord.
Can 1 is for modification.
Modification.
And can 2, can 3?
For can 3 for recalling the said order, my lord.
Recalling the said.
What happened, my lord?
Who is for the other side?
My lord?
Who is appearing?
Sanjeev Mukherjee is appearing, my lord.
Huh?
Sanjeev Mukherjee, one under advocate, and Mr. Somnath Bose is appearing for the CSC, my lord.
Your can number 2.
Can 3, my lord.
Can 3.
Can 3. That's filed by the respondent.
Your can number.
My can number is 1.
That's why I'm asking. You are moving your can 1.
Can 1.
Yes. Where is the order?
Order in the page 19, my lord.
Page 19.
Page 19, my lord.
9.
Can 1, my lord. Page.
Can 1.
Can 1, my lord.
Page?
Page 6, 7 onward, my lord. In can 1. Page 7. Page 7.
Order dated 4th March.
4th March.
Yes.
What happened, my lord? In this matter, the address of the respondent was wrong, my lord. Private respondent, my lord. And immediate after getting the knowledge, my lord, I have made intimation to the CSC as well as the police authority not to execute the order, my lord. Kindly come to the page 11, my lord.
Page 11.
Page 11. In this case, I intimated that the address mentioned in the cause title of the petition was, there is a typographical mistake.
Last paragraph.
Last paragraph, my lord.
To whom you intimated?
On
Detail manager.
the general manager, CSC, my lord, and district engineer and officer in charge, and I will took up, and I will also intimated that I will took up an application for appropriate application.
Last paragraph. And the order was passed, 4th March order was passed.
My lord, my lord.
And you inform on 19th March.
On the
On 19th March you informed.
my lord.
Last paragraph.
And
Last paragraph, my lord. I have stated, my lord, I have been instructed that to file an application for modification and mention the proper address, the respondent number 3 and 4, my lord. And therefore, I request you not to execute the order dated 4th March 2021 and until the order dated 4th March 2021 is modified by the Honorable Court, my lord. And thereafter, my lord, I took up this application. My lord, kindly come to my prayer, my lord.
So where you mention the address?
Address I have mentioned.
Paragraph 2 there.
Paragraph number
No, 2 na, 2
2,
na.
my lord.
Na, 2 na, 2 na, 2 na.
1. The senior citizen,
Hey, ji, paragraph 7.
my lord, paragraph number 7 is here.
7.
That the respondent number 3 and his younger brother duly appeared in the said and filing the
7.
yes.
Residing at Banamalli.
Konomalli Roscoe Road, my lord. That is their address, my lord.
These are the both 3 and 4.
3 and 4, my lord. And thereafter, my lord, they took up an application, the can number 2, for drawn up a proceeding under section 340, my lord. And Honorable, the coordinate bench passed the order, my lord, on 23rd June 2025, my lord, that there is a typographical mistake and they have the coordinate bench given the liberty to the petitioner to took up an application for
Recalling of the order.
recalling the order, my lord.
Where is that order?
That order, my lord, 23rd June, my lord,
Copy order.
2025, my lord. May I give the order, my lord?
So can 2 was disposed of.
Can 2 was disposed of, my lord, and the court hold that
So
there
what
is
is
a
the can
typographical
3?
mistake.
What is the can 3?
Can 3 has been filed by the opposite, the respondent number 2 and 3 and 4, to, as per leave granted by the Honorable Court, my lord, for recalling the order, my lord. But I am praying before your lordship to.
Who is appearing for the? Who is appearing? You.
No, I am appealing from CS Limited.
Who is appearing for 3 and 4?
Sanjeev Mukherjee, my lord.
So today it's not appearing.
My lord.
Yesterday also,
time.
accommodation was paid for lordship, made it not today, yesterday. Today I don't find them. Well, basically, lordship may
You are
find
appearing for whom?
for CSC.
My lord,
They are saying can 3 and can 1 are the same. If your lordship is pleased to look into
Recalling the order.
paragraph page 5 of can 1 and the page
since the my lord respondent appear, my lord, kindly pass a fresh
Page
order, my lord.
page 8 of can 3. I find similar, my lord. Prayers are similar. Both of them are asking for the same relief.
The writ petitioner has filed an application being can number 1 of 2020, 2024, 2021,
My lord.
2021. Praying for
2021, my lord, can.
praying for modification of the order dated 4th March 2021. 4th March 2021 on the ground that after the order passed by this court dated 4th March 2021, by directing the respondent number 5, by directing the CSC for providing electric connection
কালো সমস্যা হচ্ছিল
the premises of the petitioner, and also directed the respondent number 5 to provide all necessary police assistance to the respondent corporation for installation of fresh electric connection. For installing a fresh electric connection at the premises of the petitioner. After the order, the petitioner came to know the address of the respondent number 3 and 4.
My lord, in this matter, I am appearing for the private respondent, my lord.
Has wrongly mentioned. Has wrongly
আপনার পাসওয়ার্ড নিতে বললেন জুনিয়র, আপনারা কেউ একটু দাঁড়ালেন না? আরে আমি তো কি বলেছি তো এটা
আমাকে বললে
এনাদের কাউকে বলিস নি।
না তো তো বললাম ওনাদের
residing at village Tamali, post office and police station, Vishnupur, district 24 Pargana, South, pin 74355503. Instead of residing at 2, Banam Naskar Road, post office and police station, Parnasri, Kolkata 70060. Immediately when the petitioner came to know the address of the private respondent number 3 and 4 wrongly mentioned in the first title of the of the petition, immediately by a communication dated 19 March 2021, the petitioner has informed the CSC authorities that he will take appropriate steps before this court for correction of the address of the respondent number 3 and 4 and requested not to execute the order dated 4th March 2021
ব্রিফ লাগবে কাগজ লাগবে
until the order dated
brief
4th March
আছে ওর।
2021 is modified.
দুটোতে দেখলাম একই কেন অনেও যাচ্ছে
বলে
In
দিই
the meantime,
আমি বললাম দেখো আমার তো মন সিমিলার
respondent number 3 and 4 have filed an application being 10/2 of 2023 praying for initiation of proceeding against the petitioner under Section 340 of the Code of Criminal Procedure on the ground that the petitioner has obtained an order from this court on 4th of March 2025 by disclosing false address of the respondent of the office by police. The respondent number 3 and 4 have also filed an application being CAN 3 of 2025 praying for recalling of the order dated 4th March 2020. 4th March 2020. On the ground that the petitioner has obtained the order dated 4th March 2021 by suppressing the material fact and giving a false incorrect address of the respondent number 3 and 4 in the cost title of the petitioner. Yes, who is appearing? What is your contention?
Lord, absolutely wrong address, no notice was served, and my lord, they have filed an affidavit of service while by obtaining the order that
Now, what is
now
your stand?
he took out an application under section 340. The learned Honorable Justice Kaushik Chandra dropped that proceeding, but granted us leave for praying for recalling of the order. We have prayed for recalling. Fact remains, my lord, prior to us, they have filed an application for recalling. So, my lord, let both the matters recalling applications be allowed.
Yes.
And my lord, until and unless they amend the writ petition,
For what?
because
Post title.
address is cost title is wrong. So they have to at first undergo that,
Okay.
and they
That's
have taken.
okay. Good. Record.
My lord, may I have your lordship's leave, my lord, to, because one of my matter is going to be dismissed by the honorable chief justice. I'm grateful.
The application filed by the respondent number 3 and 4 being CAN number 1 of 20, CAN number 2 of 2023 for initiation of the proceeding under section 340 of the CRPC was taken up by this court on 23rd of June 2025, and this court told that the petitioner made a bona fide mistake
অনেক বড়
during the first title of WPA
I mean,
004 of 2021 by publishing an incorrect address of the applicant of the respondent number 3 and
after amendment we appear
accordingly this court
next week sometime.
is not inclined to proceed further against the petitioner under section 340 of the CRPC and the can was disclosed. Now the petitioner has filed an application being CAN 1 of 2020, and now the writ petitioner praying for modification of the order.
Both
Of the order dated 3rd March 2020,
চলছিল
and the
বোর্ডটা
respondent number 3 and 4
ঢুকলাম
paid for
তো দুই থেকে দৌড়তে সব ঠিক আছে।
Recalling of the order at 4th March 20. Consider the submission made by the council for the respective parties. Admittedly, initially when the writ petition was taken
গতকাল
up
তো
for
এর
hearing,
সঙ্গে বাইরে ছিলাম,
the
পেছনে জ্যাক
address
থেকে
of the
দুবার বুঝে
number 3 and 4 was incorrect. Subsequently, when the petitioner has realized that he has obtained the order by disclosing the incorrect address of the respondent number 3 and 4, immediately the petitioner has informed the authority not to execute the order dated 4th March 2021, and he also informed the authority that he will take appropriate steps for modification of the order dated 4th March 2021, and accordingly the present petition being can 1 of 2021 is filed. The respondent number 3 and 4 filed the application and being can number 3 of 2023-2025, praying for recalling of the order as per the leave granted by this court by an order dated 23rd June 2025. This court find that the petitioner intend to correct the address of the respondent number 3 and 4 as mentioned in paragraph 7 of the can numbers 1 of 2021. Accordingly, the order 21 full stop. If this court find that the address of the respondent number 3 and 4 is required to be corrected. And once the petition is given liberty to correct the address of the private respondent number 3 and 4, the writ is to be amended, and the amended writ is to be supplied to the respondent number 3 and 4 at the new address. Accordingly, considering the above, this court finds that after service of notice upon the respondent number 3 and 4, the matter is to be taken up for hearing after to decide whether the petitioner is entitled to get electric connection or not. Accordingly, order dated 3rd of April, 4th March 2021 is recalled. Petitioner is full stop. The petitioner is given liberty to delete the previous address of the respondent number 3 and 4 in the cost title of the plate, and to add the new address of the respondent number 3 and 4 within a period of 1 week from the date of this order, and after the amendment, after the correction of the address of the respondent number 3 and 4, the petitioner shall supply the copy of the writ application to the respondent number 3 and 4 at the new address within a week thereafter, and to file affidavit of service on the returnable date. According in view of the above, can 1 of 2021 and can 3 of 2025 are disposed of. Let the petition be appeared before this court on 10th of December 2025 under the heading new motion. I have recall the order, given liberty to correct the address, serve the notice to the private respondent, file affidavit of service.
Since the private respondent
May be
appeared, my lord,
appearing, but you serve the copy tomorrow, again he will say, I have no power. Serve the, then
then
you
my lord, I accept.
মানে
May I
copy may be served to CSC also with the amended cost title.
Yes, I will serve. May I permit to hear and now, my lord, the post title? May be correct?
Yes, correct.
Yeah.
I have given 1 week, whatever you do. If today you want, you correct it.
Any direction for appearing after the
10th December
10th
as
December?
new motion.
As your lordship, please, my lord. Deeply obliged, my lord.
Next. Yes.
Before going into the merits, I'll tell your lordship, in this writ petition, I find there is already a subsisting interim order. Thereafter, Milord, I find there is a can where, Milord, the court asked for a report, and there is a can 2 which has been filed where we have filed an exception to that report. Now, my lord, the thing is, I find there are no directions for exchange of affidavits. Now, this interim order has not even been challenged by any of the parties to the proceedings. So, my lord, at this stage, my lord, subject to, of course, what your lordship feels, my lord, if the pleadings could be complete, then the hearing can commence.
What you have prayed for? What is so clear?
My lord, matter is like this, my lord. We had supplied, my lord, certain medical equipments to the state of West Bengal. There were certain machines for measuring hemoglobin and the strips which are inserted. Now, my lord, what had happened is this, my lord, we had supplied the 80% of the quantity and I'm entitled to payment. Now, from the date of supply, my lord, they have been using and they have used 3/4 of the supply that I have made. There was no complaint during this 1 year period, 1.5 years period. When I first asked for payment, then they say that your goods that you had supplied a year back was defective. Now, two things, my lord. They don't reject the goods, they don't offer to return the goods. So, my lord, under the Sale of Goods Act and under the contract also, the title has passed. So, we took it, my lord, it is as if one of alibi, my lord, for not making payment or disputing it. So, my lord, we came, there was a performance bank guarantee. This performance bank guarantee, my lord, we got a threat that this guarantee would be encashed. So, my lord, we filed a writ and can 1 is, my lord, an order seeking not to encash the bank guarantee till such dispute is sorted out. Court was pleased to protect us that the matter is sub judice, and the court also asked for a report. Now, my lord, the report that has come, my lord, they have shown the report as of 3 government hospitals in West Bengal. We have gone to the national laboratory, considered those 2 reports side by side and showed that this report is palpably absurd. And that is where is, my lord, my exception to the
They
report.
filed the report by way of can.
No, they filed it just like this, my lord.
Have you received? Acha, these are the reports.
I believe, my lord. And there is an
What is the
exception.
can too?
Can 2 is an exception to this report, where we have showed that this is palpably absurd.
So who
Lord,
is
will, Lord, will kindly keeps it for hearing on any date, my lord, because the learned AGP is leading me in this matter, my lord. We have also filed our reports. It's my lord, a money claim. Essentially, we are contending that there is an arbitration clause, and the fact that there are clauses under the contract under which the state can reject the defective goods. My lord, we have relied upon everything on the report. The report is exhaustive. It contains everything. So I was humbly praying, my lord, will kindly fix this for hearing for any date.
So your report may be taken as affidavit in opposition.
My lord, I will file an affidavit
What I
to
was
this
saying.
particular exception which has been taken. My
That's so you have
Yes.
taken the exception. You are telling that the matter is to be fixed for hearing. So at the time hearing, then you cannot say the you will.
Yes.
I'll file a affidavit, my lord, to the
If you
exception.
want
which
to
is-
file affidavit other than the report, then the court will grant time. If you say that now this will complete the affidavit in opposition, then I will record. They will not use the affidavit. Then I will fix the matter.
we wish to file an affidavit, my lord, on our instructions.
The respondents have filed a report in 2 volumes after serving the prosecution for the petitioner. Petitioners have filed exception by way of can 2 of 2025. Police stop. Counsel for the respondent submits that though they filed the exception, but they intend to file affidavit in opposition. Let affidavit in opposition within 2 weeks.
But within 2 weeks.
Be filed within 2 weeks, reply if any there to be filed within. Mr. Dutt,
1 week. 1 week thereafter.
within a week thereafter.
Lord, may I pray for 3 weeks instead of 2 weeks?
3
It'll
weeks?
take some time.
3 weeks, 2 weeks.
May I say this, my lord? He will file an objection to can 2. Might as well, my lord, since he is taking 3 weeks, might as well file an objection to the writ petition also and can 1, so that the pleadings can be complete.
Correct.
So he is only praying for can 2. He is not praying for.
Can 2 or writ petition.
He want to file
Want to
objection
file
in all.
affidavit in opposition, can 2 or
My lord,
writ petition.
to the entire writ petition as well as the exception which is now brought on record.
Position with regard to writ petition as well as can 2. That is the exception filed by the petitioner to the report. Within 3 weeks.
Within
Right,
3 weeks.
within 2 weeks.
Then 2 weeks, my lord,
Within 2
because
weeks, police stop. Let the matter appear. So I am fixing a specific date so that you should not say that. 5 weeks, na? Then it will go to January.
Probably we'll be knocking the vacation goals, my lord.
January, it will come January.
So January, my lord.
So let it come month. Acha, interim order is also there. Let the matter appear on 6th of January 2025. Interim order is extended till 9th of January 2026 or until further order which
Let the affidavit of service of Can 2 will be kept with record.
affidavit of service is respectively kind 2 of 25 to 30.
Obligation.
Grateful. Next.
My application. This was the matter your lordship would recall where my drawings were being used by the railways.
What?
My drawings, which were my proprietary articles, they were being used by the railways. Railways has been given time from August. They've not come with instructions as to how they are doing it. Your lordship had given them a chance on 6th of November to come with a affidavit to show how they are using my drawings in other tenders where my product is excluded.
No, not August. Matter was first taken on September, late September.
June, July, August,
But,
September.
Malad, it is being ready, Malad, it's being affirmed today only. Malad, I take the apology for could not complete.
What? Report.
Malad, the affidavit. Malad.
Affidavit?
Malad, affidavit of opposition.
Affidavit in opposition.
Yes, Malad.
Then he will file the reply. Then he will file the
Malad kept the material point open, Malad. Malad, we should.
That is already you kept open.
That's kept open.
Any day, Malad, it is being affirmed today. The person concerned, is here, Malad, he will comment today, Malad.
So today you will affirm. Reply.
1 week. The interim order that is there by your lordship's order of 6th of November.
What are not confirmed, Malad, as Malad directed. That is
The
any day, Malad,
counsel for the
That's an
respondent submitted. The affidavit is ready and in court
Bolo
it will be affirmed and supplied to and will file before this court. And after supplying the copy to Learned Counsel for the petitioner. Petitioner prays for time to file reply. Let affidavit reply be filed within a week. List the matter. Not only
No, no, it's not from the.
on 9th of December 2025. Yes, tell me when. 10th? 10th of
Oh,
December.
my lord, sorry, this way, my lord. 11th.
11th. 11th of December 2020. 11th of December 2020.
Only one request.
The respondents submit that they are not going to issue work order till the next date of hearing. Let the matter appear under the same heading.
That one request, my lord, it will retain its position. In the,
Same heading.
very grateful, very grateful.
Item number 3.
Worship, in this matter, I am appearing on behalf of the West Bengal Power Development Corporation.
I am for the
No
petitioner.
notice has been served upon it. No notice has been served upon
Yes,
it.
served by mail.
Served by mail. And received the
This was
physical
filed in July. He has received his copy.
copy. Yes,
if he-
this is the copy.
If he wants 24 hours to take instructions, I will not stand in the way, but let him not make these bizarre submissions first thing in the morning.
Not a business
Notice served
submission,
on
Your
him.
Lordship.
How did he appear
He's
otherwise?
an old person, Your Lordship.
How did
I
he
have to
appear otherwise?
See the physical
Oh,
copy. Your
very well.
Lordship.
He's not computer savvy. Very
Yes,
well.
yes, very much.
My lord, there's only one short point involved. My lord, I'll tell you, lordship, what the point is. My learned friend can thereafter respond, if necessarily, with your lordship's leave later. There was a tender, my lord, floated in respect of supply of sulfuric acid. I was a participant in the tender. One of the criteria of the tender was that you must either have the wherewithal to manufacture it yourself. Otherwise, there must be an authorized vendor. An authorized vendor. You can't take it from the market. You can't act as a middleman. Take it from the market and sell it to the authority.
Any clause that he has to produce the certificate from the authorized who will.
Yes, there's a clause, and this clause governs the entire term of the contract.
Correct. With the guarantee.
Yes. Now, these documents are on record. My learned friend will also see. We challenged it. We challenged it. I will show what bars are there. First, let me propose for you to dispose. Now, we challenged the fact that we were not being given the L1 tendership. Our challenge was negated because there was such a clause in which he, despite not being a manufacturer, could take it from a vendor. I was the only entity in the fray who had manufacturing capabilities. But still, because of that clause, it was said very well he can become L1 because he can give it to the manufacturing vendor. The Honorable Coordinate Bench of your Lordships, however, made a rider, dismissed my writ, said, however, the authority must ensure that this person whom you've given the L1 always throughout the contract period gets that supply through that one point authorized vendor through whom the supply is being made. I carry an appeal before the Honorable Appellate Bench. Appeal is dismissed. Therefore, the order of the Honorable Single Judge remains. Subsequently, I write to them saying, please let us know, because we've come to know that the supply is actually not coming from that person at all. It's now being procured from everywhere else. We have certain way bills which we have put on record, which will clearly show that now the supply is being made through other persons. That authorized vendor is a bogey. What is my right? My lord will say, what is your right, Mr. Banerjee? You are not a qualifying tenderer. You lost out in that process. My right is, if by showing a bogey to court, my right to compete has been eliminated, then that person should not get the benefit of that elimination. It should be left open again to for the public participation. Everyone comes in. I'm not saying give it to me. Everyone comes in and you participate.
Does that cause of action continue?
That initial cause of action of my not getting it doesn't continue. Why doesn't it continue? Because
That is over.
why doesn't it continue? Because given the terms of the tender, the award to the L1 was proper. But if it is found that a fundamental term subsequently is being violated, which caused my elimination despite being the only person who was eligible, because I was myself a manufacturer, then that gives me a cause of action. My humble prayer today is this: my learned friend appears to be unelectronic mail savvy, therefore he hasn't read the notice.
I'm just telling you, impromptu, your lordship. I'm just telling you.
No, he did not say something impromptu. That is what I'm saying. Instead of saying it impromptu, I'm requesting my learned friend to please. One second, brother. I'm request my learned friend. I have made a specific allegation. That's only the allegation.
Okay, you do one thing, supply the copy.
No,
He's got a copy.
I have a copy.
He wanted to be given a fresh physical notice of the fact that it's appearing. No? Oh, he's waived it. He's waived it.
I did not have the. I am not very computer savvy. Lordship, let me tell you now. I'm just seeing, just browsing through it. E-way bill is not any prima facie proof also. That one person, he depends upon a prima facie proof of e-way bill. In GST matters, your lordship, any person GST record holder can generate it electronically. Suppose I am, both are suppliers and any X and Y supplier. I want to, this is one kind of, let me tell you, it's kind of fraud in GST being conducted. I can generate any kind of way bill. Suppose I can generate a way bill that I am getting goods from Tata to Tata, any company's name. You can take any company's name. These prima facie is no evidence at all.
Okay, so let it file the affidavit. You are filing affidavit.
I have annexed these. Let him say whether I have generated them or not.
Also, you file affidavit.
Let him give it in the form of a report in 2 weeks, my lord.
I was saying affidavit only in 2 weeks, not only report.
Counsel for the respondent. There's got time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply by
3 days.
a week thereafter.
A week thereafter.
A week thereafter.
Let it, my lord, retain its position, my lord.
Let the matter appear. On 17th December.
Obliged.
Deeply obliged, lordship.
My lord, retain its position, my lord.
17th December, adjourn motion. As adjourn motion.
As adjourn. Adjourn motion.
AO 2 weeks, your lordship.
2 weeks, 1 week.
No.
My lord, will it be possible for it to come slightly at the top of the pile of the adjourn motion?
Adjourn at the top.
At the top.
At the top, yes, your lordship. This at the top.
Yes, next.
Number 10.
Lord, I appear for the
Writ petitioner. My lord, yesterday this matter was adjourned on the ground, my lord, as my learned friend has pointed out that the matter has to go before the IPR division.
Yes,
But I have consulted the IPR division rules of the High Court, my lord.
Ah.
My lord, he is indeed correct, my lord. It has to go before the IPR division.
correct.
Yes, yes.
You
It has
want
to
to
go.
withdraw?
No, my lord, let it be renumbered and sent to the IPR division, my lord, because there is an interim order.
Recorded. Counsel for the petitioner submitted. The matter is connected with the intellectual property. Accordingly, he prays for taking appropriate steps for listing the matter before the appropriate court having determination on the intellectual property matter. In view of the above, WPA 23994 of 2025 with CAN 1 of 2025 is released from the list of this court with the liberty to the petitioner to take appropriate steps to place before the appropriate court having determination.
I'm grateful, my lord.
Next.
Item number 11, I am participating.
My lord, I am for the petitioner led by Mr. Shami Mohammed, your lordship.
Yes.
My lord, he is in court number 17, your lordship, and he is engaged in another matter, your lordship. May I pray for not today?
Not today. Not today. As per prayer made by the counsel for the respondents, WBSCDCL, you are appearing for whom? The correspondence. Let the matter appear on Tuesday, on 25th. Next. Under the same heading, next.
I beg to appear, my lord. Well, a new connection for the new domestic connection for the flat. The petitioner purchased on, my lord, 26th March 2025, this year. My lord, after purchasing, he applied on 8th of, my lord, May. Accordingly, inspection was conducted on, my lord, on 10th of May. Thereafter, my lord, no electricity connection has been effected or requisition has been sent for.
There was no connection there?
No, new flat. And my lord, from the web tracking, my lord, it is transpired that an objection has been raised. My lord will find page 15, objection dated 9th of June 2025. In bottom, my lord.
Who has made the complaint?
The promoter, I believe, because my lord, the promoter is saying, I will not allow him, you to get electricity. So I made party to the promoter. He refused to accept the service. Every service is there.
Absent, refused, yes.
Refused to accept this service. My lord, I am ready and willing to pay the requisite fees. My lord, whatever.
When you applied for?
My lord, applied on, my lord, 8th of May. My lord, page 14.
8th of May. Domestic connection?
Domestic connection. My lord, inspection date, my lord, will find.
Inspection carried out?
Yes, my lord, 10th of May.
Then there is an objection.
Objection. My lord, no
I'll
objection.
seek for inspection with police help, my lord. My specific instruction is that we need a inspection for ascertaining feasibility of providing supply. I'll seek for a fortnight's time to inspect and file a report.
File a report? How soon? 10 days?
I'll give me a fortnight.
Which area?
This is Howrah.
This is Howrah. Fortnight.
Salki area. My lord, they can affect electricity.
The petitioner has filed the present application praying for grant of.
My lord, all existing connections are there to the other flat owners.
That's the report.
Yes.
Praying for grant of new domestic electric connection in the residential premises. Counsel for the petitioner submitted. The petition applied for grant of electric connection on 8 May 2025, and subsequently the petition came to know there is an objection from the developer for grant of electric connection in the premises. Accordingly, the petition is filed. The notice was served upon the private.
My lord, as per my instruction, my lord, inspection already conducted on 10th of my lord
Written
May.
under the
No, we are in
with
November.
the endorsement refused.
Refused.
Then council appearing for the DESC prays for time to ascertain whether there is any feasibility to provide electric connection to the petition as prayed for by the petition. In view of the above, the CSC is directed to file report within 10 days after serving the copy to the land council for the petitioner, the petitioner is liberty to file exception to the report, if any, within 2 days.
Wait, 3 days.
Within a week.
3 days, my lord.
Within
Otherwise, it will.
Within 3 days, let the matter appear on.
My lord, I'll seek for police protection since there was an obstruction, my lord.
Let the matter appear on. आज कितना तारीख है 20 है ना 19 पे the matter appear on 9th of December 2025 under the same heading. It is made clear that if there is an objection from any corner for inspection of the premises in question of the petitioner by the CESC authorities, the concerned police authority. You have made a party?
Yes, my lord, respondent number 4.
Yes, we have met police department.
That is the officer in charge. Any police station shall provide necessary assistance to the CSC officials for inspection of the premises.
The cost of the police should be paid by the petitioner.
No, my lord.
At the time of inspection by the CSC authority to ascertain whether there is a feasible to grant electric connection in the premises of the building.
The cost of the police should be paid.
Let the raise.
Otherwise, the police will not go.
My lord, may I submit, my lord? It is the duty of the service provider to.
No, it is not, my lord. There are thousands of
There is restriction, then you have to how the authority.
My lord, it would be
It is made clear that if the CSC required any police assistance, the cost shall be borne by the petitioner.
I'm grateful, my lord.
And my lord, one thing, if they found, my lord, there is where electricity can be affected. In the meantime, they will also be at the
report comes, court will pass a report. Let the report come.
Because, my lord,
if it is there, you mention that before 3 days, I will take the matter.
my
No
lord,
problem.
one thing, my lord, regarding the police cost, my lord, it would come a huge, not less than, my lord, 10-15,000, I believe. So, my lord, the police authority is duty bound to give, my lord, protection to the license.
I will not stand in the way, but if the police doesn't go, my lord, my officials will come back.
Can't the police cost card दीजिए अगर cost अगर नहीं they were asking the cost then you come to
Well, they will not, the entire exercise will be futile.
The police is there, my lord.
You are asking for the electric connection, you have to provide that.
My lord, regarding the.
But it is the order of the court. क्या बोल रहा? To provide the.
My lord, the order of the court, police can go.
Yes.
Police will not go.
Okay.
If there is no cost paid to the police, they will not go, my lord.
Okay, let us see if there is an assistance you applied for. The police telling the cost is to be paid. You inform this court. We'll see to that. It will be delayed on their part. On.
Yes, it unnecessary. It will be delayed.
What can be? Yes.
My lord, in item number 14, Dr. Madhusudhan Shah is appearing on behalf of the WBC DCL.
Who is for the petitioner?
I am for the he can't able to come the court. He can't able to come the court due to some medical.
I am the petitioner.
I am the petitioner.
You are the petitioner. What you have paid for?
Not to
I have paid for new connection.
New
For the
connection.
factory.
Not today. As per okay, not today.
Lord, I am appearing for the state.
Not today.
On Monday.
Tomorrow.
And I'm for the respondent number 7.
May it please your lordship, I beg to appear on behalf of the petitioner. This pertains to a meeting, my lord, which is to take place at Memory, which is a place in Bardhaman, my lord. It's around 82 kilometers away from Calcutta. So, my lord, the meeting will be held on behalf of the Bharatiya Janata Party. The leader of the opposition will also be attending there. So we had, my lord, sought for permission for use of sound and amplifiers, my lord, in tune with, my lord, the relevant prevalent norms. We had approached the SDO. We had routed it through the, my lord, the OC of the local police station. My lord, we'll find it. Application টা? Yes, page 28, my lord. It's in vernacular, but it was addressed to the SDO through the OC memory. Intimation about having a meeting on the grounds of this particular club known as Uday Sangho, the pro forma respondent, on 21/11/25. The time is, my lord, from 2 p.m. to 7 p.m. We intend to use 10 microphones, my lord, 50 chairs, tables, and the expected turnout is around, my lord, 6,000 to 7,000. So,
what is the time?
But time is from, my lord, 2 p.m. to 7 p.m.
Yes.
Yes.
6 to 7,000 people.
6 to 7,000 people. Now, my lord, it's a pretty large ground where regularly, my lord, the biggest Kali Puja of that area is held, my lord. We have also annexed, the club has also given us the necessary permission. And we have also annexed, my lord, the copy of, my lord, the permission.
That is subject to page number 44, Mr. Bhattacharya.
Yes. Page 44.
What is 44?
Page 44, my lord, demonstrates the permission for Kali Puja given to this particular club on this particular ground, even in 2025, for having, my lord, the Kali Puja. So, my lord, we make this application. It was for the SDO, my lord, to decide. But peculiarly, the police, despite not having any jurisdiction, because in terms of Section 30 of the Police Act, the police has powers to regulate meetings and assemblies on public roads and thoroughfares. So it's about public places, not about private areas. But the police still said that no, you are required to supply these information. So they asked for the volunteer list.
Where is that?
Page 29.
Page 20. Yes. Provide the volunteer list along with the
Route sketch map of how VIP will enter the venue ground. Provide route sketch map how the supporter will enter in the venue. Where is the proposed VIP and other dignitaries car park? The proposed supporters big and small vehicle will be parking area. Then NOC from the electricity department, permission NOC from fire department, permission copy from NOC from PWD civil and electrical department. So, my lord, we respond to it. The club's permission, my lord, we have annexed already. Page number gulo bolo. Yes. So we respond to that particular query, intimating the police that look here, under the Police Act, you do not have the jurisdiction to do that, because it was basically for the SDO, which was routed through you. So page 46, my lord, is that particular letter which was addressed to the OC. But in the meantime, by way of abundant caution and as law-abiding citizens, page 50, we have already supplied the list of volunteers to the police.
Page 50.
Page 50. Then, my lord, the sketch map, that also, my lord, we have provided to the police, indicating all the details. Page 43, my lord, will find the sketch map. So we have responded to query number 1 to 5 with our letter. Page 43, my lord.
43 is there with regard to the details.
With regard to the details. So, my lord,
That is with regard to
query 2,
3.
query 3, query 4, and query 5.
Propose supporters of big small vehicles be parked. Okay. Query 5.
There is a local adjacent school. They have permitted us, my lord, to use their grounds also for parking the cars. Now, my lord, when it comes to, my lord, now the fire safety certificate.
And volunteers details is also there.
Yes, volunteers, my lord, we have.
Page 50.
Page 50.
Yes.
Now, my lord, coming to the question of electricity permission, my lord, first of all, my lord, the police is not having, my lord, any authority or jurisdiction, my lord, in view of Section 30. But, my lord, as bona fide citizens, knocking the doors of justice, page 32, we have already taken a temporary collection. Because there, before the meeting, there will be a portrait of Bharat Mata also, my lord, where a small aarti will be performed. So we applied, my lord, for a temporary connection, and the temporary connection has been given already. Page 32.
Yes.
Now, at fire department, we approached, we were handed up this particular form at page 34. My grievance is primarily, my lord, against the SDO and the fire authorities. Because the police is saying that you require a fire permission. We go, we were handed over this particular form. Page 30, electricity page, sorry, page 32.
Page 34 is the form.
34 is the form which they hand up to us, my lord.
Correct.
We fill it up.
Yes.
We say that since the police is insisting to get a permission because permission is not required. In terms of section 23A of the Fire Services Act, my lord, when a pandal is constructed, or my lord, there is a structure having an upper ceiling or side walls, only then, my lord, 23A comes into play. That is, my lord, temporary structures and pandals. Ours is a small stage with iron and cloth, without any walls, side walls, or without any ceiling. So it does not come. But what they do is, they say that, no, you have to apply. They hand up this particular form. We fill it up. We intend to submit it. They say that, no, we cannot take it unless and until you get the police permission. So we inform that police permission is not required. In terms of section 30 of the Police Act, they say that, no, we will not be accepting. So, my lord, Friday is the meeting, and my lord, it's a regular occurrence, my lord, that the party in opposition has to knock the doors of justice for each and every, my lord, meeting, as well as, my lord, rallies, political rallies, my lord. So, my lord, I am aggrieved by this particular action, my lord, attributable to the fire department, as well as, my lord, the SDO. SDO, my lord, is the authority.
What the SDO done? You
But-
applied before the SDO?
No, the first application is made to the SDO through the IC. That is the system, my lord, which is observed, my lord.
No, you have to. When you filed an application, where is your application?
My lord, application is the first annexure,
28.
but it's at page 28. My lord will find it is addressed to the SDO Purva Bardhaman through the OC memory. So, my lord, the SDO is the authority. এটা দাও জোসেফকে এটা দেখাবো কোনখানে আছে এটা হ্যাঁ yes SDO টা কোথায় yes my lord, may kindly take this notification হ্যাঁ দাও but kindly takes page দিচ্ছি দাদা পড়ে দিয়ে দিচ্ছি kindly takes page 3. But the second box on the left, loudspeaker should be used only from 6 AM to 10 PM in open area after obtaining necessary permission from the competent authority, that is the SDO, BDO, Deputy Commissioner of Police. So, my lord, this is why we apply. And also, my lord, in terms of the Police Act, in terms of section 34A, which is a state amendment, my lord, it's a West Bengal amendment. My lord, for sound permission, my lord, we have to approach, my lord, the SDO. It's West Bengal amendment. So, my lord, this is the grievance, my lord. We apprehend, my lord, in tune with, my lord, I am also fortified with, my lord, judgments galore, my lord, to depict, my lord, how, my lord, may kindly first, my lord, take section 34A, my lord, of the Police Act. This is by you.
Yes.
Yes. No, my lord, also, my lord, may kindly appreciate the wordings of section 30 of the Police Act regarding meetings and assemblies on public roads, thoroughfares, or streets. It is about public. public thoroughfare, public street.
Public assemblies.
Yes. Now, my lord, in support of my contention, my lord, I'll be referring to, my lord, 1973, volume 1 Supreme Court cases, page 227. The relevant paragraph will be, my lord, paragraph number 35. It's, first of all, the ratio is, my lord, public meetings cannot be totally rejected. It can be regulated. But again, it says, if the right to hold public meetings flows from Article 19(1)B and 19(1)D, is obvious that the state cannot impose unreasonable restrictions. It must be kept in mind that Article 19(1)B, read with Article 13, protects citizens against state action. It has nothing to do with the right to assemble on private streets or property without the consent of the owners or occupiers of the private property. Here, my lord, I have the consent also. The pro forma respondent, my lord, I have made the club a pro forma respondent. I have demonstrated, my lord, on a regular basis. It's an annual affair, my lord, that the largest Kali Puja, the biggest Kali Puja of that area, my lord, is held there. My lord, in tune with, my lord, the several judgments, my lord, the Honorable Court has also taken judicial notice, my lord, that opposition has to be given a level playing field when it comes to, my lord, having rallies or political meetings, my lord. In terms of, my lord, the memo at Annexure P2, it is our reasonable apprehension, my lord, that the police, in some way or the other, my lord, and the fire department, because the fire department is saying that no, we will not receive it. So, I'm sorry, but P3, page 29. My lord, in light of, my lord, these facts, I have prayed for an order, my lord, for a direction upon the authorities not to interfere or to permit us, my lord, to have the political meeting, my lord. Interim orders are, my lord, I am pressing for E and F, my lord.
What is the prayer A?
My lord?
When members grant permission
Yes.
to the organization to use the microphone.
B and C, essentially.
Yes.
Prayer B and prayer C, my lord, essentially.
Yes.
My lord, my contention, as I was indicating, only the last point, my lord, regarding 23A, my lord, of the West Bengal Fire Services Act. Boi ache? Debo oita. My lord, kindly take me. It provides for erection of temporary structures or pandals. States that a person who intends to erect a temporary structure or pandal with roof or walls made of straw, hay, ulu grass, golpata, hogla, dorma, mat, canvas, tarpaulin, polythene sheets, and high density polythene or other like material for use as place where members of the public may assemble shall apply to the director for permission to erect such structure or pandal, and such permission shall not be refused if the structure or pandal conforms to the conditions that may be prescribed in this behalf, and the fee as may be prescribed in this behalf is paid. So, my lord, the preconditions are, my lord, first is, my lord, a structure.
Erect a temporary structure.
Yes, a structure, my lord, with roof or walls made of, my lord, these materials.
So
Ours is, my lord, no roof, no side wall, nothing.
There's no roof.
No roof. It's just it's like a podium.
Podium.
Yes, it's a field, it's a playground, and we'll have a small dais where, my lord, the political leaders.
You're not having the.
No, nothing. That is our specific case also, my lord. We have stated that also, my lord, in our pleadings as well. In our pleadings as well as, my lord, to the representation that we address to the police. We have categorically stated that. We have, kindly take
Para 14.
para number 14, my lord. The petitioner further states that the stage that is intended to be erected does not attract the provisions of Section 23A of the West Bengal Fire Services Act 1950. A stage made of iron and cloth without any roof and walls will be erected, and as such 23A of the West Bengal Fire Services Act is inapplicable. However, as an abundant caution, an application has been made without prejudice before respondent number 3, which they were reluctant to receive. That also I have indicated. So, in view thereof, I am pressing for the prayers, by way of, presenting this application under Article 226.
But I am for the pro forma respondent number 7, my lord. I have given my no objection to them, my lord, to continue with the meeting, my lord. And more so, my lord, your lordship has already seen, my lord, the permission which was recently granted, my lord, by the state authorities, allowing us to conduct Kali Puja, my lord, in the year 2025, my lord, less than about 2 months back, my lord. This is my respectful submission.
1 month.
Yes.
I appear for this. But the very outset, Lord, হ্যাঁ, হ্যাঁ। না না তুমি থাকো, তুমি তো একসাথে আছো তো, অসুবিধা কোথায়? আমার অসুবিধা নেই।
Performa is supporting.
Yes, yes.
Admittedly.
Yes. At the very outset, Lord, but I'm taking the point, Lord, that the writ petition has no cause of action. No cause of action. Because of the fact, Lord, that application has been filed, submitted before the authority, and your lordship has seen the subdivisional officer's application has been submitted before the officer in charge. But I fail to understand, I've never seen that SDO application through officer in charge, I've never seen, but subject to correction. However, Lord, so far as the rally or the right under the constitution, but nobody can deny it. But if your lordship kindly see our report, এটা তো দিন তো জজ সাহেবকে
একটা কপি দিয়ে দাও।
দেবো সব দেবো, and kindly see also, because your lordship has just now, Lord, my learned friend submitted that leader of opposition will be there, and he is having the Z category, Lord, the security. Your lordship kindly say এটা দিন তো জজ সাহেবকে, this is the, Lord, the approach to, Lord, reach the, Lord, the ground. Lordship kindly see one after another photographs. This is the way, a very narrow passage, and this is the, Lord, ground. We have taken the photographs for your lordship's convenient. Therefore, Lord, we have, Lord, asked them to, because we have not denied, we have not refused, we have asked them to obtain a fire permission and temporary electric permission. They have already, Lord, annexed. We have nothing to say about this. But so far as the, Lord, my learned friend has, Lord, referred the section 30 of the, Lord, Police Regulation Bengal, that yes, no permission is required. In this regard, Lord, I will place one division bench judgment from paragraph 9. সাইটেশনটা তো আমি তো রিপোর্ট হয়েছে এখানে জানি না, ডাব্লিউপি আমি তোমার কপি দেবো দাঁড়াও, তুমি যখন বললে আমাকে দেবো, আমি নিশ্চয়ই দেবো। নামটা হচ্ছে তোমার ঋতুপর্ণা সরকার দত্ত versus State of West Bengal. But for paragraph 9, your lordship kindly see. দেবো, আমি পড়ে নিয়ে দুটোই কপি আছে, দিচ্ছি। তাহলে তো সিনিয়র কম পেয়ে যেত।
Paragraph 9.
From paragraph 9, your lordship, Lord, I am traveling to your lordship to, Lord, go through from paragraph 9.
Yes.
This is, Lord, the judgment, Lord, in the public interest litigation.
private area, private ground meeting নিয়ে
প্রপোজিশনটা প্রাইভেট গ্রাউন্ড বা প্রাইভেট প্রপোজিশনটা র্যালি প্রোটেস্ট যেগুলো না করা যাবে না বলেনি, কেন বলেছেন? I'm drawing a lot of evidence up to 12. Up to 12.
ঋতুপর্ণা সেনগুপ্ত বটে না?
ঋতুপর্ণা সরকার দত্ত, WP 568 of 2015. 15. জাজমেন্টটা দিয়েছে 2018-তে। তা 3rd May. Though, my lord, I am led by learned advocate general, but he is not, my lord, not in the station. He's out of station. অবরোধ দেবে না না আমার সঙ্গে না বলবে না এই দ্বীপের ঘর সাধারণ আমরা আড্ডা মারছি আলোচনা
Yes.
blood but your lordship has seen blood but there is no denial of right.
Correct.
But at the same time blood the law and order situation control is totally under the police
Correct.
administration, and therefore blood we have asked for these that conditions, but blood without waiting or without making anything, blood they have come up before your lordship. And so far as the blood, your lordship kindly see the report and photographs. Blood the way to blood the actually venue. Your lordship kindly see the passage. Kindly see the passage. Therefore, blood, my resource submission is this. Blood, let them take in blood the permission from the fire brigade, because fire brigade, if anything has happened, just now my land friend has said this, we apprehended, but we are also in apprehension. If anything has happened, entire responsibility will be on the shoulder of the police.
Fire brigade is okay. So you can make necessary arrangement with regard to the deployment of the fire tender, whatever it is, with regard to because there is no such structures are there.
Not structures, but blood
So only if the fire authorities came to know that there is a gathering or something is there for the 2 hours, they can deploy the fire tender if any untoward incident will occur. And with regard to the electricity department is already
temporary electricity, blood, I've seen that.
They will
I've
take
seen that.
precautions of that.
Your lordship kindly blood in earlier occasions, blood, this coordinate bench, several orders have been passed. My land friend also knows, my land friend appeared. I also appeared.
Correct.
But there is blood the reduce of numbers and blood certain conditions and blood the microphone, blood the microphone system blood has been reduced. But your lordship kindly take note of it. Microphone.
What is the permissible volume of the microphone
Decibel limit, yes.
system?
Yes.
What is the permissible
Yes.
limit? They will not go beyond that.
Will not go beyond the permissible.
Authority can take if they were taking.
No, blood. So far as the
Malad will find it at page 44.
so far as the blood the
Malad will find it at page 44.
DJ blood lordship kindly reduce it. Number. Kindly blood. Otherwise blood we shall
Or in fact, Malad, this is not. I have handed up to your lordship, Malad, the notification.
Mr. Bhattacharya,
Yes, yes.
you have stated that 6,000, 7,000 people.
Yes.
But if you come to the page 34, number of person expected to be present at the time in front of the estate 2000.
Yes.
In front of the dais. In front of the dais. That is in front of the dais, my lord, there will be 2000. Thereafter, my lord, there will be a gap. Behind that, my lord, there will be.
What is the total?
Total will be around turnout কিরকম হবে? Total 6000. But they are saying, my lord, I'm on oral instructions, my lord, received from my client present in court. They expect something between, though they have stated 6 to 7, they expect something, my lord, between 4 to 6.
And with regard to the way to go to
My lord,
the
my lord, my instructions are, my lord, vehicles having 10 wheels, my lord, ply through that road. This is one. Second is, my lord, the largest Kali Puja of that area takes place there. Third is, my lord, the judgment cited by Mr. Banerjee. We know of the judgment, but we don't cite it because, my lord, if we cite that, the party in power celebrates, or rather, my lord, has their 21st July program blocking entire Calcutta. Blocking entire Calcutta.
My landed
No, no.
friend has reached
And
by 10.
I'm just replying. I'm just responding. I'm just responding.
Yes.
I'm just responding. my
No,
lord.
no, no. My
And
landed
secondly,
friend
my
has
lord, secondly, but I'm just distinguishing. Secondly, the judgment is squarely inapplicable because my lord kindly takes the first paragraph. But I'm grateful to my learned friend who found out the soft copy because Mr. Banerjee never gave me one. It deals with, my lord, Kolkata and adjoining areas and public roads and thoroughfares. It is not about
No,
private
no, no,
area.
Certainly
That is what the judgment is about.
9, 6, paragraph 9 to 12.
My lord, kindly sees what the honorable court was dealing
The
with.
principle laid down.
Para
Principle
2.
laid down.
Para 2.
It is not
Para 2.
restricted.
And my lord, my arguments,
maybe the matter
my arguments are based on, my lord, section 30, my lord. I have cited Himatlal, my lord, Himatlal Shah,
section 30.
section 30 of the Police Act. In fact, deriving power from section 30, the PRB, the Police Regulation of Bengal, that was also, my lord, the Police Regulation of Bengal was published. I know this book since my childhood because this book was written by one of my uncles, my lord. So I grew up, my lord, seeing this book. So
okay.
PRB also, my lord.
Only blood subject to what my learned friend has said or subject to correction.
I'm just concluding.
Milord, if your lordship kindly, milord, reduce the time from 2 p.m. to 5.
They cannot submit this. They do not have any authority.
No. Then,
they do not have
then your lordship kindly, milord, allow us to use an affidavit.
Yes, please. Yes.
2 to 5 instead of 7. And milord, the number of persons may be within 3,000. Lordship kindly, milord, and the volunteers' names already supplied. Lordship kindly, milord, peruse our predicament also and our agony, our apprehension. Lordship kindly, because it's a court of equity. Lordship kindly make it check and balance.
I'll just refute the contention of my learned friend by relying upon, my lord, paragraph number 8 of Mahinder Singh Gill's case. Para 8 or 10. This is something which is like, my lord, a post-decisional reason, my lord, which is now coming because the letter which was addressed to and which has been responded to, my lord, at page 29 did not contain anything about numbers or about the duration. It was about only the volunteer list, route sketch map of supporters, proposed VIP and other dignitaries, proposed supporters big and small vehicle, and the permission and NOC copies.
And kindly,
it was not even.
With regard to 1 to 6, you have given, you have obtained.
Yes. 1 to 5 we have. I have produced before the honorable court, my lord, the electricity permission.
But
and PWD has no business whatsoever, electrical department. And my lord, we are also using green generators, my lord. That is also we have.
Accident may take place from green generators also. Yes, is the electricity supply. Yes,
they have provided.
Electricity we have already
generator generating the electricity from electricity. May no.
He will take up precautions. But I will pass it on.
Lordship, kindly consider my submissions and kindly record my submissions also. This is premature application, no cause of action.
That I will record.
Yes. And
but I'll just place para 8 of Mahinder Singh's case. I'm handing over.
Kindly reduce the numbers and the microphone.
Will be visited by the local people of that area, my lord. Local people of that area. This is not how, my lord, the voice of the opposition can be suppressed.
Approach to the.
What is the population of that area?
Mother, it's a populated area, but one
Population of that area.
memory is a populated area, but it's
Yes, more than 6,000.
Populated area.
Populated area.
6,000 only.
That is why, my lord, and the dignitaries will go, and with the securities, my lord, we have to maintain that.
the dignitaries had to knock the doors of justice by way of filing petitions. That
Yes,
whenever we go,
that is
whenever we
time.
go, the
That is every
supporters
time.
of the party in
Every
power attack us.
Every
The
time.
police line them up. That is also listed today before the Honorable
Every
Chief
time, my
Justice.
lord, every time.
But para 8, the second
Nowadays,
equally
it has become
relevant
trend.
matter is that when a
Nowadays, it
statutory
has become
functionary
trend.
makes
Trend.
an order
Yes.
based on certain grounds, its validity must be judged by the reasons.
The lordship kindly will not kindly
Grateful,
consider
Your Lordship.
the reduce of numbers and the microphones and the time from 2 to 5. Kindly consider.
The petitioner has filed the present application.
আমার ওই তো 3000 বললাম কি খারাপ কি বলে
The direction
I love you.
upon the respondent.
মানে যে থাকবে লোকমান্য তুই
Upon
থাকবি
the respondent number 2 for grant permission to the petitioner for organization to use microphones and speakers during holding meetings, which is scheduled to be held on.
Lord kindly consider Lord
Yes, yes, I will take care of it. 21/11/2025
100 না
100 hours to 1700 hours at the ground belonging to the respondent number 7 at Chachai, CHA, yeah? 2 numbers Camp Post Office, Pala Police Station, Nimari District, Purva The petition says that on 12/11/2025, the petitioner has submitted an application to the SDO Purva Medinipur, Sadar within bracket South, through the OC Memari PS for grant of permission to hold a public meeting by the Bharatiya Janata Party.
May I take your lordship's leave?
Yes, yes.
Lord, another matter is
Sure,
Mr.
Yes, yes, you can leave. You can leave. You can. Lord, may I also by the Bharatiya Janata Party. On receipt of this said application, the officer in charge, Memory PS Purva Bardhaman, by a letter dated 13 November 2025, requested the petitioner to provide the following information. Following in page 29. Page 29. The petitioner has brought the attention of this court and has submitted that the petitioner has provided the details with regard to serial number 1 to 5 and also obtain temporary electoral connection from the concerned. The grievance of the petitioner in the present application is that there is no necessity for obtain any fire clearance certificate or any permission from the PWD civil or electrical department. On the ground, the petitioner is not making any construction over the proper at the time, not making any construction over the at the premise at the place where the meeting is to be conducted. It is the main contention of the petition that the meeting will be conducted in a stage made of iron and cloth without any roof and wall. And as such, in terms of Section 23A of the West Bengal Fire Service Act 1950, it is not necessary for get any permission. That's why 23A, there is no requirement of getting any permission for fire authority or the APW. Fire authority. The petitioner also relied upon Section 30 of the Police Act, wherein in terms of Section 30, the regulation of the public assemblies and procession and licensing of the same has been provided. He submits that in the present case, being aware of Section 30 of the Police Act, has also applied for grant of permission and obtained all the necessary permission from the concerned authorities. all the concerned authorities. And thus, the fire authority cannot say to obtain permission from the concerned police for grant of fire permission. Grant of fire permission. Conflict for the petitioner further submits that as per Section 23, capital A of the West Bengal Fire Service Act 1950, the person who intend to erect a temporary structure or pandal with roof or walls made of straw, hay, ulu grass, golpata, hola, drama and dharma, mat canvas or other like materials, permission is required. But the petitioners are not making any temporary structure which are coming under the purview of Section 23A of the Fire Service, West Bengal Fire Service Act 1950. Full stop. The counsel for the petitioner submitted the petitioner is intending to hold the meeting in which 6 to 7,000 publics will be attending the said meeting. And as such, the petitioner has taken all the precautions so that no untoward incident would occur. Per contra, learned counsel appearing on learned counsel for the petitioner has also relied upon the judgment in the case of Himmat Lal K. Shah versus Commissioner of Police, Ahmedabad and another, reported in 1973, Volume 1, SCC 227, and submits that the Honorable Supreme Court has categorically held that the state cannot impose unreasonable restrictions. As per Article 19(1)(b), read with Article 13, protects citizens against the state action. It has nothing to do with the right to assemble on private estates or property without the consent of the owner or occupier of the private property. He submits that in the present case, the petitioner has already obtained no objection. Where is an objection?
Yes, no objection from the club. Page 27, Bharat.
Already obtained no objection from the
Uday
respondent.
Shanghu Club, yes, the pro forma respondent.
He further submits that the place where the petitioner intends to hold the public meeting, in the said place, every year the state used to grant permission to perform the Kali Puja. And in the month of October 2025, also in the said area, the authorities have granted permission to hold the Kali Puja, and thus there is no question of denying the petitioner to hold the public meeting in the said place. Per contra, an advocate appearing for the state submits that the petitioner has filed the present writ application without any cause of action. He submits that though the petitioner has applied for the permission, but authorities have not denied with regard to the permission, and thus the petition is not maintained. Secondly, the petitioner has submitted that the counsel for the state further submits that as the leader of opposition is attending the said meeting, but the way to go to the said place, is very narrow, and the police authority has to take appropriate steps so that the leader of opposition should be provided proper police protection. And if this court will allow the 6,000 to 7,000 people to assemble in the said ground, the police will face difficulties to provide proper police protection to the leaders of opposition. Then counsel for the state further submits that in the case of the honorable division bench of this court, in WP 1130 WP 568 of 2015, dated 3rd May 2018 has held that has fixed the guidelines with regard to determine the reasonable restriction. And as such, the state authorities is taking precautions so that no untoward incident is occurred. Learned counsel for the petition, the state relied upon submits that unless and until a restriction is not imposed upon the petitioner for holding the public meeting, the petitioner, the state authority will face will suffer irreparable loss and injury. क्या बोला? Suffer badly to restrict the peoples to go to the place of the meeting, and the police authority will be in trouble. But the London Council for yes, anything further of the state?
Hey, Rusha.
Anything further? You want to add anything?
No, just reduce the numbers, Lordship.
Council for the state submit that though the petitioners praying for holding the meeting with 6,000 to 7,000 people, but it is to be reduced up till 3,000 people. He further submit that the petitioners shall not be allowed to use the loudspeaker in a loud voice, and the petitioner should maintain the loudspeaker in the permissible limit. Had the London Council for the respective parties produce the materials on record. This court find that on 12/11/2025, the petitioner has applied for grant of permission to hold meeting by the Bharatiya Janata Party, in which the leader of opposition is also present. On receipt of the application from the officer in charge of Memari PS Purban has requested to obtain necessary and no objection certificate from the concerned. As per the said communication, the petitioner has to obtain altogether eight informations from the concerned authority, out of which the petitioners already obtained 6 permissions and also obtained the temporary electric connection from the electricity department. Only the question with regard to the fire department, NOC from the fire department. It is the specific case of the petitioner that the petitioner is not making the stage where the meeting is to be conducted is made of iron and cloth without any roof and wall and under such no fire permission is required. Fire permission is required. The petitioner has relied upon section 23 capital A of the West Bengal Fire Service Act 1950, which reads as follows. 23A. If the petition, it is the specific case of the petitioner that the petitioner is not going to make any temporary structure, and the meeting will be conducted at a stage made of iron and cloth without any roof and walls, and thus this court is of the view the section 23 capital A of the West Bengal Fire Service Act 1950 is not applicable. But this court is of the view, as the petitioner says that about 6,000 to 7,000 people will be gathered in the meeting, and thus the fire brigade, fire service authorities shall also take necessary steps for deploying the fire tender, about two fire tenders in and around the place where the meeting would be conducted, to avoid any untoward incident. As regard the provide permission from the PWD civil and electrical department, this could find that is not necessary, as the petitioner is not making any construction in the said place. And the petitioner already applied for the temporary electric connection from the electricity department, from the concerned authority. Good. Considering the above, the petition is disposed of by passing the following order, comma, the gathering and the authorities are directing to allow the petitioner to conduct a public meeting in presence of the opposition leader of opposition on what is the date 21 2025 from 2 p.m. to 7 p.m.
Well, let it be reduced 2 to 5. Well, Lordship, my humble submission.
By the time I am reducing your no, but the gather.
But at least 6 p.m. At least 6.
So why? What is the
Lordship,
reason? I mean, why?
Because
The state cannot have
this
the
is my
same-
own
it does not have
instruction.
the jurisdiction.
No.
Police
Jurisdiction,
doesn't
but
have the
the
jurisdiction.
ultimate police has to control
gathering
everything.
Police
not
does
be
not
more
in
than-
respect of a private
the
meeting.
gathering shall not be more than 5,000.
Madam, may kindly make it 6. Very good.
5,000.
এই 5,000 5,000 থেকে বেশি করবেন।
More than 5,000. Foolish.
Well, just now my land friend has said 4,000 to
5,000, not more than 5,000.
Not more than 5,000.
Not, that's why I have restricted that 5,000, not more than 5,000. Foolish.
and the microphone.
The petitioner
Yes,
shall
we will be
use
meeting the ambient.
microphone as per the as per the permitted limit.
And the number of the
As per the
microphones.
permitted limit, and the number is, I don't think there is any.
Only 10 mics. 10 box and 50 mics. 10 boxes and 50 mics.
50 mics. Lordship,
Yes,
kindly.
the dignitaries.
As per the permitted limit,
Yes.
it shall not use any microphone or any soundbox more than the permitted limit
Grateful.
as provided under.
Grateful.
So what is your law? As per what the state of the guidance in the public?
It depends upon the.
No, but I have handed over the law, my lord, the 2009 memo. The memo to 2009.
Because SDO is the authority.
Yes, we have
But
applied
Lordship,
for him.
your
to the
Lordship,
police.
kindly direct the SDO.
The petitioner.
Kindly direct the SDO.
My lord, may kindly
No, no, just a
specify.
minute.
Yes.
And shall use loudspeaker. Use loudspeaker and microphone in terms of the notification dated 29th of December 2009.
Or, my lord, any subsequent notification.
Or any further amendment
Grateful.
to said notification.
Grateful.
The sub-divisional office, magistrate or officer.
SDO. SDMs here, my lord, are known as the SDO.
That's right. The sub-divisional officer shall be at liberty to keep vigilance if the petitioner use the loudspeaker and microphone above the permission limit, that they are liberty
Grateful.
to take
Mine.
up a petition.
My lord, may file the affidavits of service.
The police. As regard the providing the no objection certificate from the department, this court already held that it is not required.
Grateful,
as the
Lordship.
petitioner
Extremely
not making any temporary structure over
Extremely
over the said place when the meeting is to be conducted. Yes, anything
Great.
further you want?
Lordship, let approach your Lordship. I have seen the photo.
Yes.
I have produced the photograph.
As regard the approach road
To reach
from
the
main road
venue.
towards the place where the meeting is to be conducted, the leader of the at the time of reaching, but at the time when the leader of opposition will approach to the said place, that place should be kept vacant, not more, shall be keep. How many persons will be allowed with the along with the leader of opposition? When
But he is a central government Z category
That category
protectee.
is not this.
A second, sir. He is a central government Z category protectee. Protection is given to him in terms of the yellow book. Insofar as route lining and maintenance of law and order at the place of meetings are concerned, it's done by the state police. But protection of his body, my lord, that is done by the
at the
central
time of
forces.
moving, opposition will move from main road towards the place of the meeting, the state authority as well as the central force.
The SP is the party, my lord. The SP may be directed, my lord, to ensure the route lining and maintenance of law and order. He's the respondent number
Officer in
Fine.
charge, memory police.
He's the
SP.
respondent number
SP
5.
office is
No, the entire district is under him.
not district.
The entire district is under him.
That is
So
our
lining.
Concerned police.
Yes,
concerned
officer in charge.
of
memory
They are so
police.
concerned about the
make necessary arrangements so that the leader of opposition shall not face any hindrance to reach the place.
extremely grateful, Your Lordship.
To place the meeting. Yes. As the writ petition is disposed of without calling the affidavit at the time of motion, all the allegation made in the writ application deemed to have been denied.
Grateful.
And law and order maintained, Your Lordship.
Yes, yes, naturally.
Law and order.
Yes.
The
Yes.
petitions are also
They have to maintain the law and order.
Yes.
the law and order at the time of conducting the meeting.
I'm really grateful, my lord. The state had shown so much of concern about the safety and security of the leader of the opposition. But actually, when he visits, my lord, the situation is different. There are attacks, my lord, which are orchestrated. That is the public interest litigation which is being heard now.
Leader of opposition, time is very short.
Grateful.
After May.
Grateful. Yes, after May, he will be the chief minister. Time is very.
একদম চিফ মিনিস্টার হয়ে গেছে
Thank you for the assistance. Yes, call the next.
1968.
Yes, have you got that report?
Yes. Not first thing first. The suspension order was communicated to him on 7th. Fifth, I'm sorry. Fifth. Secondly, my lord.
Yes.
The first available tournament where he can participate is not on 18th but on 24th
24th of
December.
Okay.
That's the national tournament, and the state ranking senior tournament is on February 2026.
Yes.
What commences from 18th is an underage tournament where he is not eligible to participate. Now, subject to what your lordship will hold, that we have a proposal for your lordship's kind, a submission for your lordship's kind consideration. 29th we hold the proceeding. The notice be taken from here only. In the meantime, we shall give him the show cause notice. 29th the hearing takes place. We will communicate him within a time that may suit your lordship's kind convenience, and what we communicate to him the decision. And in the meantime, he can register himself. He can register himself. Since the registration takes place only in November and December, he can register himself.
He can register. He may allow to register. In the meantime, you issue the so cause notice within a week from date and hold the
29th we shall hold the proceeding. In the meantime, we shall issue the show cause notice.
And take appropriate decision.
Two, three things. Firstly, there are other tournaments also, which is 26th to 26th of December. That's an international tournament. It's in Bangladesh. That's one tournament. And I've been instructed that this tournament, which I had indicated in page 68 and 69, those are also I would be playing. This is what specifically I've taken instructions on.
68, 69.
68 and 69.
To 23rd, 22nd, 23rd, and 1st November. This is 2nd December. That is, I don't know.
24th will be the date. That's the
And page 69. It's the drawing of fixture is on the 25th of November, and the date of the tournament is 11th December to 15th of December.
That's not zone. That's not zone.
No. That's a not zone tournament, but otherwise can also participate.
Not zone inter-university badminton, not zone inter-university badminton.
North Zone Inter-University Badminton, men and women.
He is not a university student.
University, how you are not in the university?
It's an inter-university student.
No.
Sorry,
He's
tournament.
Not the zone inter. Not the zone inter. You are not the north. We are. You are the north zone inter.
The 22nd.
We have been instructed that he was,
ভুল
I don't
বলছে,
know.
ভুল বলছে, ও
ভুল
ভুল
বলছে।
বলছে। Can't participate this year.
North Zone is not there.
Northern Inter কি করে খেলবে ও? That's a university tournament.
Only thing which I am apprehensive of, otherwise I am agreeable to my learned senior friend suggestion. Only thing, there would be requirement to bring witnesses also. So I would also be needed to do that. Then there is a provision for appeal. But everything would spill over the tournament
24th is the first available date.
See, one day, if you want to adduce evidence, then
Bring all-
I don't know what will happen.
করতে বলেছে।
But of course not that page 68 document, it commences from 22nd December, but the first available date is 24th of December for the state. State of West Bengal.
Other thing, but this communication which my learned senior friend handed over, it's not a signed document. It is in the Word format. Kindly see docx.
Correct.
It's not a signed doc. So nobody has taken responsibility. Somebody possibly, and it's not to the petitioner number 1 or either. This is possibly to the petitioner number 2. I
No,
do
we
not
have got
know.
both.
I do not know.
Both we have got.
But this is not a signed document. And this also does not refer to on which date a decision was taken by the committee to suspend.
5th.
It's not there. But it is also not there. So, anyways, this is.
It's from the file.
This never saw the light of the day till date. Now suddenly it is there in
On
the file.
5th we had communicated.
Suddenly,
this.
upon rummaging,
When you receive the copy, when you receive the so-called notice, you made it.
I did not receive any. Oh, when I will.
Then you have it all.
This never saw the light of the day. Suddenly, after tomorrow's hearing, yesterday's hearing, this has come up.
On 5th, twice he was communicated, once through WhatsApp, once through email. He should not have
Disposing of.
Should not have suppressed.
In the registration, I would be permitted to do without
You
prejudice
are at liberty to make your name registered before the tournament at any
for the
tournaments,
tournaments. Yes.
Any tournaments, and you they will issue.
So he has to register his name as a member of this association.
Yes.
You registered your name. You registered a name. By which date you will
The district committee will send his name for registration to us. He has to approach to the district committee.
Where is the district? Here only.
No, he's one comes from East Kolkata district, the other comes from West Kolkata, North Kolkata district, probably.
So where is the head office?
But that's the Badminton Association head office is the one respond number 3.
I think it's in Godia. I'll just check. It's Godia.
It's Godia. Not very far off. ও ডিস্ট্রিক্টের থ্রু দিয়ে পাঠাতে হবে
কোরিয়া স্টেশন
সেটা প্রসেস
না হ্যাঁ ওটা না হলে যেতে পারে না
being agreed with the order of suspension
specific order
issued by the Badminton Association of India, West Bengal Badminton Association against the petitioners on 5th of November 2025 for a period of 6 months. 6 months. With immediate effect, pending further disciplinary proceeding, the petitioners have filed the present application. The petitioner says that the petitioners have not received the order of suspension, but only they got the said suspension order through the from the website, and they could not get an opportunity of hearing before the order of suspension, before it the order of suspension. The petitioner said that immediately after receipt of the order of suspension, the petitioners have made the representations. But you have made a representation? Yes. What is 79 now? You have not made a representation?
Yes, kindly.
Not. You have not made any representation. Good. The petitioner says, counsel for the petitioner submits that due to the suspension, due to the order of suspension issued against
Page 57 is the representation. 57.
The petitions are not, the 57 is, kindly see the date.
This is 17th of September 2025.
Your order is 11. 5th 11. 5th September.
5th September.
5th September. And subsequently they made a representation to the West Bengal Badminton Association, but that has not been considered. Not been considered. The main contention of the petitioners that due to the order of suspension, the petitioners are not going to participate in any of the championship, badminton championship, either national or either national or international badminton tournaments. He further submitted from the month of December 2025, the national and badminton international tournaments is going to be starts, and as such, the petitioner may be allowed to participate in the said tournaments. He further submitted by an order dated 18th November 2025, this court has directed the respondent number 3 for production of the document from which the order of suspension has been issued. In compliance of the order dated 18/11/2025, Learned Senior Counsel Mr. Majumdar has placed the communication, words of communication dated 5th September 2025 and the original minutes of the emergent council meeting held on 5th of September 2025 at 4:30 p.m. Wherein a decision has been taken for placing the petitioners under suspension for a period of 6 months from participation in any tournament with immediate effect, subject to pendency of the pending disposal of the disciplinary proceeding. It is submitted that Mr. Majumdar has drawn the attention of this court to Rule
12
within bracket B of the West Bengal Badminton Association, wherein it is provided that the disciplinary committee for necessary redress based on the gravity of the charges and having due consideration preliminaries, suspend the concerned charged persons or even a members or impose any other interim sanction till the final decision of the disciplinary committee. And counsel for the respondents relied upon the said provisions has submitted when the petitioner came to know about the illegal act of the petitioners, the petitioners have been paid under suspension pending disciplinary proceeding. Mr. Majumdar submitted though the petitions have been placed under suspension, now the association has decided to issue show cause notice upon the petitioners, and the petitioners are liberty to appear before the disciplinary committee to place their grievances. In view of the above, the respondent number 3 respondent number 3, if intending to issue any show cause notice upon the petitioners, shall issue the show cause.
Lordship may indicate it as an association because since it's a registered society, so he had to be imputed to an office bearer.
The association, if the association is intending to issue the notice upon the petitioners, the association is liberty to issue show cause notice upon the petitioner by by which date you will issue?
But we will issue by
within a week from date. Within a week from date.
No, we contemplate to conduct the hearing on 29th so that we can finish it off by.
Then a week will not give a time to give the reply, my lord.
Today we are on 20. By 25th.
So if they could give it by the 20.
By 25th. We are on 20. You will get 25th. By 28 you file, and 29 there will be a hearing. within a week बोला ना, if intending to issue so cause notice, the association shall issue notice, so cause notice, if any, to the petitioners on or before 25th of November 2025, and shall conduct that 2025 fully. It is further informed that the disciplinary committee will be held on 29th of November 2020. According, the petitioner is liberty to appear before the disciplinary committee on 29th of November 2025. Fully. The disciplinary committee is directed to complete the disciplinary proceeding within a week. By passing appropriate order, by communicating the same to the petitioners.
Grateful to you.
With the above observation, the writ application is dismissed.
My lord, the registration issue.
It is made clear that pending the suspension of the petitioners and pending disciplinary proceeding, the petitioners shall be at liberty to register their name before the
district concerned district
badminton association.
Concerned ki bolbo?
District committee of the association. No, committee no.
Before the concerned district committee of the association,
Or with respond number 3 association, as the case may be.
Directly
before
correct.
the any
And
Direct. It has to be through the committee, district committee.
district committee of the concerned district committee of the association, and if the petitioners registered their name, the petitioner shall their name can be the petitioner shall be at liberty to participate in the tournament subject to outcome of the discipline.
Grateful. May I take back that original?
Book there.
I'm so
subsequently, I will correct it.
I'm so grateful.
Yeah, for an email.
That original there, original you can.
We'll supply a copy.
Yes. Original resolution. You give not that resolution. Give it back and take the copy. Yes, next.
My lord, learned counsel appearing for respondent number 7 is on his leg before courtroom number 11. So I am praying for short passover.
What is the matter?
My lord, matter principally, my lord, violates my fundamental right of not being heard, my lord. My lord, he basically, my lord, has nothing to say with regard to, maybe, my lord, he was my appointing authority, Social Welfare Board. Anyway, my lord, if
when
For the state lead by Mr. KJ Yusuf.
because
when your seniors will
I
be
don't want to,
available.
my lord, waste my lord valued judicial hours, my lord, to had me again adjourned.
When your senior will be available?
দুটোর সময়?
No, two other matters.
At 2 p.m.
Tomorrow? What time? Come tomorrow, not today.
My lord, of time, if commences, my lord, I would not stand ever, my lord.
We are coming every day, not today, Lordship. Every day.
No, that I won't say, ma. এরম বলিস না।
Oh, 2 years. Lordship, kindly fix a time, Lordship.
Tomorrow तो नहीं होगा ना, कल तो hearing matters.
My lord always accommodates, my lord. I do not say it happens, my lord, sometimes for the any other reason, my lord.
Then come on Monday.
Monday
Or Tuesday. Because tomorrow I don't think the adjourned motion will be taken. Tomorrow the hearing matter will come first.
My lord. Friday, my lord.
Tuesday.
Friday
also the criminal matter will be taken.
Criminal matters. Very whenever.
Yeah, Tuesday.
Monday, my lord.
Monday. Landed counsel for the respondents press for adjournment. According case adjourned, let the matter appear on 24th November at 12 noon. I have fixed. If your senior will not be available, then you have to argue.
Extremely grateful. 24th at 12. I shall be my post. Extremely grateful.
Next.
Your Lordship, I am for the petitioner.
But I am for the Union of India.
Yes.
Your Lordship, first I would like to give this supplementary affidavit with a prayer to allow this. This is a arithmetical mistake which has been done in the annexure number P8, and it is been substituted by annexure number P13 in this supplementary affidavit. And paragraph 234, it has been mentioned what is the why the supplementary has been submitted.
Who is for the respondent?
I am for the Union of India.
Huh?
I am for the Union of India.
My lord, secondly, the matter is first heard on 3rd 11/2025, and an order has been passed by the Honorable Court and for the mediation. And on 6th 11th, the mediation has been held. And at the mediation center, the answering respondent number 2, 3, and 4 has not came to the mediation center. Neither they're given their presence.
Mediation failed.
Yes, and
What is the grievance in the
and
writ
accordingly, the meeting has been postponed by the mediation center with an order to present before the mediation center on 21st. So I will request your lordship to pass a necessary order to direct the respondent number 2, 3, and 4 to present before the mediation center at least.
What 2, 3, and 4?
2, 3, and 4 are the bank, Punjab and Sindh Bank.
Lillian Asker.
Yes. Union of India is not the answering respondent. 2, 3, and 4 is the answering respondent.
Fourth is the Tumpa Mandal.
Yes.
2, 3, and 4. So it is fixed on 21st.
It is given on 21st, but I need the liberty to serve today's order to them. So it will be.
This is a mediation center. They have issued the notice. They appear. How the court can direct them to appear before the
Mediation center. That.
Center already issued the notice.
Yes.
Come on, I am fixing on next week, 27, 28.
My lord, after the order of the mediation center on the 6th, they haven't appeared, and it is being clearly directed in the minutes.
Will not appear, automatically non-starter report will pass and it will be communicated to this court, and then this court will proceed with the matter.
Okay, my lord. Okay, my lord. Then fix a matter.
Order.
Yes.
If they will not appear, then tomorrow you will come with a contempt application.
Okay, my
They
lord.
have not appeared.
Okay, my lord.
Take all these
Okay,
responsibilities.
my lord.
Of the mediation center, they have issued the notice.
Okay, my
They are
lord.
interested to settle the matter. They will come before the mediation. They are not interested to settle the matter. They will not come and
My lord.
report.
Okay, my lord. It will be better than fix a time.
Supplement
Yes.
affidavit.
And my lord.
Let us say pick up with the record. The petition also handed over the notice issued by the mediator fixing the date on 21st of November 2025 at 4:30. Accordingly, the case is adjourned. Let the matter appear on 3rd December 2025.
My lord, one thing I want to bring to your notice, my lord. The cost title has been wrongly input in the list, Delhi list. It can be changed. It is given in the. It is Ranjit Sarkar versus state. It will be Ranjit Sarkar versus Union of India. And the advocate name is also mistakenly.
The petitioner has pointed out that in the cause list, the cost title has been wrongly recorded as Ranjit Sarkar and others versus state.
My lord, with the liberty to serve today's order to the respondent, it will be highly obliged.
But it should be Ranjit Sarkar and others versus Union of India and others. Accordingly, the name of the parties in the cause list may be corrected. Attorney department is directed to correct the name of the parties in the cause title.
My lord, I am paying liberty to serve today's order to the respondents.
Yes, next.
Obliged, my lord.
Item number 20.
Obliged, my lord.
20. I beg favor the petitioner, my lord. It is served much earlier, my lord. It is served much earlier, my lord. It is to 21's petition, my lord. My lord.
2021.
2021 matter, my lord.
So, what is the grievance in the petition?
Yes, my lord, the final bill is not settling, my lord. The tender amount, my lord. I have completed the tender work, my lord. 70%, my lord. There is a note sheet of the authority that I have completed the 75% of the work, my lord, and worth rupees 12 lakh something. And that amount has not been settling, my lord. This is my grievance, my lord.
Who's
And
appearing for the state?
state, not my lord, the Union of India, the Coal India is the necessary party, my lord.
Coal
Fox and
India.
Mondal appearing in this matter.
Without the notice.
Earlier, sir, my lord.
Then fixing a date, issue the notice.
My lord, as your lord.
As none appears on behalf of the respondents, comma, the petition is directed to inform the next date of hearing to the respondents and to file affidavit of service on the returnable date. Let the matter appear on 9th December.
I'm grateful.
Next.
The 21, my lord, I am appearing for the state led by Sheikh Mohammad Ghalib, my lord. He is physically
For the
present
petitioner,
over
my lord.
there.
The petitioner, my lord, seeks a license under the Bengal Moneylenders Act, my lord, money lending license. The statute provides that I can make an application before the appropriate authority, and my lord, they can consider it and pass.
Whether
before the my lord, appropriate authority of the collectorate.
Before applying this license,
My lord.
have you started the business
No,
of money lending?
No, I have not started. I'll do it subject to the license being granted. Now, my lord, initial application, my lord, came back. First application is at page 11, my lord. It with form 2, which
Page
is
11.
requisite. Page 11. Yes. This is not first application made, sent, came back from the sub-registrar West Bengal Moneylenders Act at page 14 with the endorsement, my lord, that no such person in the address.
Page 14.
Page 14 and 15 are the, my lord, postal, my lord, consignment particulars. I send it, it comes back at page 15 with receiver reported no such person in this address.
To whom you are sent?
This was sent to the sub-registrar Kolkata Collectorate because he is the not concerned person, my lord, who is having the office of money lending.
That is not available.
Not available. Then, my lord, I sent it, page 16, next application, to the department in charge, Kolkata Collectorate. Now, this, my lord, comes back with the form 2. This comes back with the endorsement refused. If your lordship, my lord, takes up pages 19 and 20.
Refused.
Refuse means, my lord, that the address is correct. They are not receiving. After that, he has gone personally, my lord, but it has not been, physical copy was also not accepted. And page 21, my lord, is the order of the government, which specifies from 28th February who is the person who has been given charge of, my lord.
Additional director of small saving is interested to look after the charge of director.
My lord.
Then
So
you
it was
apply
again, my lord, sent once more at page 24.
Correct.
But not again, my lord, it comes back with endorsement refusal.
Again refused.
Refused, my lord. If your lordship kindly comes to page 32 and 33.
Yes, refused.
Under this position, my lord, since refusal is good service, my lord, I take it to be, my lord, a good service, and my lord, then
To whom you served?
But the person in charge of the money lending.
Come to the page 32.
32, my lord.
Correct.
My lord.
And kindly come to the page 21.
21, yes.
21.
Additional director.
Then where is the address of the additional director?
So that was also done. I'll check, my lord. Address is same, my lord.
My lord, may you shorten the issue.
11 NS Road.
May the issue be shortened, my lord. My lord, as per the Act, Moneylenders Act 1940, the license issuing authority is a sub-registrar, that is respondent 5. So, my lord, I find, my lord, that he has to consider it.
It was sent to sub-registrar also.
My lord, so lordship may direct this respondent 5 to consider this in accordance with.
First he has refused. Kindly see the page number 11.
It was by post, I find, and the endorsement is first endorsement. No, page 11 is the first. Page 11 is the
Person is
No such person in this address, but not there is a sub-registrar. I have also ascertained from the internet and as well as my learned friend, there is a sub-registrar in the office of collector.
Kolkata collectorate will consider. Lordship, he has to consider, my lord. Kindly send it to him.
It is part of this writ application. This has been served upon the state because my learned friend, senior friend is appearing and representing.
But the problem is that his application is not with the authority.
Yeah, so this application, since it will be now, if he is asked to apply afresh, it will be a new application. So let this application be sent,
Which is part of the
given by
petition.
him, and be considered.
Let it be considered not by the respondent number
Got
5. Now 4 code.
But as per your
Five, not director, 5.
now as per your notification,
Notification test 4. As per notice is 4, my lord. As per notification. Page 21.
Page 21.
Page 21.
Act says, but the authority joint secretary to the government of India has given the additional director of director Smallest interested to look after the charge of director Smallest.
But till
To be very honest and humble, my lord, I had a discussion with this respondent for just a few minutes back.
Okay.
He says, my lord, that a copy may be sent to me also.
No, this is the act.
So, my lord, let this gentleman be approached. He will take the necessary, my lord, steps.
Section 11, my lord, kindly takes up.
Yes, I have.
Sub-registrar is the authority, my lord.
Yes, I have already stated that. Section 11 is there, sub-register, that is respondent 5.
This is the act, my lord, concern.
I have said already.
Yes, yes. Now, the heel. 5 we consider.
As per the act, 5 is authority, jurisdictional authority.
Correct.
Let 5 consider, my lord.
So that is why I was asking for 5.
The petitioner has filed the present application praying for consideration of representation for grant of license for money lending.
Yes, stated.
Initially, the petitioner had made an application to the sub-registrar Kolkata Collectorate NS Road on 8th of June 2025. Praying for grant of license of money lending. But the same was returned with the endorsement. No such persons in this address is available. Subsequently, the petitioner has sent the representation to the department in charge. The same was also returned with the endorsement refused. So, the petitioner again sent the representation to the small saving.
Department in charge.
Small saving. And the Directorate of State Registrar of Money Lending. But instead, application response returned the endorsement. The counsel for the petition submitted time and again the petitioner had made an application, but the same has been returned to the petitioner either addressing not available or refused. He submitted that as per section 11 of the Bengal Money Lenders Act. The sub-registrar is local units in whose jurisdiction the money lender lending license is to be issued with the authority for consideration of the case of license copy.
এরকম কালো কপি লাগিয়েছিস কেন?
Internet council appearing for the states.
তো এটাই fulfill যে ডেপুটি পাঠিয়েছে পড়াই
As per section 11 of the physical copy. Sub-registrar
এটা কি এন্ডোর্সমেন্টটা কি আছে? না না এটা হচ্ছে ডিপার্টমেন্ট
And as such, if the petitioner approach the said authority from the said authority to dispense appropriate order, will dispose of the grievance and representation of the petitioner within a specific time. Considering the above, the writ petition is disposed of, But how? Then he has to submit this application.
Lord, this application is part of the writ petition which is served upon them, my lord. So it is.
Petition
And Lord, what we serve the writ petition again, it has been, Lord, come back with the endorsement.
You submitted a press
They are not
application
taking.
within a week.
They are not taking the physical. I have pleaded. I have pleaded, Lord, that we went there physically to submit a physical copy, which was not accepted. This is a difficulty. Lordship will kindly record that the office of the collector shall accept the copy.
Yes, Lordship.
No,
Is the authority to
একটা কালেক্টরকে অ্যাড্রেস করে করব কারণ এটা রিসিভ করার পর চাইবে পয়সাটা নিলে তো পয়সাটা পাবে
specific type. In view of the above, the petitioner is directed
to collectorকে অ্যাড্রেস করবে
to submit a fresh representation to the sub-registrar, to the respondent number 5, that is the sub-registrar, Bengal Money Lenders, Kolkata Collectorate, NS Road, Kolkata, within a period of 1 week from date.
So my lord is directing 4 to forward to 5. My lord is involving directorate also.
No, I am not. I am not, because as per the act, it is there.
It is 4.
I don't need that notification is continue or supersede.
Lordship, respondent 5 will be the
5,
consulting
yes.
authority.
And to the so and so, and 1 week from date. And if any representative, the sub-registrar is directed to accept the representation submitted by the petitioner, if any, and to pass appropriate order after giving an opportunity of hearing to the petitioner within a period of 4 weeks from the date of receipt of the
8 weeks.
8 weeks from the date of receipt of the representation by passing a reasoned and speaking order.
I'm grateful, my lord.
Though the writ petition disposed of at the motion stage, the allegation made in the writ application is deemed to have been denied.
I'm grateful, my lord.
Deeply obliged, my lord. My lord, let my name be recorded along with Sheikh Mohammad Ghalib, my lord.
I've already given your name, madam. Don't worry.
Deeply obliged.
Not
To
to
you
me,
also.
To my lord.
Has made representation, but the same has been returned to the petitioner with the refused. Yes, next.
My lord, I am appearing for the petitioner.
My lord, I am appearing on behalf of the respondent's company, along with Mr. Sumit Roy, who is in appearing.
My lord, my reply, affidavit and reply be taken on record.
Yes, what is the case?
My lord, I'm led by Mr. Abhishek Haldar. There's a bereavement in his family. Someone died, my lord. So I can continue, my lord, if my lord wants.
You will argue?
If my lord wants, I can argue.
I don't want. It is your case. If you want to continue, the court will hear you.
My lord, I want to start.
You want to start? But you have to complete.
Then, my lord.
What is the matter?
My lord, it's a matter. My land has been taken. It's a 12 decimal of land adjacent to NH 512. The land has been utilized as a corridor for 132 kV transmission wire, and no compensation has been granted to me.
When it was taken for utilization of the.
My lord, in 2023. 2023, I've raised objection. I was given hearing.
Have you considered your request?
No, my lord.
Compensation is given.
No compensation has been given.
Yes. What is your stand?
Page 30 is the order.
Page 30.
Yes, my lord. Impugned order is at page 30.
Terms of the Honorable High Court's order.
30.
30. Annexed at P1.
Yes.
My lord will come. My lord will take up telegraph acts, my lord.
Which section? 10D?
Yes, my lord. 10D. My lord, the language of the section is any damage. But what they have quoted here is no physical damage. My lord, how can they come and interpret damage as physical damage? My lord, this is a homestead land of me. I was going to make construction on it. Due to this stringing of the transmission wire, I'm not being able to utilize the land at its fullest potential.
It is a high tension line, is
Yes, my lord, it's a 132 kilovoltage transmission wire.
How you can do that?
My lord, not a penny of compensation has been given to us.
My senior method, under the act, we have the right to draw line without any permission. Accordingly, we have drawn the line. If he is entitled to get compensation, he, my lord, the company will provide that. If suppose they have assessed zero compensation, their remedy lies upon the district judge to challenge that order.
Under the law.
My lord, we have done that. My lord, we have done that. There.
Appeal?
Yes, my lord.
Yes,
My lord, we have filed.
in the appeal?
My lord, the appeal has been reminded back under order 7 rule 10.
Where is the order of the district judge?
Yes, ma'am. I'm showing.
So if it is the order of the district judge, then you challenge before they have remanded the matter back.
Yes, my lord.
Then?
My lord, we have filed a civil revision to that effect.
Correct.
This Honorable Justice Shampa Sarkar granted us the liberty to file this writ petition because there was no other remedy we can avail it under the act.
Where is the district judge order?
My lord, the district judge order is at page 79. It is dated 1st of December 2023. My lord, where the specific statute is giving the subject matter jurisdiction, the order has been rejected on want of subject matter jurisdiction.
Reference is regard to made a decision. So this is a written of plaint.
Yes,
Plaint is written to you.
Yes, my lord.
District judge does not entertain.
No, my lord.
Yes.
For want of subject matter jurisdiction, to that we have filed a civil revision. The revisional court granted us the liberty to file this writ petition because
the revisional application order.
My lord.
That is order.
Page 80, my lord.
Page 80.
Yes, my lord. My lord, there is a recent Supreme Court judgment on all these issues, addressing all these issues. If my lord grants me permission, the matter is kept tomorrow. My senior will also be there. I will place that judgment, my lord.
But
my lord, it's a 19th August 2025 judgment by Supreme Court on this issue.
from Kerala?
Yes, my lord.
From Kerala?
Most probably, my lord. I exactly don't remember.
Bunch of cases of
Yes, my lord. It's a nine applications.
Correct.
It's a bunch of 9 applications.
with regarding compensation of
Compensation, my lord. Yes, my lord. My lord, kindly keeps the matter tomorrow. I'll place the judgment.
not tomorrow, from Monday.
My lord.
Before that, may we get the copy of the order? Because I'm told that is not available in any of the journal. If I get a copy.
The
Yes, ma'am.
counsel for the petitioner argued at length, but argument could not be completed. She submitted that she is relying upon the recent judgment passed by the Supreme Court. Accordingly, case is adjourned. Let the matter appear on 25th November.
In
25th, 26th, I shall be out of station.
25th, 26th are out of station. 27, 28 will not. Then come on 1st of December. 1st of December.
In the meantime, let me have a copy of that.
What copy?
That the
Judgment.
judgment, yes.
Okay, let they come with the judgment. Yes, next.
Obliged, my lord.
Take your book. Yes, next.
Yes.
Yes, sir.
Yes, my lord, I am for the petitioner, and the copy has already been served by a affidavit service. Just I'm placing the affidavit service first. And the basic thing that without giving any opportunity or without considering my representation by the forest department, my forest license has been cancelled without considering my representation and without giving any opportunity to the petitioner in question.
Where is the order impugned?
My lord, the kindly sees the cancellation order at page
Who has issued
50,
the order?
50, at page 50.
50.
Order passed by the forest department. Page 50.
50 of writ petition.
50 of writ petition.
I don't have any 50 in my writ.
Your writ petition ends on 44.
Up to 44. That is why I was also looking for the impugned order.
Your writ petition is from 44.
My lord, this is kindly sees.
44, up to 44. In fact, I have taken a note.
Volume 2.
My lord, kindly sees my.
Yes.
Volume 2.
Yes, volume 2.
I have not been served with volume 2, Lordship.
Entire I have served. I have served the entire writ application, even the volume 2. This is my copy.
But the problem is the state is having some problem with the document. That's why they are keeping your document.
You have not served.
And only
No, this is the only writ petition I have received.
that document has been supplied.
Even in the back sheet also there is no written. It's not written volume 1.
My lord, it was served by my clerk, but volume 2, if not served, kindly allow me.
You have been mentioned
Volume 1,
here.
volume 2 bola ho nahi to.
You are not mentioned here also. That's why this court also.
Yeah.
Then I check it.
So right. Sorry, my lord, kindly.
Nahi volume.
Give the copy.
Back sheet is volume 1 bola nahi volume.
My lord, just I have got the one copy. I'm giving the copy.
Only volume 2 will do.
Oh, yes.
I have volume 1. So got.
So I may kindly be allowed for only 15 days to serve the copy properly.
15 days to serve the copy.
Not today kore din. I am ready with.
No. Tomorrow I will not be. Make it Friday.
No, not Fridays. Make it Monday then.
No, Monday I will not be available, my lord.
It is informed.
Either Friday or next week.
That the volume 2 of the writ application is
Sorry, it is
served upon
service.
the
Volume
state
2
authority.
survey karone na.
According petition directed to serve
Total to
the
service kore to.
the writ application to the petitioner.
44 mane
By-
mane first volume.
I know.
44 tak mane first volume is up to 44.
No, first volume.
By 24th, you serve the copy.
Yes.
Serve the copy by 24th.
Yes.
By 24th
After
of
44, I will serve
by
the second
24th of November 2025.
Start
Please-
from 40,
Is the matter on 26th?
44. Start from 44.
26th.
Yes. My lord, 26. Yes. Serve koro. আজকেই তোমাদের নাম্বার নাও নাম্বার নাও
By 24th, is the matter.
সার্ভিস করো আমি আজকে সার্ভিস করে দিচ্ছি
Volume 1 up to 44.
up to
45. Clerk number 10.
নাম্বার নিয়ে নাও ক্লার্কের নাম্বার নাও
This matter,
So, my lord,
additional Solicitor General is appearing. I'm led by, but he is not present today. He didn't come to the court today. Kindly adjourn the matter and fix a date.
What is the matter?
Lordship, may
ASG is appearing. What is the seriousness in the
Lordship,
matter?
the matter is for renewal of passport.
Renewal of passport.
Well, after filing this writ petition, some correspondence has to be incorporated, and I have made a supplementary affidavit. So, supplementary affidavit will kept to the record and copy.
What document you want to rely further?
Lordship, after filing this documents, which has been a letter issued by the passport office for giving a objection with reference, and I made an application, and where Lordship the clarification seeking to enclose some documents with the criminal cases, and I have annexing all the
Have a criminal case? You have a criminal case.
Lordship.
So you obtained the relaxation from the London trial court.
Lordship, I have got an order.
Got an
Lordship,
order.
Got an order.
In spite of
And
that, they are not
Lordship,
allowing.
I am placing that
No,
one document.
after getting the order from the trial court, the authority is not renewing the passport.
Lordship, what the petty cases, Lordship,
No, I
I am
want a
showing
copy
that
of the
one
supplementary
document.
affidavit.
Okay, you give the
Lordship,
supplementary affidavit. Give the supplementary affidavit. When your ASG will appear?
26th or 27th, 28th November.
You take instruction. Learned Counsel, you give the supplementary affidavit.
Lordship, I am giving
Learned
the
Counsel for the
supplementary affidavit
petitioner
and
has filed supplementary
then-
affidavit by disclosing certain documents after serving the copy to the Learned Counsel for the
but the affidavit be service be kept to the records.
respondents. Let the same be kept with the record. Full stop. The counsel for the respondents prays for time. Record. Let the matter appear on 2nd December.
But the affidavit service be kept to the records.
Affidavit service be kept filed by the petition be kept with the record. Yes.
The supplementary affidavit, the affidavit service be also be kept to the record.
Come on, 2nd.
2nd December. Grateful.
25.
Not my writ petition. No, they were there on the last occasion. Because I had taken adjournment on, I think, last Thursday or Friday because I was not ready in the matter at that time, my lord. I'd asked for a one-day accommodation. It's a very simple matter, my lord. I am a manufacturer. I'm in the business of manufacturing envelopes. And Government of India gave me a contract, 2 contracts for making, for giving them 5,60,000 and 9 lakh envelopes, total 47 odd lakhs. Rights, the inspection agency, they were supposed to do the inspection, and upon their confirmation, I was supposed to supply.
Envelope also rights is there.
Rights is there also. Rights, my lord, conducted 3 investigations. Every time there was a different personnel, and for one reason or the other, they have raised issues which, my lord, according to us are, and your lordship will also see from the report, is my lord, not at all, they're arbitrary, and they're, on that basis, my lord, we could not been able to supply. Because of non-supply on time, Government of India has not terminated that contract. So our entire issue is, my lord, the inspection which Rights has conducted.
What the red court will do?
My lord, I am asking, my lord, 2 things has happened. One, my lord, 47 lakhs I have already spent. My envelopes are all ready. I've invested the money, everything is ready. Number 2, I had also a security deposit of 1.5 lakhs, which has been forfeited.
Go.
My lord, writ court, my lord, here. Well, here, your lordship will see whether the inspection agency's actions are rightful or wrong. That is all, my lord. So I was actually asking for, when they come, I'm asking for twofold interim prayer, my lord. One, my lord, if the inspection agency, Rights, can conduct an investigation again, an inspection again, and give a proper report. And my lord, if the report matches with whatever the criteria is, it's all.
Suppose today they might the report and you find it is okay up to the mark.
Then Government of India has to accept it.
Then the Government of India will take now. After that, we have already issued the tender and the other party has supplied the material.
But the wrongful termination, absolutely wrongful termination.
What the writ court?
My lord, your lordship can also grant me compensation, my lord. A monetary relief, even a writ court can grant. This is absolutely wrongful, my lord.
None appears on behalf of the respondents. For the interest of justice, the case is adjourned. Let the matter appear on 25th. 25th under the same heading.
25th.
Affidavit of service filed under petition. Next.
It's my action. And I am for the respondent. Okay. An affidavit of service. Well, the petitioner is a constable under the CISA, under the Union of India, without making a suspension, without termination, his remuneration since April 2025 has been stopped.
CISF.
Yes. The only he is ill on the stress
adopted by the higher authority, where he compelled to admit it in the medical college hospital in Calcutta. He's the permanent resident of the West Bengal.
He is the permanent employee as a constable.
Yes,
He was a
12 years service has been rendered.
Huh?
12 years service has been rendered.
Correct.
And thereafter, my lord, he admitted in the medical college hospital, and sometime he absent of his service.
He was
But,
suffering from what?
my lord,
He was suffering from what disease?
my lord, the mental and also physical disease. My lord,
Physical disease.
only my lord, the higher authority, my lord, use his as a servant.
So how the writ petition? Why the central administrative tribunal?
My lord, if there is the violation of the fundamental right as well as the constitutional right.
CISF is not under the central administrative tribunal. It is not coming under central administrative tribunal.
No, my lord.
No.
This is practically the cause of action, what heroin in Jharkhand. I am surprised how it is maintainable here.
That's why I'm asking first maintainable with regard to writ petition. I am not on that.
No.
With regard to you are appearing for whom?
For Union of India, my lord.
Union of India. CISF is
Yes, my lord.
CISF is the central government unit.
Yes, my lord.
Correct. And he is working under the CISF. So whether the CISF is not covered under the notification of the Central Administrative Tribunal Act?
No, my lord.
No.
No.
So it is directly to the High
Yes,
Court.
yes.
So it
CAT doesn't deal.
Huh?
CAT is not within the CISF, BSF, all these things.
that is on
Yes,
directly
yes.
to the
Yes, my
to the High Court.
Yes.
There is no notification on the Central Administrative Tribunal.
No,
Okay.
no,
And
not
now
yet.
second is the cause of action arose in Jharkhand, where he was posted.
He was posted in last posted in Bokharo. Kindly bولیں Chandrapura, Bokharo. He was practically his all jurisdictions lies in Ranchi, and his grievances against the respondents are the authorities in Ranchi, in Jharkhand. So he has filed this application only because he is resident of West Bengal.
Yes, sir.
And the prayer portion is also mine.
Respondent number 3 is assisted financial benefit to be provided. Medical unfit.
Yes.
He has been declared a medical unfit.
Not declare as a medical unfit, but
Where is your discharge certificate?
do not discharge certificate. Kindly come to the page 30. This is the medical opinion or specialist list. Page 30.
Page 30.
According to the medical opinion, the rest is required for the purpose of the recovery is health.
Sir, he was working as a constable.
Yes.
Whether he has been what is the problem with you now? He is in service.
He is in service.
So what do you pray for now?
I don't know why authority did not pay that my remuneration.
Only for release of your salary.
Yes.
Salary.
Yes.
Where is the prayer? Total recovery alternative renown.
But the mental torture by the respondent 3, his association or financial benefit to the provide for the respondent till recovery. A writ in the nature of mandamus commanding the respondent to issue direction upon after recovery the petitioner should join.
Pension. Monthly pension. So that's why I'm asking whether you have been declared as a medical unfit.
Nobody will be.
Or whether you have been discharged from performing the duty of the constable by the CSF authorities. Whether you have been dismissed.
No, nothing has been done. Not
what prayer you have made?
My prayer is prayer B, the writ in nature of mandamus commanding the respondent to issue direction that after recovery the petitioner should join in such unit wherein the petitioner can tender the service as per the direction medical.
Where is the case that you have joined and the authorities are not allowing? Where is
Yes,
the
ma'am.
case?
Yes. Obliged.
Where is the case?
My lord, until and
Show me the letter that you are suffering from illness, and after the recovery of the illness, you appeared before the authority, but the authority is not allowing you to report the duty. Where is that? Show me.
till now I am in the bedridden condition. I am not capable to go to the one place to another place.
So what is the prayer? You see the prayer? Retirement benefit with monthly
Well,
pension.
this is the subsequent and alternative pair. If they did not make payment in
Coming to the High Court while preparing the writ petition, you should bear in mind what you are praying before the court, and it is the life of your petitioner.
Yes, well, April 2025, no payment has been made. But during that period,
I fully appreciate. He was under medical treatment. He could not join the duty. The medical neither the medical reimbursement nor any monthly salary has been released. So your simple question is that he may be the monthly salary be allowed and the medical reimbursement. What is your prayer?
In pair C, I am not placed. Well, I am not. That has been wrongly adopted. But I am not placed in the pair C. But
And where is the letter that you have joined? Where is the letter you joined, or where is the letter that you are under medical treatment? You may be allowed to continue under medical treatment. After recovery of the medical treatment, you will join the service. Where is that?
Representation.
Which service jurisprudence you are reading?
Malada given liberty to live in
Withdraw it.
Malad given
And also see whether the cause of action before this court is there or not.
yes. This is the also Malada.
Petitioner may reside, but the cause of action where he was posted, Jharkhand.
All along he was in Jharkhand.
According to the section 20 of the Code of Civil Procedure, any office
For the doesn't apply in the rate in the service matter. Then every government employee who is working in the state of the West Bengal given in the deputation to the other, then
if that person will be working under the Union of India, they may be.
It's a judgment of this court also, and my judgment is also go through. I don't remember.
If your lordship kindly adjourn this matter today, I will ready.
Consult.
Yes.
These are the 2 points. How your writ petition is. First is with regard to
Regarding
I
jurisdiction.
think there is a judgment. I know neither here or there. I don't know. And second thing, where is the representation? Government employee without the representation, how you make a prayer before the court?
That lordship given liberty to file a fresh representation, and that will be considered.
The service, that's what I'm telling. So in the service-
I see and come back.
As per the affidavit of service filed with the petition be kept with the record. Affidavit of service filed with the counsel for the petitioner prays for time to take instruction. According cases adjourned, let the matter appear on 9th December.
One thing, disciplinary departmental process is going on and he is not appearing.
Bring. The full
If
report.
he is
Then
not
at counsel
moved
for
to one
the
place to another.
then at counsel for the state. You are appearing for the state.
Yes.
CISF submits that the writ application is not maintainable before this court on the ground of jurisdiction, and the CISF authority, the disciplinary authority have already initiated a disciplinary proceeding against the petitioner for absence from the service, from long absence from the service.
Absolutely.
As the petitioner prays for time, accordingly, the court has not gone into the matter of the case, not gone into the merit of the matter. Let the matter appear on so.
Get.
Have you received the charge sheet?
No.
Disciplinary proceeding?
No charge sheet administration.
Have you received the charge sheet? Memo?
Nothing. I will take instruction.
My lord, in 27, I'm appearing for the petitioner, my lord. My lord, here, my lord, petitioner is praying for, my lord, the amount which has, my lord, has been paid to the deceased who have died in the COVID-19 period, my lord, which is my lord 50,000 amount, my lord, and also the amount which is my lord because the body of the deceased person could not be handed over, shall not be handed over to the my lord, to the family of the deceased, my lord.
Who is the petitioner?
My lord, petitioner is the husband of the deceased, my lord.
Husband of the deceased.
Deceased, my lord.
Correct. So,
My lord,
this is the wife died during the pandemic COVID-19.
yes, my lord. May I should
Due to the
illustrate
COVID.
Yes, my lord. In 2021, 22nd May of 2021.
Correct. Then,
my lord, may I lordship show you the advertisement where my lord, page number
the
29.
notification you are claiming the damage.
29, my lord, with this
29.
page 29 of my writ application, my lord.
Yes.
My lord, to the my lord, the disaster management authority, my lord. Here, my lord, in the first column, where it has been stated, my lord, who died prior to 28th March 2020, they have to, my lord, approach the authority and within 60 days, my lord.
20th March?
28th March 2022. Petitioner wife died in 2021 of
Yes,
May,
within
my
that
lord.
period, yes.
Yes.
Then,
My lord, file an application for my lord, the payment of the ex gratia amount to the disaster management authority, my lord, which is annexed in page 24, my lord.
so what has happened after
After that, my lord, the petitioner only came before this honorable court, wherein my lord, Honorable Justice Champa Sarkar, my lord, passed an order directing my lord to take the previous writ petition as a representation and considered to the considered to the SDO, my lord. After that, SDO, my lord, called for the hearing. But till date, my lord, they made RTI application about any order has been passed or anything, my lord. Till date, no order has been passed and no money has been disbursed in favor of me, my lord.
so have you appeared before the authority on 28th of January?
Yes, my lord, we have applied on, my lord.
No, you have appeared before the authority on 28th January in terms of.
Yes, my lord, we have duly appeared before this authority, my lord. Yes, we have approached the we have appeared on the hearing, my lord.
The wife of the petitioner died during COVID, died on 22nd of May 2021 due to COVID-19 pandemic. Full stop. The petitioner has made a representation to the authority for grant of ex gratia payment within bracket compensation on account of death of the wife of the petitioner during COVID pandemic 19.
And my lord,
as the representation submitted by the petitioner was not considered, according the petitioner has filed the writ application before this court, being WPA 2703 of 2023. And this court, by an order dated 27th of September 2024, has disposed of the writ application, directing the sub-divisional officer Sri Rampu Hugli to consider the case of the petitioner and to communicate within a period of 3 months from the date of
service of the copy of the order. In terms of the order passed by this court dated 27 September 2024, the sub-divisional officer Sri Rampur Hubli had issued notices of hearing on 10th of January 2025 and 28th of January 2025. And according the petitioner has appeared before the concerned authority, but till date the concerned authority has not passed any order. Considering the above, this court find that no purpose should be served by keeping the writ petition pending. Accordingly, WPA 13320 of 2025 is disposed of by directing the sub-divisional officer Sri Rampur Hubli to comply with the order passed by this court dated 27 September 2024 and to complete the proceeding and to pass reasoned and speaking order after giving an opportunity of hearing to the petitioner within a period of 6 weeks from the date of communication. WPS disposed.
Lord, in the previous year, it was conducted, my lord, the hearing, but no order has been passed in accordance with the law, my lord. My lord, earlier occasion, my lord.
28 January. Yeah?
Lord, earlier occasion hearing was conducted, but it was not
Correct.
considered.
No order is passed. Again, has to pass. Give the hearing. That's why 6 weeks time is given.
My lord, the prayer is, my lord, the ex gratia amount of 50,000 and
But
also.
how the court can decide you are entitled? The authority has to decide. If the authority will say you are entitled, they will release. If they found that you are not entitled, then you can challenge the order. Let the authority decide, sir, first.
My lord. HON'BLE.
May it please, Your Lordship. May it please,
I'm
Your Lordship.
appearing for banking ombudsman in the matter.
My Lord, this is my affidavit of service, my Lord. My Lord, insofar as Axis Bank goes. My Lord, may kindly first seize Your Lordship's last order dated 12th of November 2025, my Lord, after which, my Lord, I'll just, my Lord, recapitulate what my case was.
Yes, who is appearing for the bank?
I'm appearing for ombudsman.
My Lord, bank. Yes, I've served. I've given the affidavit of service, my Lord. There is one hand receiving and there's one email also, my Lord. If Your Lordship can. Both are there, my Lord. As well as Your Lordship's order.
Yes.
My Lord, just to recapitulate, my Lord, the petitioners before Your Lordship, my Lord, along with the private respondent number 6, my Lord, they are partners of a partnership firm known as Hynix Logistics. My Lord, initially it was the petitioners. Thereafter that, my Lord, the private respondent number 6 was brought in. My Lord, subsequently, my Lord, all along, my Lord, the petitioners were the majority stakeholders in the partnership firm. My Lord, thereafter the differences arose between the partners. My Lord, as a result of which, my Lord, the respondent number 6, my Lord, had a grievance and we had a counter grievance with respect to that. Now, my Lord, those are ancillary facts. Now, my Lord, what resulted in my cause of action, my Lord, is this that, if Your Lordship may kindly have page number 55 of my application. My Lord, has it? My Lord, the private respondent number 6, my Lord, he files an application under section 9 of the Arbitration and Conciliation Act. If Your Lordship may kindly sees the cause title first, what he has mentioned in page 55 is that application for interim protection against the opposite parties, my Lord, those are the petitioners before Your Lordship, from operating the current account standing in the name of Hynix Logistics in ICICI Bank, Bidhannagar, Salt Lake, having account number so and so, as mentioned in the detailed schedule here under. But thereafter, his picture was given with regard to what was the reason for the dispute. And then Your Lordship may kindly takes up page number 59.
Yes.
But I'll just want to place the prayer portion since it will be of relevance. The prayer, what he has sought for in the said petition, which was filed.
Yes.
My Lord, has the prayer, my Lord, I'm placing. Hence, it is prayed that the learned court would be pleased to grant interim protection, thereby granting order of injunction against the opposite parties, restraining them from withdrawing any amounts from the account numbers so and so lying in the Bidhannagar Salt Lake branch ICICI and / or, if Your Lordship may kindly marks that portion, and / or any other bank accounts lying in the name of Messrs. Hynix Logistics without the signature of the petitioner till the commencement or conclusion of the arbitral proceedings. Right, my Lord?
Yes.
Thereafter that, Your Lordship may kindly takes up page number 53.
53.
53, my Lord.
Yes.
My Lord, Your Lordship, what he does with the said petition, my Lord, on the 2nd of May 2025, it was directed to be served. Thereafter that, on the 4th of September 2025, we find it is the order, my Lord, I just want to place it. Today is fixed for service return. Petitioner takes no steps and found absent on call. It appears from the record that the petitioner is not at all interested to proceed with the instant case further. It is already 3:45 p.m. and no further time can be given to so and so for show cause by the petitioner as to why case shall not be dismissed for non-compliance of court's order. My Lord, this is at this stage. Now, my Lord, what he could not do directly from the court, my Lord, he did it indirectly. My Lord, the two bank accounts of the ICICI branch, my Lord, which has been mentioned in the petition, along with the Axis Bank account, my Lord, which is the grievance, my Lord, for which I have approached Your Lordship, 3 bank accounts came to be frozen of the partnership firm when we attempted to withdraw the money. There was nothing which could be done. My Lord, page number 62, ICICI Bank writes to us that we have marked debit freeze of your account number so and so on the basis of complaint of fraud received from the third party, Dinesh Kumar Sagar Gupta, on 12th of September 2025. Lordship kindly marks the date because he did not appear on the 4th of September before the court. He made a complaint on the 12th of September and got my ICICI bank accounts frozen. My Lord, we gave a reply to that. My Lord, thereafter which the ICICI bank defreezed my accounts. Okay. However, my Lord, if Your Lordship may kindly takes up page number 66, the Axis Bank, my Lord, in spite of my notice, my Lord, indicating all these facts, my lord, did not defreeze the account.
Yes.
And my lord, this has resulted, my lord, the petitioners to approach your lordship's court.
Yes.
My lord, this was the simple issue, my lord, that today, when their court's order was not there.
Have you served the private?
Yes, my lord, I've already served. Matter was lastly taken up. My lord, your lordship's pleasure was is that to serve upon the Axis Bank so that they can give a report, failing which, if your lordship may kindly have your lordship's order also.
Yes. Yes.
My lord,
You
so
are
far
appearing,
as
madam?
I'm appearing for respondent number 4, Banking Ombudsman. They lodged a complaint with us, which your lordship will find at page number 64, which
Yes.
my learned friend has cursorily placed.
Yes.
So this was addressed on 11th October. Thereafter, there was an automated response given to the petitioner on 2nd of November, and follow-up was done, because normally when a complaint is lodged with Banking Ombudsman, it is followed up along with the
Bank.
concerned bankers, the regulated entities.
Correct.
Now here, when we followed it up, we got a response from ICICI Bank. However, with regard to Axis Bank, there has been no response. The response which we have received from ICICI, although that is not in dispute because they have also, yes, the accounts have been defreezed. But at least just for the sake of bringing it on record that what steps have been taken pursuant to the complaint, this is only to bring that.
But Axis Bank has not.
But
given
Axis
any-
Bank has till date not responded. So we are yet to close the complaint because we are yet to hear from them, and that is pending consideration. And in between, because they have come up in writ, naturally, whatever is the outcome of the writ, we shall abide by.
Yes.
At this stage, my lord, there is no application against the
State.
And
You're for the?
I am for the state.
The bank, Axis Bank is not coming with you, not coming to the court also. What?
My lord, paragraph number 8 of your lordship's order, my lord, the last order which has been passed on the 12th of November 2025, my lord, your lordship had said that it is made clear on the date fixed if Axis Bank failed to file the report, appropriate order may be passed, my lord. My lord, your lordship had indicated that also, my lord, which we had enclosed and served upon them. My lord, today, my lord, there is no,
Private respondent is also not coming.
no, my lord. But that he has not appeared before the arbitration court also, where he has filed the petition.
Now, whether there is any order pursuant to which there has been
No,
freezing of
there is no
account
freeze.
is not known to the bench.
There
at
is no,
least.
my lord, there's only one proceeding which is there. And my lord, there's no criminal case which has ever been registered. That the state would have then, my lord, indicated to your lordship. So in the absence of anything, my lord, they cannot have frozen my accounts merely on any complaint made by any partner. And especially, my lord, what he could not do directly before the courts of law, he's choosing to do it indirectly.
In which court the arbitration proceeding is there?
My lord, may kindly have page number 55.
Alipur.
Yes.
Alipur, you do one thing. You are the party to the petition.
Yes, my lord, I'm a party.
You do one thing. I am keeping on Monday.
Very well.
You check what is the stage of the arbitration, if there any stay or not.
My lord, next date is on the 26th of November.
26th of November.
Yes, it's as per the order.
That's right, 26th of November. I am fixing on 26th of November, no? So I am fixing on 28.
Very well.
28. You take if it is dismissed or if there is no order.
Yes.
Bring that. If there is no order, then the court will.
Then, my lord, your lordship may kindly also grants me a liberty to file a supplementary affidavit. Then, in that event.
In terms of the order passed by this court, dated 12th November 2025, the petition has served a notice to the Axis Bank, but in spite of receipt of the notice, none appears on the website. Learned Counsel, appearing for the respondent number
4, my lord.
4, submit that on receipt of the complaint from the petitioner, the respondent number 4 has initiated the proceeding and forwarded the matter to the concerned bank. The respondent number 4 received information from the ICICI Bank, wherein it is revealed that the ICICI Bank have already defreezed the account of the petitioner. See, further submitted, the Axis Bank has not submitted any report to the respondent.
Well, we can only, I'm just interrupting your lordship, my lord, because, my lord, the service has not been affected upon us, my lord, as of now, till date, in the, yes, just observe, very well.
With an affidavit or
Very well, my lord, we'll do that. We'll
think that there is no order by stay
Very well.
under section 9, then the court will proceed.
Deeply grateful, my lord, deeply, we'll do that.
This court finds that the private respondent has initiated a proceeding under section 9 before the learned court of before the learned district judge Alip. But from the order sheet, it reveals that though the private respondent has initiated a case under section 9, proceeding under section 9, but is not appearing before the court, learned court, and the matter is fixed on 26/11/2025. Accordingly, the case is set down till 28th of December 20.
26th of November.
26 is fixed. Then I am fixing on 1st of December.
Let
the matter appear on 1st of December 2025. The petition is directed to file affidavit only to the effect with regard to the stage of the case pending before the learned district judge Alipur under section 9 of the Arbitration Act, and to also to state whether there is an order of stay is passed by the learned.
If a time could be fixed, my lord.
Let the matter appear on 1st December at 12 noon.
Much better.
Same, I think.
Deeply.
Item number 28, I am appearing on behalf of the petitioner, Lordship. Lord, this is my affidavit of service. Lord, I am a government contractor and I completed my work within the due course of the day. It is of about 2021, Lordship. Thereafter, I submitted the bill to the authority, and thereafter the authority sat tight over the matter. That time, I filed a writ application. In that writ application, there was a direction to pass the resent order, whether the representation of the the order of that writ petition is annexed, starts from page 22, and the order is page 25, at page 25. May I place the order?
Executive Officer, Panchayat Samiti, consideration representation is strictly in accordance with law within a period of 8 weeks.
Yes, and thereafter a reasoned order was passed. And the reasoned order is annexed at page number 59 to 61. Reasoned order was passed on 4th March 2021.
69.
Kindly come to page
69.
No, I am coming, my lordship. Page
67.
There are several petitioner. I am referring the page 61, lordship. Page 61, 4/3/2021.
Yes.
The time period of 5 days has expired after extensive hearing of the petitioner and the official presence, and based on the documents as available in the office of the undersigned, has the prima facie reason to believe that the scheduled work were completed by the petitioner Sujoy Mondal. Hence, is ordered that Sujoy Mondal is eligible to get the payment after scheduled documents, after scheduled deduction, as mentioned in the NIT number 699/PS dated 3/7/2015 and NIT so and so and so and so. Thus, the representation made by the petitioner is considered. Therefore, the case was disposed of, and in terms of that honorable court's order, the reason order was passed, and the petitioner is eligible to get the payment. But till date, till now, the payment was not made. Whereas in the year 2024 at page 82, my lord, kindly come to page 82. On 12/9/2024, the Special Secretary, Department of Panchayat and Rural Development asked the Additional District Magistrate to disburse the payment of the petitioner, lordship. And my lord, I am pressing the relevant portion, the second paragraph. In this regard, the undersigned is directed to inform you to instruct the Bagda Panchayat Samiti to arrange the necessary payment to the petitioner from the State Finance Commission Fund or 15th Finance Commission United Grant Allotment or own resource immediately in compliance of the solemn orders of the Honorable High Court. Necessary procedural formalities are to be maintained in person. My lord, there are several representations. My lord,
You can say this is connected with you.
my lord,
That is connected with your case. How you can say?
well, a recent order was passed and therefore fund for scheme of Bagda Panchayat Samiti, but my lord, 15 and 16, and my work order is of 15 and 16, lordship. That is why this letter is relevant, my lord. My lord, kindly come to page 83, my lord. Thereafter, on 21st November 2024, the executive officer wrote a letter to the district panchayat officer. My lord, kindly, the relevant portion is the undersigned is directed to inform you that the Special Secretary of the Government of West Bengal Panchayat and Rural Development Department, Government of West Bengal, has instructed to inform Bagda Panchayat Samiti to arrange for necessary payment to the petitioner from their State Finance Fund or 15th Finance Commission.
Yes, the same as repeated. Then
Yes, lordship. Thereafter, kindly come to page 84. Page 84 is my representation dated 8th January 2025. And thereafter, kindly come to page 85, lordship.
Yes.
6/3/20, the letter dated 6/3/2025. The district panchayat rural development officer, the executive officer wrote the letter to the district panchayat rural development officer. My lord, kindly come to the second paragraph. On discussion of the matter in the meeting, it has come to the notice that the present PRI body of Bagda Panchayat Samiti is not willing to release the payment from the current allocation of fund as tender and work order of all the scheme of AAP have been issued of both SFC, that is SFC and 15th Finance Commission, first and second installment, and the work have been grounded for execution. In this context, it is requested to accord special fund to the Bagda Panchayat Samiti for release of this payment if possible, or issue administrative approval for including the scheme of AAP of 2025 as the current.
what has happened?
That is not that. Nothing is happened. My lord, kindly come to page 86, my lord. On 6/5/2025, the district panchayat officer wrote the letter to the executive officer, and kindly come to second paragraph, lordship, that you are requested to make necessary arrangement for payment to the petitioner from State Finance Fund or 15th Finance Commission United Grant Allocation or own resources immediately. My lord, that is my case, my lord. Till date,
Yes.
I have.
Yes, my lord. So far, my instruction is concerned. This is the
You will not
instruction.
pay them.
Yes, my lord.
Huh?
Yes, my lord. Matter is already fixed for hearing on Ato. Block Development Officer Bagda North West Bengal. He pleased to resign order that the given the hearing of the opportunity to their reasonable dated 7/5/2025 in respect of the particular issues.
My lord, after filing of that writ petition, that was happened, and I have participated in that hearing also.
Where is the written order?
That is
Perhaps no written reason order is being passed till date.
no, my lord. 22/7/2025. That is the order, my lord.
There is a direction upon the respondent number 10, the executive officer Bagda, to take step for consideration representation.
একটা report করে একটা দিন। টাকা দেবে না?
হিয়ারিং এ ডেকেছি।
Who is to release the amount?
My lord, Bagda Panchayat Samiti.
Yes, my lord.
My lord,
What
respondent
the
number.
block development officer has done?
Yes, my lord.
What the block development officer has done?
Everyone is directing the Panchayat Samiti, you please release the fund, but Panchayat Samiti is.
Yes, my lord. My lord, I have gone through.
There is already adjudication.
Yes, my
Yes.
lord, yes.
There is already
Adjudication.
Yes.
Then additional secretary is already passed an order,
Order, my lord.
Yes.
for release. So
Yes.
how this again they pass this order?
Yes.
Can I call this? Playing with the court's order?
No, my lord.
Then who is the authority
Bagda Panchayat Samiti.
for release of the payment?
My lord, respondent number 9 and 10. Sabhapati Bagda Panchayat Samiti and Executive Officer Bagda Panchayat Samiti.
No, to whom the direction was issued by the additional secretary?
Executive Officer Bagda. Additional Secretary direct the District Panchayat and Rural Development Officer.
82, page 82. Where is the page 82? Special Secretary to the Government of India.
Kindly come to page 82.
Yes, 82.
Yes. Special Secretary directed to the Additional District Magistrate to release the fund. District Magistrate directed the District Rural and Panchayat Officer to release the fund. And District Rural and Panchayat Officer directed the Executive Officer to release the fund. But Executive Officer sat tight with the matter. Executive Officer of Bagda Panchayat Samiti.
When the executive officer will be able to appear before this court? Tell me, I am fixing a date as per your convenient, or you go, I am passing out over for the 10 minutes to go talk with this executive officer, take the time when he will available here.
Yes, ma'am.
Come after 10 minutes. Take a call. When he will avail before this court in person. No hanky panky.
No, my lord. No.
Pass over. Yes, call the next matter.
Item number. For the petitioner, my lord. Or prayer for removal of the electric meter installed by violating the order of the learned executive magistrate Egra in the district of Purva Midnapur.
This is report from the state, not.
Arrest the private respondent.
I am the private respondent.
So you want your arrest?
Yes. Only that in the respondent number 7 is
What is the
required
prayer?
here.
What is the prayer?
Prayer for removal of the electric meter installed by violating the order of the learned executive magistrate Egra Purva Medinipur. For a fact of the case,
Yes.
my lord, since 1971, my lord, petitioner has been possessing a piece of land situated at plot number 4 of Mauja, Khatian number 1/11/2 of Mauja Chowk Bishu, under Potaspur Police Station in the district of Purva Medinipur. My lord, after constructing a dwelling house there, and in the said, my lord, at plot number 4, in the front side there is a plot number 3. Some portion of the plot number 3 has been vested in the year 1971. And before that, my clients, or that the petitioners herein have been possessing this said land. as used as its ingress and egress, as there is no other road or way to go to the main road. And several government came in the meantime, they did not acquire the said land. After that, the petitioners made application to the DL and LRO for the settlement of the said land. For the settlement of the said portion of this vested land to be as settled in their favor. My lord.
So
On
what is your prayer before this
prayer
court?
before is, my lord, I'm coming to this point. My lord, on the 10th June 2025, respondent number 9 to 14, 9 to my lord, 9 to 14, along with some other antisocials and others, forcibly enter into the land of the vested land and took possession of the said land.
Correct.
And after 2 or 3 days, they constructed a tin shed room there.
Correct.
There. And my lord, in the meantime, petitioner lodged a complaint before the Potaspur police station.
Correct.
As the police authority has not taken any steps, your petitioner filed an application under section 163 BNSS before the learned executive magistrate EGRA. And my lord, that is on the same day an order was passed, and learned executive magistrate, my lord, restrained the police, or directed the police authority
Where
to
is the
maintain
order?
the peace. Order, my lord, that is page number.
Where is the order?
My lord, that is page number 51. Page number 51, annexure P6. Whereas, my lord, I am reading this said order. My lord, consider BL and LRO Potaspur 2 is directed to inquire into the matter and send a report with sketch map to this court. Officer in charge Potaspur police station is directed.
Who has written this letter? Page 51? Page 51.
Page 51.
P7.
No, P6, my lord.
No, page 51 is something else here.
But that is executive magistrate order.
No, there is a representation.
And this case number 435 of 2020.
My lord, that is
this case number 435.
435.
It's a representation.
Oh,
51 is a representation. Which case is this? What is your name? Tapan Mehti?
Yes.
Yes, then
Oh, representation there.
it is a representation.
The page number,
Where is the order?
page number 7 or page number 6?
Yes, 50, page 50.
Page 50.
OP is directed not to demolish the fiscal
And
possession
thereafter,
of-
my lord, and thereafter the next page is the order. Next page is the order.
No, there is no such order, only one page. Page 50 is the order.
Page 50 is the order.
Yes.
Yes, sir.
Officer in charge police station director inquiry into the matter report.
Report.
Then the OP is directed not to disturb the
Peaceful possession
of the
petitioner of the against the shoot land, and OC Potaspur
Directed to
is
maintain
directed to
defense.
maintain peace over the
Correct.
issue.
Correct.
On 27th June 2025, the electricity department came and installed an electric meter, and that the electric meter was installed
Electric meter of in whose premises?
my premises.
In your
Yes,
premises.
my lord, plot number 4.
Ah.
But the antisocials, my lord, acquired plot number 3 some portion. And but the electric respondent number 7 here, the assistant engineer and station manager.
Who is appearing for the respondent number
That
7?
is my respondent number 7 hearing.
Who is appearing? Assistant engineer.
And his men came.
Have you served the notice?
Yes, my lord, I have
Where is
served.
the affidavit
Oh, this
of
is
service?
affidavit of service.
Where is your affidavit of service?
Only Karuna.
We are the owner of in respect of the plot.
Let
number
the
3.
report be come from the electricity department where the meter has been fitted. Let it come. It will be clear.
Yes. Yes.
But your lordship has asked him this very pertinent question. Your lordship come to him with the prayer portion. Kindly him not come.
I have gone through the prayer one.
No, my lord. It was first filed before the
Prayer
only, my lord, to arrest the persons. Thereafter, my lord, the
And another thing, my lord, the writ petition, my lord, again file a writ petition which is pending in this court, my lord.
What petitioner?
The police election. WPA 22949 of 2000.
My lord, it was fast moved before his lordship. Honorable
Kindly
Chief
come
of-
to the prayer.
Yes, my lord.
How this writ petition be before?
My lord, it was released or my lord transferred by his lordship, Honorable Justice Chittankar Ghosh, my lord. That is the earlier order, my lord. That is order dated.
Where is the removal of the electric meter? Commanding Raswana already installed in the state room, validating the order.
Yes, my lord, that is.
Remove. Yes, prayer C.
-2. My lord, that is prayer C. A writ in the nature of mandamus commanding the respondent number 7 to remove the meter already installed in the tin shed room by violating the order by the learned SDEM, Subdivisional Executive Magistrate. Agra. My lord, it was first
that
moved
is a
before
violation of
lordship,
the order of the executive magistrate.
but
No,
violate.
No, but the justice
Yes.
Ghosh has released on
Release the
that
matter
only
before your lordship.
As yes, my lord.
I'm not.
only on the prayer of C.
Yes,
Prayer
yes.
C.
Prayer C is here.
Prayer C.
C here.
Nothing else.
Multiple player.
Multiple prayer. I can be done. So, but your where is the CSC or
My lord,
WSC?
I have served notice, review service is filed, my lord.
Okay, I am fixing a date.
Yes, ma'am.
Asking them to submit the report. If they will not submit the report, I will dismiss your writ application.
Yes.
The court cannot.
Yes.
Go into
My report be kept
I
on
will
record.
take, I will take your report.
Yes.
This court
Civil in nature, দুজনের মধ্যে।
find that a report is required to be filed by
That writ petition may be taken up by your lordship. Your lordship kindly.
which writ petition?
WPA number double.
Another writ petition filed by.
What writ petition you have filed?
No.
Any other writ petition?
No.
Here,
This is the
this
number.
is the same manner advocate never change.
Tapon Maiti and other advocate is changed, but petition.
Okay,
Ghulam Mustafa.
Golam?
this court find that
My lord, I have no knowledge about it, my lord.
only obtain
But
report.
kindly call for these records.
Please.
Number of
Find
these
the
are
report
kagoj
number 7, that is the assistant engineer and station manager, Pataspur Customer Care Center, SDCL, Pratap Dighi, District Program Midnipur. Though the petition served the notice, but in spite of service of notice, none appears on behalf of the respondent number 7. Accordingly, the respondent number 7 is directed to submit report to the effect, submit report to the effect on whose request the meter connection is provided and whose name the meter connection, on whose request and on whose name and in which plot the meter is provided, and whether the premises where the petition is residing, the said premises is being affected with the meter connection provided by it.
Double two.
Let the report be filed within 2 weeks from the date of receipt of this order.
949 of 20.
The state respondent has filed the report. Let the same be kept with the report. The petitioner, it is informed to this court by the private respondent that the petitioner has also filed another. What is the prayer in that? Which group? You're sure? Has also filed another writ application being WPA number? WPA number. Give the WPA number 22949 of 2025. Let the said writ petition be placed along with the present writ application on the next date fixed. Please the matter on 10th of December 2025. The petition is directed to communicate this order to the respondent number 7 and to file the affidavit of service on the next date fixed.
To read petition has been tagged, my lord.
Yes, tagged.
But date may be fixed.
10th December. And you serve the copy to the respondent number 7.
7 again. Again.
Yes.
Yes.
I have given them back.
Yes.
Thank you.
Thank you.
उसमें एक पेपर चला गया वो नहीं सिंगल पेपर yes call the next matter.
My lord, prayer, my lord. My lord, since the matter is, my lord, covered by the division bench judgment, my lord, I seek your lordship leave to move that matter may be moved by my landed junior man.
I appear for the respondent number 1 to 3. In the principal respondents.
What is the prayer?
My lord, registration of deed, registration and execution of deed, my lord.
Registration and execution of sale deed.
Yes, my lord. My lord, the fact is that my lord, respondent authorities KMD, Kolkata Municipal Development Authority, my lord, Metropolitan Development Authorities, my lord, initiated a project, my lord, that is South End Conclave, popularly known as Kosba New Market, where the petitioners, my lord, applied for shop rooms and car parking and garages, lord, carriage place. But my lord, my lord, the petitioners have already paid the amount as full consideration amount as directed by the KMDA. But till now, my lord, KMDA has not executed the deed and registered the deed, my lord. And yes, my lord. And some of the shop owners, my lord, has earlier initiated a writ petition, my lord, against which KMDA has preferred an appeal, in which, my lord, may I hand over? But the fact is same, my lord, that initially the applicant, namely Kolkata Metropolitan Development Authority, agreed to sell and or transfer the property in question, including car parking spaces, as mentioned at page 146 and 147 of the stay application, to the respondent number 1 writ petitioner, namely MFAR Constructions Private Limited, and for a consideration price agreed between the parties. Pursuant to such agreement, the entire consideration price for transfer of the property in question was paid by the respondent number 1 petitioner to the appellant herein. Appellant is KMDA, my lord. However, the KMDA authority, the appellant number 1, could not transfer the property in question in favor of the respondent number 1 writ petitioner, as it was subsequently discovered by the said authority that it had no title in the property in question. Now, my lord, next page, my lord, last paragraph. The Kolkata Metropolitan Development Authority is thus directed to execute and register the deed of lease in favor of the respondent number 1 writ petitioner, accordingly positively within 6 weeks, upon compliance of all necessary formalities which are required to be completed by the respondent number 1 writ petitioner, my lord. And my lord, as per this order, my lord, KMDA has also registered a deed of, executed and registered a deed of lease to the writ petitioner of, yes, my lord, and that lease is for 99 years, and subsequently with renewal clause of 99 years, my lord.
I don't have any objection. If the petitioner, in fact, the petitioner, if your lordship sees paragraph 26 to 28, that is not matching with the prayer made, although they averred and made submission in that regard. This refers to the decision just now my learned friend has said. Here,
yes,
my lord, here this case, which is referred to by my learned friend, there the same with the same grievance sound. This petitioner had approached this honorable. The honorable single bench directed us to execute a deed of conveyance. That is the spirit. We preferred an appeal. And before the division bench, the matter was heard and this order was passed, whereby the KMDA was permitted to execute the lease deed in favor of the writ petitioner respondents. Now this petitioner wants relief in the light of this order. My lord, why we were unable to execute? There are two reasons. My lord has seen that my learned friend has read that the land in question where the market complex is constructed, which could be detected by us a much later, my lord, that the state didn't grant freehold title in our favor. That is the one difficulty for us to, my lord, execute deed of conveyance, the sale deed. And another is, in December 2012, the government introduced a land policy, whereby the government and its parastatals were directed to, my lord, allot only grant lease to allot on lease on basis for 99 years with an option for renewal of like period. That is 99 plus 90. And being, my lord, a parastatal of the state government, we are under the administrative control of the state, particularly the Urban Development and Municipal Affairs Department. We are
Now, what is the contention? What is your contention? Whether at this stage you are able to.
We are agreeable to execute lease in favor of.
Can I record your submission?
Yes, yes. My lord may record that we are agreeable to execute lease deed in the standard format, which we are executing in favor of many of the persons who will be executing. Following the, my lord, the policy of the government, that is 26 December 2012. If the petitioner is agreeable to accept, my lord, we are ready to accept.
Yes, my lord. I am agree.
For 99 years, initially for 99 years, with an option for renewal of like period.
You come with the written instruction.
My lord, written
instruction. Have a written instruction?
Instruction I have for myself, my lord. My lord has seen. My lord need not read the entire paragraph. And from this page, the later portion referring to paragraph 26 and 28, my lord may see the stand of the case. Here one resolution is referred to, which was relating to this issue. That since the KMDA doesn't have the real title, how it can confer a better title than it does.
Yes.
This apart. One thing, if your lordship sees page 22 and 24, even that was perhaps not even intended to by the authority. If your lordship just
And how you maintain the writ petition? 3 petition, 3 stops. How you maintain the single writ petition?
There are three petitioners.
Then how much amount you have paid of the writ
My lord,
petition?
I undertake to pay.
I undertake.
How much amount you have paid with regard to the writ petition?
I undertake to pay.
Yeah,
We undertake.
My lord, I will undertake to
You
pay.
pay the amount, then you come.
My lord.
One writ petition payment, you cannot take the order of 3 writ petitioners, sir.
My lord.
Then
If they undertake.
file you pay. How many times? I will fix the next week.
My lord, I will pay tomorrow, my lord.
Day after tomorrow.
Day after tomorrow, my lord, I will.
Day after tomorrow, madam.
Day after tomorrow. My lord, let the matter be taken up on day after tomorrow as per your lordship's convenience.
It is fine that in the present writ application, there are altogether 3 writ petitioners, and all 3 writ petitioners have paid for a direction for registration of conveyance deed. But this court find that only one petitioner has paid the required court fee in the writ petition. Counsel for the petitioner submit that undertake that he will pay for the other through writ petitions. According case is adjourned, let the matter appear on 2nd December 2020. Come on 2nd December.
2nd December.
2nd December.
My lord, may I take back my instruction? I will get a Xerox copy
And if you take the exact instruction, that will be better for you. You take the yes, call Paswa matter.
Deeply obliged.
Paswa.
But I am for petition, lordship. This is affidavit service.
Paswa.
Oh, Paswa.
Yes, my
Yes.
lord, I will several attempts.
Huh?
28.
20.
Let he appear before this court. Let he appear before this court. This court finds that initially the petitioner has filed the writ application before this court, and by an order dated 21st of January 2021, this court has disposed of the writ application by directing the executive officer of Bagda Panchayat Samiti to take steps for consideration of the representation of the petitioner strictly in accordance with law within a period of 8 weeks from the date of communication of the order. Police. In compliance of the order passed by this court, the executive officer by an order dated 4th of March 2021 has passed an order holding that the petitioner is eligible to get his payment after scheduled deductions as mentioned in NIT number 699/PS dated 3rd July 2015 and NIT number 200/PS dated 19th February 2016. Even holding that the petitioner is entitled to get the payment, but the executive officer has not released the payment. Subsequently, on receipt of the representation of the petitioner, the special secretary to the government of West Bengal by a communication dated 12th of September 2024 directed the Bagda Panchayat Samiti to arrange for necessary payment to the petitioner from the State Finance Commission Fund or Fifth Finance Commission United grant allotments or own resources immediately. In spite of several directions passed by the competent authority, the amount has not yet been released. Again, the district panchayat and rural development officer has passed an order directing the executive officer on 6th of May 2025 to comply with the order of the Special Secretary to the Government of West Bengal, Panchayat and Rural Development, Government, and to submit an action taken report immediately. In spite of several directions passed by the concerned authorities to the executive officer, till date the executive officer has not released the payment to the petitioner. According to this court has directed the learned advocate appearing for the state to consult with the executive officer and to ascertain when he will be available to appear before this court. But the learned advocate informed that in spite of several calls, he is not available. According, this court has no other alternative but to direct the executive officer, Bagda, executive officer,
Bagda Panchayat Samiti.
respondent number.
Respondent number 9 and 10.
He is not.
10 is executive officer.
Bagda
9 is
Panchayat
Bagda
Samiti,
Panchayat.
Bagda. Executive officer, Bagda Panchayat Samiti, Bagda, the respondent number 10.
10.
To appear before this court in person on 2nd December 2nd December, 19, on 25th of November 2025 at 11 a.m. and to explain why the payment has not been released. Let the matter appear on 25th at 11.
But later time may be fixed.
You are not heard the order. The petitioner is directed to communicate this order. The petition is directed to communicate this order to the executive officer for compliance. Next.
Grateful.
31 I am for petition, Lordship. This is evidence of service, Lordship.
Yes.
The 5th October, my lord, 2020, the petitioner came to know his cousin brother expired.
Yes.
His cousin brother expired. Thereafter, my lord, police came to recover the dead body of the room and sent for postmortem and start a UD case. In the postmortem report, page 12, my lord, this is hanged. But date of death is not correct, not exact. Kindly see top portion of the my lord.
For which the death certificate cannot be issued. After going through all the formalities and taking the opinion from the postmortem doctor, we have come to a conclusion. Our date, you know, kindly consider the report. Next page is 1st October 2020. If this date can be recorded for the all purpose.
Page.
Second page, your lordship.
Page number.
Last second page, your lordship. Fourth paragraph.
Page number.
Second page. Page
On
number.
a report, bolo.
Report. Second page.
Report.
Yes, your lordship. Second page, last fourth line.
This may be recorded for all the practical purpose. In the particular case, deviation felt if any may establish through the meticulous investigation and the written reply Dr. General recent report has duly been handed over to Rajidas and received the copy. Where is the report? What report you have given?
Report.
The date of this can be recorded.
Date was 1st October 20.
For all recording purposes. It is opened from the postmortem.
That is my pair.
That is the grievance.
My pair A, that is considered. Kindly see my pair A.
For this purpose, the person has to come to the writ court. What the authority is doing, sir? With that person, for the purpose of death certificate, if person has to come to under 226, it is very sad affairs of the state. But it is benefit for the lawyer.
Yes.
We have time to time
I made several representations.
to all the concerned authorities from time to time. And at last, we have received this from the
Record.
Yes.
The grievance of the petitioner before this in the presented application that
No, one copy no.
In the postmortem
1st
report
October
of the
was-
son of the petitioner,
No, my lord, he's my cousin brother.
cousin brother of the petitioner. No exact date has been mentioned, and as such, the concerned authorities are not in a position to issue the death certificate of the cousin brother of the petitioner, who alleged to have passed away by hanging.
My lord, hanging.
By hanging.
Page 12, my lord.
By hanging.
Postmortem report, page 12. Top, my lord.
The state respondent has filed the report and submits that that as per the report of Dr. Chittaranjan Bhattacharya, the death of Mr. Arpan Das, son of Pradeep Kumar Das, aged about 32 years, could have been occurred on 4-6 days prior to holding the postmortem examination. That is in between 30th September 2020 to 2nd October 2020. And accordingly, the doctor has opined that the date of death may be taken as 1st of October 2020. Consider the report submitted by the authority wherein the doctor has opined that the date of death may be taken into consideration at 1st of October 2020. In view of the above, who is the authority to give the birth certificate?
My lord,
death certificate.
2, 3, and 4.
Medical officer. Who is issuing the death certificate?
Municipal.
Delhi municipality.
Yes.
You
Respondent number 7.
You will issue. So I am passing direction upon you.
Considering that the first.
About the respondent number 7, the administrator Bali municipality office at Bali is directed to issue death certificate of the deceased Arpan Das, son of Pradeep Kumar Das, by showing the date of death as 1st October 2020 in terms of the report of the Dr. Chittaranjan Bhattacharya. The respondent number 7 is directed to issue the death certificate of the deceased to the petitioner within a period of 2 weeks from the date of receipt of the sum.
Grateful. Can I direct to copy of the report?
Yes, copy of the report. The state respondent is directed to circulate the copy of the report to the respondent number 7 as well as the counsel for the petition.
My lord, grateful, my lord. আচ্ছা আমি জেরক্স করে আপনাকে দিচ্ছি আপনাকে দিচ্ছি গ্রেটফুল my lord.
Yes.
Madam, I'm for the petition, madam.
I am for the respondent number 5.
My lord, there is a.
One point regarding the.
My lord, fact is that.
Mentality.
My lord,
Neither the cause of any cause of action is there. Neither the writ petitioner has any locus to move this court. But these are the two preliminary objections. My lord, let him put.
My lord, there is allegation against the respondent number 5, the West Bengal Council of Yoga and Naturopathy, that they are giving illegal registration to the practitioners of yoga and naturopathy, and for that 24 numbers of registration has been cancelled, challenging the 19 individuals.
you?
My lord, I am the owner of a, my lord, Yoga and Naturopathy Institute. And my lord, paragraph 2 and paragraph, my lord, 10, I have stated that I am interested person because, my lord, as the director of the Yoga Institute, my lord, the registration is very much important thing, because those registered persons, as per paragraph 10, my lord, subsequently come, that the yoga and naturopathy treatment is considered as an alternative medicine treatment, and on the basis of registration granted by the respondent of 5, a person acquires right to give treatment to general people. If the person is not qualified to treat the patient, there is
Keeping the mentality open, you file affidavit.
Affidavit or a short
Because
report.
it is
as
required
far-
affidavit.
On that point, but my lord, on the point itself, my lord, because in the earlier writ petition, there is a direction. There are series of writ petitions. There is a series petition and my lord, in the earlier writ petition, there is a direction that the reason order is being published, my lord. The reason order is there, my lord. Kindly come to that reason order.
Round of litigation was there.
Yes, yes.
So now how you are challenging the maintainability?
There is a public interest litigation which is pending by one of the doctors. There are two writ petitions which have been disposed.
Okay, you do one thing, if it is pending as a public rental litigation before the division bench, I will refer the matter to the chief justice, let the matter, all the matter be together.
This matter that can be
But
done.
avoid the complete decision.
But he does not be locus. At best, this could be a public
If
interest
the
litigation.
similar matter is pending before the division bench as a public interest litigation, let this matter be tagged with the.
But that their point is different. Here point is different. Of the same institute.
So okay,
same-
how
but-
soon you will file the reply affidavit?
2 weeks.
2 weeks.
I'll file a short report, my lord.
The you are appearing for respondent number?
5.
What about the other respondents?
They are state respondents.
State?
my lord. They are state respondents.
They are not appearing. Have you served?
Yes, yes. I've served, my lord. I'm appearing for the council.
Served?
Yes.
Delivered?
Yes, yes. Because respondent number 5 is the main respondent. He is giving
Affidavit of
authority.
service filed by the petition be kept with the record. None appears on behalf of the state of respondent. Comma. Counsel for the respondent number 7.
No, 5. 5.
Respondent number 5. Praise for time to file affidavit in opposition. Let affidavit in opposition filed within 2 weeks. Reply if any there to be filed within a week thereafter. Please the matter on 16th December. 16 December.
Plus Item 50 is also same. If my lord.
Item
50 is also.
50.
Same directions may be given.
Okay, no problem.
Same party.
Same party.
Same writ petition.
Record the same 50 or
Prayers are different. Prayers are different. আমি তো affidavit এ দেবো। 50
50 also.
I-
huh?
দেখুন,
Yes.
প্রসঙ্গিক চক্র। Yes, yes.
Lord,
That's
subject to Lordship's kind sanction, may I submit one thing. 33, 34 and 39, 40. My Lord, due to my personal difficulty, my Lord, because my daughter's exam.
Monday,
no, my Lord.
My lords, I am in item 50, my
26.
lords. Item 50 has been called upon.
26, I'm
26.
26. Let there be a note to that effect in the list, my Lord, only 26. Up to
Item number
33, 34
33, record on 33, 34
and 39, 40
39
and 40.
39, 40. Put on 20.
My Lord, let there be a note to that effect.
My
Let there
lords,
be a
Fix
26. Let there be a
26
note to
November.
that effect in the list. ठीक है?
Give the number. You give the name.
I'm grateful.
item 50 has also been called upon, my lords. It is. My lords, item number 50 was called upon.
50 already direction is passed. You give the name and it will be recorded.
35 ডাক হয়নি তো?
You are appearing for
My lords,
whom?
my lords, I am for the council petitioner. My lords, item number 50 is a different matter, my lords. It relates to the freezing of bank account by the
50.
by
They are
the
telling
bank.
us. Yes.
Bank account. No, he's the petitioner. 50 is against that council also. No, bank account এর কথা বলছো না তোমরা? তুমি তো petitioner.
What is the name of your petitioner? Yes.
But original side, may I be permitted to mention one matter for playing for your lordship? Need to draw up and complete the.
Huh? And what is the date of judgment?
10th of this month, but I have delay for 1 day. এটা একটু deeply.
Yes, I am for the plaintiff. I am appealing for the defendant of 2 and 3.
But I'll be Milad as brief as possible and try to complete. Milad.
I think it will be the verge of completion.
Yes, yes, yes.
So many notes.
By this time, I would have completed if Malad would have been at code number 38. Milad, I just recapitulate. Milad, I started with Milad, Mr. Arpit Khunteta's Milad deposition.
Yes.
Milad, I also Milad showed Milad, it's only pointed out by your lordship only that Milad, the authority that he had showed, Milad has not been proved. It is still now identified to be identified for identification. So Milad, in the eye of law, there is no evidence on behalf of Milad Arpit Khunteta. Milad number 2, Milad, I have relied on a judgment. Perhaps it's there, Milad, in my law's record. Milad, where Milad, I have Milad 2024 6 SCC 130. আচ্ছা তো ব্যাস ঠিক আছে Milad, this is that if a power of attorney holder can only give evidence to his personal knowledge. Milad, Myloli recollect Arpit Khunteta said he has joined in 2018. The suit is of 2014. So he has said that I have joined in 2018. So anyway, he has no personal knowledge. So his judgments comes in.
Paragraph 28.
Yes. Milad, now Milad, I have Milad taken Milad to your lordship Milad the evidence of Milad Mr. Ekka, the last witness of Milad, the for the defendant. Now Milad, Myloli recollect, it was Mylord specific and pointed question to Mr. Ekka that whether your authors who had written the letters are still in service. This is the last question of the suit from your lordship. Milad, if Milad only just point out to your lordship, Milad, this is question number, yes, 62 to D2, DW2. Question number 62 to the court. 62 of 28th November 2024.
Yes. Do you know whether?
He said yes, they are in service.
Yes.
Now Milad, also Milad, kindly note, Milad, I had put Milad a question. Milad, kindly takes question number 53 to Mr. Ekka, that have you disclosed any document before this court to show that you were employed at Jharsuguda division with railways from 2009 to 2014? He said no.
Question number
53. Just the page Milad before that. 53.
Have you discussed any document?
Yes.
Yes.
He said no. Number 2. Number 3, Milad will kindly take question number 47, just Milad at the same page. Under which power did the deputy engineer have the authority to authorize you to depose with this code? There might be some railway board order. Then I referred question number 48, that according to is this Mr. Khunteta's that notification of 1993? He said yes. So Milad, if Milad has not accepted Mr. Khunteta's authority, so Milad, he again relies back on Milad the same authority. So Milad, he is again Milad hit by this judgment of 2024. Because Milad, more so Milad, in this case Milad, the authors are still in service. And Milad, they are avoiding the court.
Yes.
Now Milad, on this note Milad, I had concluded on that day. Now Milad, kindly see, Milad, Myloli recollect, just make a note. Milad, one of the issues was that Milad, many of our documents were Milad a photocopy. Now Milad, we had Milad lodged a FIR, Milad complaint. Sorry, Milad lodged a complaint. Now the Milad, my witness PW1 had Milad categorically deposed before the lordship's court. Milad, kindly note Milad question number 24 to 24, 25, 26, 27.
PW1.
PW1.
Question
24, 25, 26, 27 before the commissioner. And 97, 98, 99. And Milad, the regarding Milad, the complaint there lost and the complaint lodged. And for that reason, we are relying for some documents on the photocopy. So Milad, 24 to 27, 97 to 99.
Yes.
Now, my lord kindly marks by the side, my lord exhibit G, that complaint. Now, my lord, in various the documents which we had to rely on a copy because originals were with the railways. We had given notice to produce to them, but till date not produced. Few of such questions. Otherwise, there will be 2 pages of note on that only in every question. 113 to 120 of PW1 and 156. 13 to 120. 13 113.
120.
To 120 and 156. Let few of such questions. Will find a galore against every question. Then, Millard.
This is with regard to the
notice to produce, not produced by the defendant.
Yes.
Now, Millard, the point, Millard, which Millard last remains to be argued before the Lordship is that Millard, the issue of impossibility, Section 56 of Contract Act. Now, Millard, if I'm not wrong, Millard, I had handed over Millard issue-wise this one, Millard, evidence analysis to a Lordship's, Millard, if Millard it has. I have segregated head of the issues, Millard, the question and answers. I thought extra আছে আমারটা কোথায় গেল আচ্ছা এটা দিন Millard, it's mark that I'll make a fresh copy. Now, Millard, I've shown this to your Lordship. Millard kindly takes 2, 5 and 3 and 4 is mainly on Millard section 56. Page 3.
Yes.
3 and Millard issue 3 and 4. Whether the design, drawings, and work methodology approved by the defendant number 2 on the basis of the subsoil explanation report GAD made over by the defendant number 2 ultimately frustrated the contract and rendered it impossible of performance.
Yes.
Issue number 3. Issue number 4 is if the answer to the previous issue be negative, whether supervening and intervening circumstances, including the work methodology approved by defendant number 2, render the contract unworkable and unfeasible in terms of the contract conditions. Now, Millard, perhaps my lord had marked in my lord that copy exhibit Q, NN, CC. My lord to mark it again. Right. Q, NN, CC. These are the correspondences. Q, NN, CC, BB, DD, S, O, GG, KK, LL, OO, W. 3 টা কি 3 exhibit 3 টা ওদের and Millard defendants exhibit 3. Only 3.
Yes.
Well, these are the on Millard section 56.
Yes.
Now, Millard, additionally, will kindly take Millard PW1's Millard cross examination question number 239. Millard kindly add that. Millard, I think that's written by hand. 239, 240.
Yes.
253, 262, 263, 264. Now, Millard, those are very important, Millard. If I just read 1 or 2, Millard, take your lordship to that, Millard. Not bother your lordship with the others, Millard. I'll file a note on that. Kindly takes Millard the evidence of PW1 cross-examination dated 4/8/2022 before the commissioner.
Question number?
Question number 253. Page 3 of that day's.
Yes.
Can you this in cross? Can you specify that which part of the agreement the railway did not abide by the terms and conditions specified in the agreement? To start with, the railways failed to inform us about the hostile law and order situation which prevailed at the bridge site, that should be site, S-I-T-E, that becomes D, which was a territory under the jurisdiction of the railways. Further, the tender document and the agreement oblige us to make soil investigation before we submit our design for the foundations and other structures. The agreement document also specified the foundation to be undertaken by well foundation methodology. Subsequent to our signing of the agreement and before we could mobilize independent agency, the railways handed over soil investigation report from their chosen agency and instructed us to follow the same and prepare our design based on the said soil investigation report. The railways who had framed the tender document and had specified the execution methodology for the foundations were aware that the well foundations may not be the correct method of making the foundation immediately after signing off the agreement. The railways handed over the soil investigation report done by their own agency and denied us the opportunity to prepare the design or to bring forward to the railways the incorrect and erroneous choice of stipulation well foundation, has denied us in a fraudulent manner and also deleted the BOQ item under which we were to carry out our independent soil investigation and ascertain the strata of the riverbed. During the execution stage at various occasions, we had brought to the attention of the railways that we are unable to progress due to the rocky strata as well as is not sinking, but the railways completely overlooked our submission. After repeated difficulty and observing the impossibility, the railways themselves suggested that we undertake one foundation so that the progress can be reviewed. However, just to push us further into impossible work situation, the railways instructed us to carry out other well foundation also. After almost working for 3 years, the impossibility of the work became known to both the parties. All our requests and submissions to railway authorities to find a solution were ignored. Finally, the railways terminated the contract and called for another tender in which the method of work was changed from well foundation to pile foundation. The value of the new tender was almost double to the value of our contract. These are very relevant. The change of work methodology proves that the railway were well aware that the methodology as provided in our contract was not correct, and in a fraudulent manner, knowing well of the technical impossibilities, the railways forced us to pursue on a faulty methodology, causing financial loss to us. Then, Millard, kindly mark, I will not take much time for lordships. The next questions, Millard, 260 to 239 to 241, Millard and mark 253, 262, 263, 264 in the same line. Now, my will kindly, Millard, take exhibit KK, Millard volume 7. Just have a look once. এই পাতলা একদম বা আমি আমার থেকেও দিতে পারি Now, Millard will recollect, Millard, while Millard, my learned senior was submitting, Millard, there has been a consistent stand maintained that they have not written to us for his soil investigation, they have not challenged. Now, my lord, in light of that, kindly takes Millard exhibit KK, volume 7, page 1668.
Yes.
Kindly mark the date 9/10/2012.
Yes.
Kindly see the subject. Subject soil investigation.
Yes.
Now, Millard, pair-wise, Millard, difficulties are being given. Pair-wise.
Yes.
So, Millard, kindly takes Millard 1669. Last paragraph. I am not, Millard, bothering your lordship with the entire content. We therefore propose that the soil investigation may be redone, laid on our practical experience so that founding level, rock level may be re-evaluated. In light of this, we requested you for reassessment of rock strata, their property parameter for fixing the founding level and rock level. So, my request made, not adhered to.
So you have made, this is your application.
This is my request.
Correct.
This is my letter.
Correct.
Millard, at the top we will find Rahi GPT JV.
Yes.
Now, Millard, along with this, Milad, with the impossibility on the count Milad heading of impossibility, my lord will also find Milad kindly takes Milad turns the page. Milad there were insurgency and antisocial activities. Now Milad kindly takes Milad 27 November 2012. Page number 1, Milad next page only.
With regard to the 168,
This is with regard to resoil investigation. Under the Milad of Milad impossibility. That was not Milad allowed. Now Milad my another head under the same heading, basically sub Milad subheading. Milad is that Milad another reason for the impossibility was Milad the activities illegality antisocial activity that was being carried out, which Milad basically resisted us from carrying out our work, and we have put this Milad brought this to the railways notice. Milad turns the page to 1670.
Yes.
Exhibit MM.
Yes.
Stop of work due to Milad kindly marks the date 27 November 2012.
Yes.
Stop of work due to agitation by anti-socials against the contract agreement. Milad, that the resentment of the local Milad, now Milad, this is one. Now Milad kindly turns the page to
What is the percentage of work you have executed?
Milad, to my Milad instructions, Milad nearly 60 to varies between 60 to 70%. For 30% balance work, Milad another Milad number second tender was floated. Milad, yes, doubling the amount. Milad the methodology was not changed in the second one. It was the well foundation. No tenderer came forward. Now Milad third tender
Then change the place.
150% increase with Milad blasting cost. Milad then Milad only for balance work 150% increase of the entire Milad my tender amount. Naturally, for blasting it becomes Milad huge difference. Now Milad also see marks Milad kindly comes to Milad, sorry Milad, it is prior page 1657 exhibit HH. Milad kindly see we have written to them that blasting is required.
Yes.
Kindly see serial number 2 and 3. Well, I am reading 3 for your lordship. Since the rock stratum is found very hard. Well, kindly mark the date, yes. 26 September 2012. The progress in underwater blasting and sinking process also got slowed down due to very little output despite blasting was done several times. Now, Milad, therefore, even the weather plate spoil spot, Milad, that is written. Now, Milad, kindly see, kindly turns the page. Then, Milad, request for extension of time. So, Milad, they were aware of the situation. They were aware that, Milad, I have been asking Milad for the re-evaluation of the soil.
Yes.
Now, এটা কত এগুলি এটা একটু এক্সিবিটটা বলো তো জি I mean the next defendant document. Milad kindly also mark Milad defendant document 11. Sorry. Achha, very good. Milad, I'll come back to that. Now, Milad, the next issue is of Milad the expenditure. Milad, prior to that, Malu recollect Milad, while we started off, Milad, one expert witness has come, Milad, Mr. Pradeep Mukherjee. Now, Milad, his entire evidence has gone on the hard rock strata. So, Milad kindly marks, Milad, his entire evidence of Mr. Pradeep Mukherjee, PW2. হ্যাঁ, question number 9 Millard will take Millard same Millard the analysis of evidence. Once again Millard same page, PW2 Pradeep Kumar Mukherjee, examination in chief.
Yes.
Millard will find now question number 9 to 22, 24 to 33, 40, 47 to 80, 82, 83, 85 to 99, 102, 103, 105 to 119. Entirely on Millard the rocky strata, rock, and Millard impossibility. So Millard next Millard will come Millard my Millard my PW3 of Millard Mr. Anil Kumar Singh. Millard Anil Kumar Singh was the accountant and the accounts officer who was Millard the signing authority and was present there as a supervisor of the project. Now Millard kindly marks Millard exhibit assessed 4 Millard files I have given Millard the entire vouchers 4 files exhibit is 16 files 16 sorry
At the time of passing the judgment and serving the judgment, you have to book one room to the court that all the documents can be placed
in originals.
No, so all the documents are placed before the court and all document has to be seen.
I think that has to be done, Millard, and Millard will have to pass. And Millard, if you can, Millard can call us for Millard's assistance also, Millard, because it's not possible humanly. We have 16 files only handed over by.
At the time recording the evidence, I was thinking on that.
No, it was shortened by your.
Who will be given the burden of the judgment? But you got.
No, we got it sputtered because of that only.
Yes.
No, Millard, digressing from the matter, yesterday what Millard assistants have been lent by my lord's court officers and especially my lord's Millard at the end of the that was Millard perhaps how Millard perhaps I have not seen in my last 17 years. Millard, a matter was released at 4:30. I have to barge into Millard the acting chief justice's room. Millard, the secretary was immensely Millard Shamrat, no? So immensely Millard supportive. We showed Millard the orders and basically Millard's order of Millard injuncting from the invocation of the bank guarantee. Millard, it was done. Millard at 4:45, I have to run back to Justice Rai's Millard court again. Millard, he basically signed on a basically handwritten order so that Millard it can be assigned. Millard, I am immensely grateful to a lordship Millard how it was done by a lordship at 5:05. Millard, Union of India was happy that they will invoke because that was not extended.
That happens sometimes.
No, but after 4:30 a matter got released and that was the last day for interim order. Profession teaches us everything. Now, Millard, kindly marks Millard SS to triple V exhibit.
SS to
triple V.
That is the vouchers.
Vouchers, 16 volumes, 16 files.
Yes.
অনিল সিং এর তো পুরোটাই তাই আবার কি বলবো অনিল সিং is entirely on accounts entirety Millard, I am getting the exhibit number. I'll just Millard, he's getting. Millard, this is page 26 of the volume 1 of judge's brief. Millard, I believe that is their disclosure, defendant. I'll just get the exhibit number. Common document. It is a common document. লেখাও আছে হবে একবার দেখো পেজ 26 নম্বর পাতাটা 26 yes.
Yes.
It's a common document. They have also placed reliance. We have also placed reliance. Now, Millard, this is the Millard letter by Millard the railways. Kindly see the date 31st January 2011. Millard, kindly see the Millard penalty.
What is this exhibit? Exhibit number?
Millard, I'm just getting SS. It's it's DD common document DD 13 and PD 34. I'm getting the exhibit number.
Yes.
Millet, kindly see Millet the penultimate paragraph. Since the depth of penetration in rock, similar, they also admit that rock is up to 10 meter, which will be tough job. All necessary arrangement for lowering of well up to 10 meter in hard rock must be ensured before fabrication of well curve. And after successfully lowering one well, further fabrication of other well curve should be initiated to avoid future complication. So, Millet, this is an admitted document by both of us, common document. Now, Millet, they also admit that Millet there is rock. If they admit that there is rock, Millet, to my respectful submission, matter hence here. Now, Millet, the next issue of Millet with regard to counterclaim of the railways. Millet, though Millet, my submission is before your lordship that Millet, the evidence tendered by Mr. Khunteta is of no relevance because of Millet, the judgment and all those things. But Millet, if Millet for a moment I give a Millet, forget that and proceed as it is. Millet, there has been no question laid with regard to counterclaim. Railway had made a counterclaim in the written statement. As my laws knows, if I made a claim of 1 rupee, they will make a counterclaim of 10 rupees. So, Millet, to my humble submission, my lord will not find any question, any document also, and counterclaim has also not been proved by showing that whether this is your counterclaim or not, signed by whom, who has signed it. Usually, that's the same like a plaint.
Yes.
Now, Millet, one question was put to Mr. Ekka. Millet kindly takes Millet, Mr. Ekka won this Millet taken already 28th November 2024. Millet, question number 57.
Is that DW2, na?
DW2. Question number 57. Kindly tell the Honorable Court about the dispute, Millet Mycross, dispute of the suit. He is answering the contract was terminated. Do you know anything about the claim of the plaintiff in the present suit? I have not seen that. Do you know as to whether railway have claimed anything? He said, yes, the railway may have claimed. So, Millet, there is no question in chief. Millet, either to Mr. Khunteta or to Mr. Ekka to substantiate Millet the counterclaim. So, Millet, counterclaim in my respectful and humble submission, Millet, it goes because it has not been proved before your lordship. Now, Millet, now, Millet, my another contention is that even if for the time being, Millet, if I consider that Millet, the evidence of Mr. Arpit Khunteta is valid in law, then even Millet, his evidence 2012
Now the another one legal question. The plaintiff, your claim. Defendant is counter claim. Whatever the decree dismissal, whatever it is. How many decree will be there? As per the procedure.
Millet, sorry, Millet.
How many decree will be there? It's a suit.
If Millet allows the counter, Millet, it should be
Not dismissal. Even dismissal decree is be there. Even allowing a decree is there.
Millet, in law, there should be only one decree. 2.
I felt before Justice Tandon in the second appeal.
Oh. Wait, Justice Tandon.
Total half an hour the class was taken.
Now my lord is taking.
Remanded, then matter remanded for passing a second decree, then appeal.
We are not knowing that.
That's why you're arguing on question of the contract, and that's why I'm asking. So two
decrees.
Otherwise, one decree it will be nullity then.
And my lord, job becomes more difficult.
That's why. Yes.
এটা আমি দিয়েছিলাম তো লাস্টের দিন। Milord, I just hand over a copy to your lordship. Milord, 2012 8 SCC 148. Milord is my judgment. Milord, 12 8 SCC page 148. Milord, I'll give a copy to your lordship.
2012?
8 SCC page 148.
Yes.
Milord, this is on Milord. Evidence Milord given beyond the written statement or case made out should not be considered by the court.
What?
Evidence tendered beyond the written statement or the plaint should not be considered. That is
Out of the pleading.
out of the plaint. So Milord, that is Milord, even if Milord for a moment, my lord consider, I'll give a copy to that Milord. If I am not wrong, paragraph 77 onwards and paragraph 83. 12 8 SCC 148. Milord, in this case, Milord, whatever has been deposed by Mr. Khunteta has not been Milord pleaded in the written statement. Milord, also Milord, in line of that, Milord, very recently, 2000 Milord AIR online 2025 SC 792. This is Milord a recent one, Milord, on the same proposition.
SCC.
Milord, AIR online 2025 SC 792. Equivalent is AIR 2025 SC in bracket civil 2505.
Yes.
This is also Milord in the same line.
Yes.
Milord, this is, I'm sorry, Milord, this is on the proposition. Milord, kindly takes 2515 page. Paragraph 50, kindly see the heading. Parties failure to enter witness box and the consequences. Well, this is on Milord, Mr. Milord, the authors who had not entered the Milord, the witness box. The failure of the defendant to substantiate their claim through documentary evidence is eclipsed by a more consequential omission. In a case where the principal controversy turns on matters lying within her exclusive personal knowledge, the silence of the defendant number one, her absence from the witness box is not a procedural lapse, but a calculated withdrawal from scrutiny. The conspicuous silence of defendant number one strikes not merely as omission, but as deliberate evasion. Defendant number one, who lies at the heart of controversy, chose not to step into the witness box and depose regarding the relationship between the plaintiff's mother and her husband. Her testimony bore direct relevance not only to status of plaintiff's mother, but also her own position. The only justification advanced was that defendant number one, being an octogenarian and suffering from arthritis, was unable to attend the court proceeding. However, this defense is conclusively dismantled by the record itself. The deposition of DW1 clearly indicates the defendant number was physically present in court during examination such and such. So, Milord, kindly takes paragraph 53. This inference is inescapable. This is not a case of medical inability, but of deliberate silence in civil proceedings, particularly where the facts lie exclusively within the personal knowledge of the party. The refusal to enter the witness box carries grave evidentiary consequences. Millard, kindly see Millard paragraph 54. Prior judgment has been referred to of Millard Vidyadhar and Manik Rao, reported in 1999, 3 SCC 573. Millard, kindly see paragraph 55. The present case is a compelling invocation of the above principle. Defendant number 1, though physically present in the court during the trial, abstained from stepping into the witness box to rebut the plaintiff's assertions that strike at the very core of the dispute. In the absence of the cogent medical evidence to support her alleged incapability, her abstainment from the witness box constitutes deliberate circumventing of the evidentiary burden resting upon her. In the Millard, kindly see paragraph 56 in the factual matrix. The adverse presumption against Millard section 114G of the Indian Evidence Act is inevitable. This court cannot overlook that defendant number 1, while central to the controversy, chose not only to abstain from entering the witness box, but also willfully bypass the statutory remedy available to the pleading's physical inability. Under Order 26, Rule 1 of the CPC, permits recording of it through commission. In the age of Millard, kindly see 59. A court of law cannot offer refuge to studied silence where a duty to disclose exists. The plaintiffs anchored their claim in the measured, unwavering testimony of PW2, an account rooted in personal knowledge and long-standing familiarity withstood the rigors of the cross-examination. His evidence, unshaken and consistent, found further corroboration in the genealogical chart presented by the plaintiffs. It is therefore stands established that the plaintiff have discharged the evidentiary burden imposed upon them by law. In contrast, the defendants, bereft of probative material or candor, resorted solely to denials. When measured against the touchstone of predominance of probabilities, the scales of unambiguity tilt in favor of the plaintiff. So, Millard, Mr. Ekka had come into the witness box. Despite that, Millard, the authors are still in service. Millard, Mr. Khunteta has been brought into a man who is not in service, Millard, at that point of time. Millard, I'll just get a book from library. Millard, I'll give a copy to 2012 HCC. Yes. Or Millard, I'll put it in my notes. Millard, given the citation to my learned. Yes. Millard, as to sum up, Millard, one more thing. Sorry. Millard, I'll rely on Millard, a judgment on Millard, section 56. Millard, AIR 1968 SC 522. 68 SC 522. Yes. Millard, kindly takes Millard paragraph 5. Paragraph 5. Section 56 of the Contract Act inter alia provides that a contract to do an act which after the contract is made becomes impossible, or by reason of some event which the promisor could not prevent, unlawful becomes void when the act becomes impossible or unlawful. It is also provides that where one person has promised to do something which he knew or with reasonable diligence might have known, and with the promise he did not know to be impossible or unlawful, such a promisor must make compensation to such promisee for any loss which such promisee sustains through the non-performance. As envisaged, section 56, impossibility of performance would be inferred by the courts from the nature of the contract and the surrounding circumstances in which it was made that the parties must have made their bargain upon that basis that a particular thing or state of things would continue to exist, and because of the altered circumstances, the bargain should no longer be held binding. The courts would also infer that the foundation of the contract had disappeared either by the destruction of the subject matter or by reason of such long interruption or delay that the performance would really in effect be that of a different contract for which the parties had not agreed. Impossibility of performance may also arise where without any default of either of the party, the contractual obligation had become incapable of being performed because the circumstances in which performance was called for was radically different from that undertaken by the contract. But the common law rule of contract is that a man is bound to perform the obligation which he has undertaken and cannot claim to be excused by the mere fact that performance has subsequently become impossible. Courts in England have, however, evolved from time to time various theories to soften the harshness of the aforesaid rule, and for that purpose have tried to formulate the true basis of the doctrine of discharge of contract when its performance is made impossible by intervening causes over which the parties had no control. One of such theories is that the theory implied term, as Infinite Miller, the judgments are quoted.
Yes.
Now, Miller, kindly see Miller, paragraph 6. These theories have been evolved in the main to adopt a realistic approach to the problem of performance of the contract when it is found that owing to causes unforeseen and beyond the control of the parties intervening between the date of the contract and the date of its performance, it would be both unreasonable and unjust to exact its performance in the changed circumstances. Though none of them was fully accepted and the court construed the contract coming before them applying one or the other of them as appearing to be more rational than the other, the consensus arrived at were the same. The necessity of evolving one or the other theory was due to the common law rule that court have no power to absolve a party to the contract from his obligation. On the one hand, they were anxious to preserve the sanctity of contract, while on the other hand, courts could not shut their eyes to the harshness of the situation in cases where performance became impossible by causes which could not have been foreseen and which were beyond the control of the parties. Millard, now Millard, Shottobroto Ghosh and Millard, the judgment was referred to. Now Millard, kindly Millard, paragraph 7. Millard, round the middle. Millard, starting with the word although in English law. Middle of the page, Millard. Although in English law, such cases would be treated as a cases of frustration, in India, they would be dealt with under section 32. In a majority of cases, however, the doctrine of frustration is applied not on the ground that the parties themselves agreed to an implied term, which operated to release them from performance of the contract. The court can grant relief on the ground of subsequent impossibility when it finds that the whole purpose of the basis of the contract was frustrated by the intrusion or occurrence of an unexpected event or change of circumstances which was not contemplated by the parties at the date of the contract. There would in case be no question of finding out an implied term agreed to by the parties embodying a provision for discharge because the parties did not think about the matter at all nor could possibly have any intention regarding it. When such an event or change of circumstance which is so fundamental as to regarded by law as striking at the root of the contract as a whole occurs, it is the court which can pronounce the contract to be frustrated and at an end. This is really a positive rule enacted section 56. So Millard, when I entered the contract, Millard, I have not foreseen Millard the rocky strata.
Yes.
So Millard, it is hit by section 56.
Correct.
So that Millard, the case of my completion of my contract does not come.
Thank you.
Millard, summing up, Millard, rocky strata, rocky bed, not Millard informed to me, subsoil exploration report done by the railways, though within my scope. Millard, the next Millard is the piling method. Millard, that Millard, I am suggesting, they have suggested well method, which has been Millard referred to by my PW2. Millard, that was impossible in a rocky strata. Thirdly, Millard, counterclaim. Millard, impossibility because of Millard the subsoil contract and Millard rocky strata, insurgency. Millard all reported to railways, not Millard added to. Millard fourth, Millard the contract Millard has been frustrated. Fifth, Millard evidence Millard given by the defendant's witness are Millard uncorroborated by any sanctity of law and Millard without any authority. Number 5, Millard, the evidence, even if taken into consideration, those are beyond the periphery of Millard, the pleadings in the written statement hit by 2012 8 SCC 148, paragraph 77, 83. I'll just put in Millard. Namely, 6th, Millard, the evidence of Millard, Mr. Ekka and Khunteta cannot be considered because they are at best a power of attorney holder. They have no personal knowledge. And Millard, more so, Mr. Ekka had said he has Millard showed no document to this court which shows that he was in service at that point of time. Okay. Millard, seventhly, Millard, the persons were in service, they have avoided my lord's witness box. Millard, I am entitled to Millard the release in the plea.
Yes. Millard, so far, the management has placed argument and judgment which has been referred
I'm learned friend. I was unable to look down so that I can reply to good judgment, and neither a copy was given to me so that I can commit before them.
দেবো কপি আপনি দেবেন?
And secondly, my lord, what I gathered from the argument of my learned friend are argued 2 days, previous day and now today. Now on
স্যার ওকে দিয়ে দিন।
on the previous day, my learned friend argued on the point of limitation, that there was arbitration proceedings. So I have to deal that, reply to that. Then my learned friend has argued on the
So
point.
you'll argue today, or you will come in the
I
next?
will argue on 28th.
28th my lord at fixed.
28 already fixed.
Already fixed.
My lord, with regard to limitation or arbitration, I have, my lord, handed over a compilation of this court's orders to show that arbitration, they have said that they have withdraw because it's more than 20% of the claim. And my lord, I have been to the, my lord, before arbitrator, before 24. My lord was satisfied with that, my lord, at court number 30.
The counsel for the plaintiff has concluded that full list of counsel for the defendant is for time.
Now it has extra.
That is already
It is
fixed on
2012. Now,
for today.
হ্যাঁ
Give me the list of those cases.
ওই তো আরেকটা 20 HSC লিখে নিলেন তো, আপনিও তো লিখলেন, দুটো তো আছে
Running through the record.
না, আজকে যা দিয়েছি আজকে দিয়েছি, ওইটা আগের দিন, এটা আজকে।
These two judgment I will.
হ্যাঁ আরেকটা লিখে নিয়েছেন আপনি, হ্যাঁ আরেকটা লিখে নিয়েছেন আপনি, ওই যে 2012-8।
Whatever the judgment I have been delivered by my learned friend, I will deal with.
Yes, yes, please.
এই নিন আরেকটা। Only Millet 2008 years says I don't have a copy. I'll Millet give Millet to him also and to his lordship.
Yes.
Well, I have been very Millet tried to very short Millet.
Thank you.
Kindly makes it not graceful.
Lord, I am appearing on behalf of the plaintiff, Lord, by your lordship's order dated October 31, 2025. Your lordship so very graciously pleased to mark this matter as partial. Lord, I had, my lord, concluded my arguments on the last occasion, and it was for my learned senior friend to reply on this. Lord, I leave it to your lordship, Lord, but this suit, Lord, whenever your lordship fixes it, Lord, but kindly makes it peremptory. That is my, because, Lord, I have finished my arguments, Lord. Only legal aspects which, Lord, are, Lord, part of their arguments with regard to, Lord, limitation, Lord, which I have dealt with, Lord, relying on section 25(3) of the, Lord, the Contract Act, Lord, saying that there is a promise to pay in view of there being a check which was issued. Lord, therefore, my lord, limitation would not come in my way. In any case, my lord, I had, my lord, shown a list of dates wherein I had shown to your lordship that I am within the period of 3 years, because there is my lord, relying on section 18. My lord, only on this aspect, my lord, my learned friend will address. If there is anything for me to respond, my lord, I shall do so. My lord, also, one more thing, my lord, lordship, Lord, only for, my lord, the benefit of myself, my lord, whatever I had argued, my lord, I've prepared a 1-page note on what was argued. My lord, I'll hand up a copy to my learned friend also, my lord, so that they also know, my lord, what I had argued. My lord, only, my lord, on the facts. My lord, and your lordship, in your lordship's brief will also have, my lord, the list of cases, proposition wise, which I had, my lord, placed before your lordship.
Yes. The counsel for the defendant prays for an accommodation. According case is adjourned. Let the matter appear. कौन सा दिन है?
Lord, only one humble prayer, my lord, let it retain its position in the, Lord, that is my only comment.
Fix for the 10th Thursday. अच्छा 26, 27, 28 तो फिक्स है ना?
फिक्स ही नहीं थी।
सेकंड दिसंबर फिक्स है वही? 3 PM, 3:30. 3:30. ट्यूसडे एंड थर्सडे नहीं है ना? फ्राइडे 5th December.
5th December. Lord, 3 PM?
3:30.
3:30. Grateful to you.
Yes, next.
Your Lordship, I had mentioned yesterday in regard to the inclusion of our petition in your daily list. My petition number is 821. Your Lordship has included it in the daily list, but my matter is actually very urgent. Otherwise, your petition,
This court is parted.
sorry, writ petition, original side.
Ah,
Otherwise, your petition will face irreparable loss.
what? What
It's in regard to the,
Ah.
I'm the petitioner,
Which was the respondent?
Shyama Prasad Mukherjee port. They have auctioned our material without any notice. The buyer has already done the payment. Only delivery is due
You are appearing in person.
in person, sir. I'm a common man. I've come
When
to
you-
your
When you
lordship
file the writ application.
day before yesterday.
It will come. Registered. Appearing in the list.
Yes, it's up in.
Number?
I request your lordship with folded hands to include to fix a date or as early as possible.
Let the other side appear. 95. ठीक है काम करो उसको ना सेकंड ट्यूसडे है ना सेकंड को ऊपर कर दो सेकंड come on
Your lordship, I'll
at the top it will come
tomorrow, your lordship, I'll be highly grateful for you.
the matter is fixed. Come on second.
Tomorrow or maximum day after tomorrow.
Huh?
Tomorrow or maximum day after tomorrow. Otherwise, your lordship, I'll have to face irreparable loss. My material will be delivered. They have already done the payment.
कल तो नहीं है ना कल already fixed matters are there. Already fixed matter is there and other party is not there. If I fix today also they will say that the matter.
They have already served.
Have you issued the notice?
Yeah.
Have you issued the notice of mentioning?
Yeah, already done.
Where is the notice of mentioning?
Yesterday also I've done, today also. The copies have also been served.
Okay, come on 25th then. 25th. Yes, next.
Thank you.
Lordship, I appear on behalf of the plaintiff in this matter. Lordship, on the last occasion, my lord had fixed this matter on 13th of November. Lordship, I'm praying that you keep this matter in the month of December.
Why? Parted.
Parted matter.
Yes, why December?
Lordship, Lordship, Mr. Dutt is not here in court today.
They would be continuing with their arguments.
What is the matter?
Lordship, I am not familiar with the facts and circumstances of the matter.
As per the prayer made by the council for the plaintiff, case is adjourned. Let the matter appear on 4th December.
Lordship. Grateful, Lordship.
Next.
My lord, I am appearing on behalf of the defendant. Plaintiff is not here.
You are appearing for?
Defendant.
Ah.
Plaintiff is absent, my lord.
On the last occasion also plaintiff not appeared.
No, not appeared.
What is the application for? It is your application.
This is their application.
GA2.
GA2 for injunction, etc.
Huh?
For injunction and consequence.
You are for the defendant.
I am for the defendant.
What is the suit for?
Suit for is said to be a recovery of money lent and advance.
Money lent and advance.
Yes.
Who is appearing for the plaintiff?
Just see the orders.
क्या parted है क्या? हैं?
Susmita Ghosh was got the counsel, Souvik Ray and Nikki Toja. These were appearing.
None appears on behalf of the plaintiff. No accommodation is sought for. It is found that the matter was listed on 19th September 2025. On the said date also, none appears on behalf of the defendant and none appears on behalf of the plaintiff. But for the interest of justice, the case is adjourned till today. Case for adjourned. It is found that the plaintiff is not interested to proceed the matter. Accordingly, CS number
Yes, 202.
203
203, my lord.
commercial नहीं है 203 of 2021 is dismissed for default. Consequently, झूठ नहीं है. It is, accordingly, GA number 2 of 2022 is dismissed for default.
My lord, I am appearing on behalf of the plaintiff here.
Your Lordship, I'm for the defendant in this matter. Your Lordship, Mr. Bagh has argued his matter here. Mr. Bagh has already argued his matter for the defendants in this matter, Your Lordship. I'm only praying for not this week. Only certain judgments had to be shown to this honorable court, which Mr. Bagh requests that he would like to show, Your Lordship. We finished arguments.
I also rely on certain judgments, my lord.
Lordship.
You are for the plaintiff.
I am for the plaintiff.
Who filed the GA1?
That is my application.
For what?
For injunction,
For injunction?
Injunction attachment receiver and then.
They're asking for the time. What can be done?
Any day next week, Your Lordship.
Learned counsel for the defendant press for time. According case is adjourned. Let the matter appear on 5th December. Yes, next.
Grateful, Your Lordship.
What is the next? Next.
5th December.
5th December. I am obliged.
But I am for the defendant number 1, Your Lordship.
Which matter?
Item number 6.
Yes.
Lordship, GA is my application.
Well, I'm opposing this application. Plaintiff.
Action of plaintiff, Your Lordship, on 2 grounds. So one is, Your Lordship, that claim is time.
No, ठीक है.
Claim is time barred, Your Lordship, and second is, Your Lordship, the nature of the dispute between the parties is fall under the definition of commercial dispute, Your Lordship. Lordship, may I place the case first? Lordship, the
GA3.
GA3, Your Lordship.
Yes.
My lord, the first point, Your Lordship, regarding the, my lord, the claim is time barred, Your Lordship.
Filed by the defendant. GA3 filed by you.
Yes, Your Lordship.
For the defendant.
For the defendant number 1, Your Lordship.
Yes.
My lord, if Lordship kindly, my lord, I have annexed in my application the plaint. Lordship, the suit has been filed after 25 years. Lordship, our work, the defendant number 1 is an agent of the defendant, pro forma defendant, Your Lordship, in the plaint. Lordship, construction work has been awarded to the plaintiff in the year 1994, Your Lordship. And according to the plaintiff, in admitted position of the plaintiff in the plaint, that plaintiff has completed the work sometime February 1996, Your Lordship. Admitted in the plaint, Your Lordship. Now, the suit has been filed in the year 2022. And based on one letter that was issued by the defendant, defendant number 1, Your Lordship, regard a document where is saying that if any amount, if at all you are entitled, and if it is released by the principal employer, then, Your Lordship, plaintiff will payment will be released to the plaintiff. Lordship, may I place the letter first, Your Lordship, because Lordship, the entire case, Your Lordship, revolving around this letter. If according to the plaintiff, this is a promise to pay. If it is a
letter dated 16 July 94.
No, 12th October 2021, page 37 of my application, Your Lordship.
27.
Yes, Your Lordship.
Yes.
My lord,
27.
Page 37, Your Lordship. Of my application, My Lordship.
Yes.
My lord, this letter issued on 12th October 2021. The plaintiff running a case that this letter is a promise to pay under section 25 subsection 3 of the Indian Contract Act. Is saying as promise to pay in terms of the definition of section 25 subsection 3, Your Lordship. So, my lord, from the date of the promise, Your Lordship, a fresh cause of action start.
Yes.
My lord, may I place the relevant portion of this letter, Your Lordship, that is important, Your Lordship, page 38.
Yes.
My lord, paragraph number 5, it starts from, my lord.
Paragraph 4 থেকে
Acha, my lord, with the the instruction of my senior learned friend, I'm reading it from paragraph number 4, Your Lordship. It is further intimated that though HSCL completed the said stadium long back 1996-97, GCDA, my lord, this is the principal employer, Your Lordship, has not released the due stroke final payment to HSCL so far, and as such, contention raised in the above representation that the contract case so pending was already settled and necessary balance payment was already been made by the GCDA to HSCL on this agreement with you in full is erroneous, and demand for payment of work done for the said stadium does not arise at this stage, as in spite of our best efforts, GCDA has blocked the substantial due payment from the work done. Now, my lord, paragraph number 5. So, my lord, here is no payment has been received. It was
Who has written this letter?
it was written by my lord, the GM of the HSCL Lordship, General Manager of the defendant number 1. In response to a letter of the plaintiff.
It is your letter.
My letter, Your Lordship.
Correct.
Yes. Now, paragraph number 5, Your Lordship. Please also recall the terms of the said agreement so executed with you, and release of payment to you is solely depending upon the payment to be released by the GCDA, which is also evident from your own said enclosed letter dated 27th June 1997. But this letter is not in record, my lord. Written earlier to HSCL on receipt of HSCL's letter number so and so dated so and so. Paragraph number 6, Your Lordship. It is further to bring to your notice that only on receipt of the final payment from the GCDA, the due payment to the extent of work so admitted by the GCDA for the said stadium, if any, will be released to you in terms of the above agreement number 16 dated 9th September 1994, executed with you. And my lord, paragraph number 7, in view of the above, the demand payment is premature, and we request you to bear with us till the court fee is court case is decided and GCDA release the final payment to HSCL. So, my lord, under this letter, defendant number 1 is saying that if at all, if any amount is due to you, will be released upon payment of receipt from the principal employer.
That is on 2021.
2021.
So 97, 2021.
There is yes. So, my lord, according to the plaintiff, is saying, my lord, this is a fresh agreement in terms of section 25 subsection 3. May I place for once the relevant provision of the section 25 subsection 3. Section 25 subsection 3 of the Indian Contract Act, Your Lordship.
Yes.
My lord, section 25 is saying the heading agreement without consideration void unless it is written, writing and registered, or is a promise to compensate for something done, or is promised to pay a debt barred by limitation. Well, this heading and my lord, any agreement made without consideration is void unless, now my lord, subsection 3. It is a promise made in writing and signed by the person to be charged therewith, or by his agent, generally or specially authorized in that behalf, to pay wholly or in part a debt of which the creditor might have enforced payment, but for the law of the for the limitation of suits. Now, my lord, in any of these cases, along with this subsection 3, my lord, such agreement is a contract. So, my lord, according to the plaintiff, a fresh timeline starts from the letter of this letter. Now, my lord, if I put a question to myself, Your Lordship, that whether this agreement at all fall under definition of subsection 3 or not, whether it is a
if it is taken also, if it is taken, okay, it is not an agreement. But in the year 2021, you have promised that once you receive the amount from the GCDA, then you will make the payment.
This is
it is a continuous cause of action.
Well, here is the point, Your Lordship, that whether this letter at all is a promise or not. the language of the letter contained in this particular letter, your lordship, when the money will be received, then will be
Once you return, you have already stated in the letter,
my lord,
the
may I,
only
may I?
receipt of the final payment from the GCDA, the payment to the extent of the work admitted by the GCDA for the stadium, if any, will release to you in terms of the above agreement.
Exactly, your lordship. Here is the point, your lordship. The letter, once a letter, my lord, so far my understanding of law, your lordship, that any document, if there is a written promise at all, if whether such particular document will be considered as a promise or not, that has been defined by the Honorable Supreme Court, your lordship. My lord, so far if I put a question to myself, your lordship, that whether this particular document at all as a promise or not, my lord, my answer would be no, for two reasons, your lordship. First, should be a promise to pay, a promise should be an unconditional. Second is, your lordship, promise should be on a ascertained sum. My lord, here this letter, there is a promise that is a conditional. If I release the receive, then I will pay you. Second is, your lordship, that how much amount you are due to you also not been stated, my lord. This is uncertain. So, my lord, if these two categories are not satisfied a document, that document cannot be considered as a promise under section 25 subsection 3. My lord, it is, my lord, this to support my entire submission, your lordship, I place a decision of Honorable Supreme Court, your lordship. My lord, my lord, in this letter, your lordship, in this judgment, your lordship, Honorable Supreme Court, my lord, I will directly place request lordship kindly come without troubling your lordship, kindly come to page paragraph 30. Paragraph 30. Lordship, paragraph 30. Paragraph 30 is the definition quote, extracted here, your lordship. Now, your lordship, kindly come to paragraph 33. What is the observation and what is held by the Honorable Supreme Court? May I read out, your lordship? Paragraph 33, your lordship. Lordship, there is a distinction between acknowledgement under Section 18 of the Limitation Act 1963 and a promise within the meaning of Section 25 of the Contract Act. Both promise and acknowledgement in writing, signed by a party or its agent authorized in that behalf, have the effect of creating a fresh starting of limitation. The difference is that an acknowledgement under Section 18 of the Limitation Act has to be made within the period of limitation and need not be accompanied by any promise to pay. If an acknowledgement shows existence of a juror relationship, it may be extend the limitation even though there may be a denial of pay. My lord, this is relating to Section 18, my lord. This is not our case, your lordship. But the next part, your lordship.
You are not case, but read again.
My lord.
If acknowledgement shows existence of juror relationship,
but
what you says?
My lord,
if you
my
receive the payment, you will pay. So you are admitting there is a relationship.
My lord, may I, to address this issue, lordship, kindly come to Section 18 for once. Section 18 of the Limitation Act. Section 18 of the Limitation Act, your lordship. Section 18 of the Limitation Act, your lordship. My lord, the head note, your lordship, effect of acknowledgement in writing, your lordship. My lord, subsection 1, where before the expiration of the prescribed period for a suit or application in respect of any property or right, an acknowledgement of liability in respect of such property or right has been made in writing, signed by a party against whom such property or right is claimed, or by any person through whom he derives his title or liability, a fresh period of limitation shall be accompanied from the when the acknowledgement was signed. Lordship, this acknowledgement should be signed within the period of 3 years, your lordship. According to the plaintiff, my lord, the work was completed in the year 1996. As per Article 18 of the Limitation Act, your lordship, when there is a fixed time time is not fixed for making payment, then the cause of action accrued, your lordship, when the work has been done. And according to the plaintiff, your lordship, the work was done in the year 1996, your lordship. So, my lord, if this my letter was issued by my client in the year 1996 between 2000 and 1999, your lordship, then maybe a question of relationship comes across, your lordship, because my lord, until unless this letter or acknowledgement is made within that period, your lordship, the prescribed period, then my lord, in that case, your lordship, that cannot be considered as an acknowledgement or extension of time, your lordship. My lord, as your lordship, the principle is there, your lordship, that even after the expiry of the limitation period, my lord, repeated letters cannot extend the limitation, your lordship. I'll place the decision, your lordship. I'm carrying that. Lordship, may I indicate for well, this case is not comes under the definition of section 18 of the Limitation Act. The case is revolving around the section 25(3), my lord, and the opposition, my lord, plaintiff stated so. My lord, now my placing section 25, the rest portion of the judgment, your lordship. That, my lord, may I?
Yes, yes.
On the other hand, section 25 subsection 3 is only attract when there is an express promise to pay a debt that is time barred or any part thereof. Promise to pay can be inferred on scrutinizing the document. Only the promise should be clear and unconditional. So, my lord, a promise, according to the plaintiff, if it is a promise, this promise should be clear and unconditional. If it is a conditional, then this document cannot be fall under the definition of promise to pay. My lord, here after this, your lordship, I'll place decision of this similar question was arose before your lordship in a second appeal, your lordship. My lord, this similar, my lord, and this case, the fact of this case is similar kind of, the content of the letter of this case, your lordship, is a similar of this present this case, your lordship. Lordship, this similar question, whether a conditional document will be considered as a promise or not, your lordship, this case was issued in this, decided in this case, your lordship. Lordship, in this case, your lordship, kindly come to paragraph 9 for once. The substantial question was framed while deciding the second appeal, your lordship. Paragraph number 9, your lordship, may I read out, your lordship? Well, may I, lordship, on paragraph 9, your...
Yes.
The second appeal was admitted by this court on 18th April 2007 on the following two substantial question of laws. Roman 1, whether the finding of the lower appellate court that exhibit A1 and A3 are acknowledgement of debt as under section 25 subsection 3 of the Indian Contract Act is correct under law, as the said provision is only applicable to the debt arise from the business transaction, that too there is a contract between the parties. Well, question was arose before the subsequent question was framed, whether a document, the reference document, whether is comes under the definition of promise to pay or not. Well, it is decided in this case, paragraph 24 and 25. Well, paragraph 24, I am placing that, lordship.
Yes.
24, your lordship. A careful consideration of exhibit A3 shows that what was conveyed was only a conditional promise, whereby the appellant had agreed to pay the amount in case he received the amount from the Tamil Nadu Electricity Board. The relevant portion of the exhibit A3 pertaining to the promise is extracted below. May I read out? I shall be able to repay the amount only after receiving the amount from the TNEB Madras to my wife. I also understand that the amount is likely to be sanctioned in the 1st of April 2000, your lordship. Well, the language is similar to my this letter, your lordship. Now, what is held by the in a second appeal, your lordship, paragraph 25. The averment in exhibit exhibit A3 clearly shows that the promise was on condition of getting the amount from Tamil Nadu Electricity Board, and such being the case, it cannot be said that the document in exhibit A3 is a promise within the meaning of section 25 subsection 3 of the Indian Contract Act. Therefore, substantial question of law with respect to exhibit A3 is answered against the respondent and in favor of the appellant. Well, if a document is conditional, that cannot be considered as a promise under section 25 subsection 3, your lordship. Now, my lord, this is in respect of condition, your lordship. Now, the second ground is, your lordship, in respect of to satisfy section 25 3 is, your lordship. My lord, for that, your lordship, kindly once come section 25 for once the illustration part. That is important, your lordship. Lordship, section 25 illustration E.
Yes.
Lordship, E says A owes B rupees 1,000, but the date is barred by Limitation Act. A signs a written promise to pay B rupees 500 on account of date. This is a contract. So, my lord, if there is an due, due from the different one to the plaintiff, your lordship, my lord, the promise should be a specific amount and asserted sum. Well, this later nowhere reflecting the any asserted sum that I am going to pay you this much amount.
Yes.
Apart from the conditional issue also, lordship. Now, my lord, here I'll place a decision. Lordship, my lord, I place a decision of Patna High Court Division Bench.
Thank you.
Lordship, I'm placing directly paragraph 17, your lordship, without troubling your lordship. Paragraph 17, your lordship. May I read out, your lordship?
Yes, 17, yes.
The learned additional district judge has, however, relying on section 25 subsection 3 of the Indian Contract Act, held that the defendant's right to claim compensation for the period of disposition was not barred on the date of the suit, inasmuch as Magnu is a promise, your lordship, in terms of the local language. One of the mortgager and the plaintiff number one promised under the Iqrarnama to compensate the defendant at the time of redemption. In my opinion, the view of the learned judge is not correct. Section 25, subsection 3, my lord, it was the provision has been extracted here, your lordship. Then, my lord, the next, my lord, the next paragraph, your lordship. The question for consideration is whether there was any promise by the mortgagors to pay wholly or in part a date. The promise under Iqrarnama was that at the time when we redeem the Rehan, we shall pay on adjustment of accounts the damages for the numbers of days and the area of the land from which the rehenders have already been out of possession. Thus, this is the important portion, your lordship. Thus, the recital in the Iqrarnama shows that the mortgagors promise to pay an amount which may be found due on taking accounts, and that is an unasserted sum. But in my view, a promise to pay an unasserted sum is not a promise to pay a date within the meaning of section 25 subsection 3 of the Indian Contract Act. Here, my lord, I'm placing for the relevant letter for once. Lordship, letter page 37 or relevant page 38, your lordship. Please recall the terms of the said agreement so executed with you, and release of payment to you is solely depending upon the payment to be released by the GCDA, which is also evident from your own said enclosed letter dated so and so. So, my lord, first condition is, lordship, this condition that payment will be released to you if it is received from the principal employer. Now, second paragraph number 6, your lordship, it is further to bring to your notice that only on receipt of the final payment from GCDA, the due payment to the extent of work so admitted by the GCDS of the said stadium, if any, will be released to you in terms of the above agreement number dated so and so, your lordship. So, my lord, the condition that when I receive the money, receive the money from the principal employer, like the Tamil Nadu electricity board, your lordship, when the payment will be received, then I will pay the money. So this is complete condition. And your lordship, here not even said if any at all entitled. My lord, so my lord, there is no promise to pay in which amount we are promising to pay for that. If at all, if it is considered as a promise, there should be a specific sum, asserted sum, your lordship. That is also not here, your lordship. So this document does not fall under the category of promise to pay under section 25(3). Now, your lordship, now your lordship, I'll place. My lord, I have make a submission in respect of that exchange of letters, your lordship, because in paragraph number 10 of the plaintiff, lordship, may I place the paragraph number 10 of the plaint? The clever drafting of the plaintiff, it says the defendant have failed and neglected to liquidate the aforesaid area of sum of rupees so and so to the plaintiff despite repeated requests, reminders, and demands. The officials of the plaintiff, apart from writing several letters, made personal visit to the office of the defendant number 1 is situated at so and so. All serious endeavors of the plaintiff went to futile due to the fact that the officials of defendants, particularly defendant number 2, on each of the every occasion assured the payment will immediately be made. Lordship, in this, while deciding, your lordship knows very well, lordship, while deciding section 11 order 7 rule 11 application, lordship, the plaint will follow the plaint averment in the plaint as well as the documents annexed with that, your lordship. Well, here no such document is there that to satisfy section 80 of the limitation act, that there is a continuous letter issued by the defendant number 1 for extension of limitation period, your lordship. And your lordship, here, lordship, the important part is, your lordship, paragraph 19, because your lordship, here it pleaded, here the defendant pleaded, plaintiff pleaded the cause of action. Lordship, if you, lordship, kindly come to paragraph 19 of the plaint, your lordship, the cause of action of this suit arose on 14 June 1996 on the day when the work was completed. And well, here the when work was completed, your lordship, it is hit by section limitation act because it was not, no step was taken by these 25 years. Now, on 12th October 2021, when defendant have accepted the claim of the plaintiffs and undertake to pay, and on 22nd June 2022, that is expire on the notice period, your lordship. Well, this date is not mentioned in the letter, your lordship, but it is pleadings of the plaintiff. But the question is, the next cause of action starts when this letter was issued. But this letter will get a accurate right to the plaintiff if it is false on the definition of a promise. If it is not a promise, your lordship, this cannot be considered as a promise to pay under section. Yes. Now, your lordship, now next point is, your lordship, on the nature of this suit, the dispute between the parties in regarding commercial dispute. But in the plaint, your lordship, paragraph number 12, in the plaintiff himself itself admitted that the nature of the transaction between the parties is a commercial dispute. Lordship, it starts from 6th line of the plaint, your lordship. Since the transaction transacted by and between the parties to the suit were commercial in nature, the plaintiff is entitled and the defendants are liable to pay interest so and so, your lordship, in commercial rate. Paragraph number 12, my lord, internal page 8, page 16, your lordship.
Yes.
My lord, since, my lord, may I read out for once? Since the transaction transacted, my lord, 6th line of the paragraph number 12, transaction commercial in nature. Now, plaintiff under this pleadings, your lordship, averment, your lordship, claiming a interest in nature of a commercial interest, your lordship, but he is admitted that this is a commercial, this is a commercial transaction. And my lord, if I put a definition of the Commercial Courts Act, your lordship, definition part section 2, subsection 1, clause C, Roman 6, your lordship. Yes, sir. Yes, your lordship. Roman 6, your lordship. Roman 6 is, lordship, construction and infrastructure contract, including tenders. My lord, this entire project was awarded to the plaintiff through a tender, your lordship. My lord, here, lordship, if your lordship kindly come to page 26 of my application, that is the letter of intent was issued. Page 26, your lordship.
Yes.
Letter was intent was issued to the plaintiff, your lordship.
Yes.
And then, my lord, kindly thereafter agreement was entered between the parties, your lordship. And my lord, the project is, your lordship, for construction of international stadium mainframe for 2 segments and connected general buildings work. My lord, it is also made in
Where is the name of work?
my lord, my lord, kindly come to page 26, the subject, my lordship, the letter of intent, subject portion. My lord, letter of intent for construction of mainframe for 2 segment of stadium and general building were connected to the segments, your lordship.
Yes.
So, my lord, the nature of the work is a commercial nature and falling the definition of commercial, your lordship. So, my lord, this is barred by law under the Commercial Courts Act also, my lord. My lord, if I summarize in 2 lines, your lordship, my lord, the first, your lordship, this promise, this particular letter is a promise, cannot be considered as a promise to pay under section 25 subsection 3, as, my lord, this letter is conditional document, and, my lord, there is no asserted sum has been mentioned that I'm going to pay that much of amount under illustration E, your lordship, and, my lord, commercial.
That's all.
My lord.
My lord,
Yes.
My lord.
Just a minute. Just.
my lord, I am Milap Toraria.
My lord, I will.
My lord, I am Milap Toraria. I want to the.
Just a minute, sir. Let me.
Well, I will reply the second point first, that it is not a, it should be filed in the commercial division. My lord, kindly see, my lord.
Okay, no, you come on the next day. If you want to continue, I will continue. There will be no problem.
I didn't, my lord.
Then I will leave all the other advocates and
My lord, I have not noticed that.
Counsel for the defendant number 1 has concluded his argument in connection with GA3 of 2024. Due to paucity of time, let us counsel for the plaintiff not argue the matter. According cases adjourned, let the matter appear on 8th December.
My lord, your lordship will. 8.
My lord, I am Milap Toraria. I want to the.
Time fix.
Yes, sir.
Your
Item
lordship,
number 19. Item number 19 should be tomorrow to be mentioned list.
my lord, would your lordship.
My lord, I am praying that
Oh,
item number 19 should be under mentioning list tomorrow.
Item number
19.
Down.
19. Why mentioning list?
I am already given an email to your lordship through registrar judicial and copy to plaintiff as well, defendant number 1 and defendant number 2.
So what is the necessity for placing the matter under to be mentioned?
Because the matter cannot be heard to just now. I am giving details.
Okay.
My lord, your lordships, my lord, kindly, my lord, fix the matter on time, my lord. Since it is a long, my lord, part hard matter.
Now at this stage, I
o'clock.
cannot fix.
I know your lordship's list is heavy, my lord. Your lordship is
That's why
overburdened.
If you get the time, then you argue. I'm fixing it. Then other advocates will
I
not
know
get
your lordship is always accommodating us. my
That's
lord.
why you come on that day. I will take the matter. What is? Yes.
My lord, I'm deeply apologetic. My lord, item
What
number 4, lordship, I was literally, I would have entered. My item number 4, my lord, it has been dismissed, my lord. Kindly restores it, lordship. My lord, I've been here on all dates. My lord, today I was entering, my lord, the matter was called out, my lord. Item 4, my lord, I'll be here any day, lordship keeps it, my lord. Grateful, my lord, grateful.
My lord, my matter will be coming tomorrow.
Next matter, the lordship will recall, my lord, I had finished my sub order 7 rule 11 in a partition suit, Mr. Moina.
That one.
Well, kindly let them finish by way of a submission of a note. But I had made my submission one day and I submitted the note.
My lords, with your permission, mentioning item. Oh, I'm so sorry. Oh, I'm so sorry.
Where is Mr. Bose?
Mr. Ghoshal is here. His junior is here, my lord. Well, let it be appear tomorrow. Let it be item number 1. Let them.
It is running in the list, my lord.
No,
it is running in the next matter.
Yes. Let it be item number 1. We'll let it conclude with a note.
So today 6 has been adjourned. Now 7 will be up. 7 will be up.
Automatically, it will come up.
What I'll tell you, lordship, there are injunction applications.
Tomorrow the WPA will be there. No, tomorrow WPA will be. WPA and the Southwind matter is already.
I see. So
let it be in the list. I will see.
It is there. It is running.
Well, let it retain its position so that on the next
it will be in the position.
Just conclude it and then
Okay.
our task is over.
My lord, my matter will be coming. under
My lords, with your
cancelling letter
permission,
list?
Yes, you see the list today when the matter will fix. Please see the
my
list.
lords, with your permission,
It is not possible that you come on Monday. Monday, your matter will be taken as at the top, like those.
My matter.
Monday, 1st of December.
Thank you, my lord. Thank you, my lord.
my lords, with your permission, item 8, can I mention? The plaintiff is here. I'm for the
Which matter?
item 8,
Hmm.
CS 160. I'm for the defendants, my lord. Seeking for 2 weeks accommodation, my lord.
Parted matter. What is the
My
matter?
lord, my lord, the
Defamation suit in my injunction application.
That one.
the
Yes.
pleadings are
What
complete.
has happened to that court?
My lord, that the Order 6 Rule 17 had been allowed. There was a civil revision application filed, or there's a stay.
There's a stay, my lord. In the 39-1 and 39-4, the pleadings are complete. My lord, if I can just file this, I've already served them.
Okay.
So, my lord, if 2 weeks accommodation can be granted sometime in December.
Let me stand in the way where, my lord, my interim order is
Yes,
expired
madam.
on 27th of this month.
27.
My lord,
My lord,
can be extended.
that of course I cannot object, my
We
lord.
got a note. Then item number 8, and counsel for the defendant pays for fixing the matter after 2 weeks. And counsel for the plaintiff submitted the interim order on 27th of November 2025. In view of the circumstances mentioned above, the case is adjourned. Let the matter appear on 16th of December 2025. Let the interim order is extended till 19th of December 2025 or until further order.
I'm ready.
But deeply.
May I have your lordship's leave to mention item number 9? Lord, item number 9 is that revocation of patent. Your lordship recalls, my lord, which was being heard by your lordship.
Who is
My
for the other side?
lord, my learned friend is here for the controller. My lord, the only thing is that there was
Go before the intellectual property.
my lord, this is assignment. That is why. My lord, substantially it is.
Lordship, I am for the Union of India. I'm leading Ms. Jain.
Yes.
Yes.
My lord, it is. It has been heard substantially by your lordship. If your lordship, I will take maximum, maybe an hour. Maximum.
Maximum.
No, because your lordship knows, my lord, it's a very
They will take.
technical matter. Very technical matter, my lord.
We are not taking the respondent.
The private respondent is the one who is, because it's their patent. Only thing is that if your lordship fixes it any day, not necessarily this month, my lord, even if it is
That medicine.
ferric carboxy maltose, yes, my lord. I made substantial submission.
What has
on that.
happened to the appeal?
Well, appeal, that was interlocutory matter, the suit. No, that is pending. Nothing, no stay, nothing. That is pending. In fact, they've stopped moving after that. No, nothing is that.
Hey, come and last minute we mandate fix it. Well, नहीं है 15 Friday 15 December at 3 p.m. 15th December 3 p.m.
I'm great.
Grateful, dear.
Item number 9. 15. It is submitted that this as per the request made by the counsel for the parties, that the matter appear on 15th December at 3 p.m.
Lordship, I'm requesting that my appearance be recorded, Your Lordship. I'll just put it on the chat box.
Give
Lordship,
the
may,
name.
Lordship, may I be permitted to mention item number 70 and 94. These are two writ petitions on the original side. Your Lordship, the urgency is the electricity is disconnected. This is a commercial building in Rafi Ahmed Kidwai Road. Lordship, the difficulty is I have to run it on generator. I'm seeking reconnection. Two connected writs, Your Lordship. One fresh writ filed by me, the owner, and one by the tenant. Your Lordship, only 10 minutes any day because, Your Lordship, I am without electricity for quite some time now. Lordship, I am incurring costs every day.
Mangal ko.
10 minutes any day.
25 ko. Huh?
10 minutes any day, convenient, Your Lordship. If it could be this week.
25 को टॉप में करना 25 को नो विटनेस कब से है 2 बजे से 2 बजे अच्छा इनका तो है
Is it possible for Your Lordship to take it up this week?
28 फिर 28 तो दूसरा मैटर है ओरिजिनल साइड मैटर है
Will it be Your Lordship's permissible to keep it this week? Your Lordship, 10 minutes I'm out of electricity. I have to run.
Tomorrow is the last working day.
Your Lordship, 10 minutes. I'm out of electricity.
Friday.
10 minutes.
I am taking chance. Is it fixing tomorrow?
Very well.
If the other matter is urgent, then you will be
South Point.
Very well, Lordship. I'll take my chance.
I don't know whether they will be ready or not.
Grateful, Lordship. 7